Chat, we are on day 13. Well, day 12 of day 13. We got to finish up the last half hour of the APRocky trial from yesterday. And we will then finish up with today. If you guys remember, APRocky is in closing arguments. And oh my God, they apparently only have like an hour of day in court in California. I don't know how they get things done there. I don't know how they get things done. We literally will watch for, a 6-hour recording is only literally like 20 minutes of talking. I just don't understand how they do stuff in California. This is where I really want like Emily Baker. I'd love to have her on and be like, what? Like, how do you guys accomplish anything there? Because it doesn't seem like you can get anything done. It doesn't seem like you can get anything done. So, anyways, chat, welcome. We are going to leave. We're going to pick up where they left off yesterday. And where we left off is right at the beginning of some fireworks that happened. There's roughly going to be a little bit of time here, chat, about 35 minutes or so. And then we'll move into today where the Tacopina finished up and the state began the rebuttal. Remember, they're making a rebuttal argument. So here we go. Bama law, yes, there is. We had to stop right before something happened. People told me this is getting pretty good here. She said she can't watch it because she likes Lewin. Well, this guy's fucking awful. Holy shit, the guy lost it. This guy has lost his shit. But yeah, that for Emily Baker, I know it's a problem because she worked in this office. She knows these people. But this guy's crazy. And I'm sure Emily knows that. She may like him, but he's still crazy. So anyways, here we go, chat.
Strict instructions to both counsel, and there are also
okay, chat. So here we go.
You gave strict instructions to both counsel, and there are also repeated court of appeal in California Supreme Court decisions about disparaging other lawyers. Let me be clear what was stated. Mr. Prislenek never said anything about the lawyers who talked about the defense. The defense has said as follows. We're trying to win at all costs. We only care about winning, not just.
Did I sustain that objection?
No, you did not until the fourth time I asked it, Your Honor. I objected 4 times.
Fucking crybabies. Oh no, it's harder for us. Suffer. Fucking crybaby bitches. Crybaby bitches. Remember, only one side's entitled to a fair trial, chat. Only one side's entitled to a fair trial. It ain't these two. These two guys don't get a fair trial. Constitution don't care about them none. But listen to them cry. Listen to them cry. Listen to them cry. Listen to them cry.
We suborned perjury, stated 3 times. I objected each time. We could have called the worst of them all. We could have called Haji. The court knows we found out about him that morning. The court made a finding that their discovery violation was not inadvertent. That means it was intentional. That means it was not accidental. They got up here and just told this jury that they didn't hear from this witness Haji, that we could have called him. The court knows we have a hearing about it. It's been very clear. The court found that they were not honest in what they provided. They were not honest about when they actually turned the information over. And now he's up here and able to argue that. And when I object, basically I'm told it's overruled. I'm the judge. The problem is the court made these findings. The court said you could not disparage lawyers. Let's be clear. Anything that he had said was true. That we suborned perjury. That we don't care about justice. Those are reportable issues to the state bar. The court knows it's not true. I know you know it's not true, Your Honor. I assume he knows it's not true. And then finally, he has repeatedly misstated the standard of reasonable doubt. There is no standard whatsoever where you can say that each one of these are, quote, reasonable doubts. That is not a correct standard. The standard is looking at all the evidence in total did the people prove the case beyond a reasonable doubt? It is improper to say, if this fact is wrong, that is, quote, a reasonable doubt. You can argue that that evidence is important enough, etc. So they're misstating the reasonable doubt. But more than that, Your Honor, they're disobeying the court's order about disparaging other lawyers. I object, the court lets it go. Then
No, wait a minute, I don't let it go. If I see or I think that Mr. Tacopina is disparaging you or you are disparaging him, I will put a stop to it.
Judge, I objected 4 times. You overruled all my objections. You finally sustained an objection. And when the court sustained the objection, I made clear that my issue was the second part, which had to do with they were in essence disparaging both of us. Your Honor, I mean, it's not a hard question. They're saying we suborned perjury 3 times. Your Honor, that's improper. It's misconduct.
I didn't hear that.
Your Honor, it's in the record. 3 different times he said we suborned perjury. I don't know what to tell you.
Hold on, Kathy, is that said?
I don't remember.
Your Honor, we said,
All right. If it was said, then I should have stopped it, but I don't remember if it was said. You have made so far 9 objections, 6 were overruled, 3 were sustained.
the problem
So
was,
therefore, what?
the problem was, I believe the first 5 I made were all overruled. The court,
They kept on saying that Tacopina and them coached a witness. That's the funny part. They kept saying these guys were liars. They kept calling 12E and Lou fucking liars. Like the idea they were doing this shit. It's really fucking annoying they would try this. That he's got the balls to do this right now and talk out of the other side of his mouth is just, yeah.
I've been in front of this court for 30 years. The court knows who I am. The court knows what my ethics are. I'm not going to sit here and tell the court that I'm objecting when he didn't say it. He said repeatedly, we suborned perjury. Your Honor, that statement in and of itself is severe.
All right. Can you, in the break, can you say, if that was said, then I'll bring it to the attention of the jury that that's an improper statement.
This is what I'm asking. Mr. Tacopina can go after our witness all he wants. He can even misstate the evidence. What he cannot do is he cannot argue, A, why we put a witness up there. He cannot say that we...
Yes, he can. He can argue why you put a witness up there. He can argue. He can do that. Buddy, that's how this works. He's allowed to attack your case and your motivations. He is 100% allowed to do that. Brother. You know, maybe we need to have like the honey, you need to listen here. Honey, this ain't how this works. Jesus Christ.
Suborned perjury. He cannot say that all we care about is winning. He cannot...
Yes, he can. He can say that. You can't stop him. You can't stop him from saying that. Crybabies. Listen to the crybabies.
Not say that this is supposed to be the pursuit of justice and the prosecution doesn't care about that. He has said all of those things.
He could say that. He
needs to stick to the evidence in the case. Either he doesn't know California law or doesn't care. And Your Honor, the court's already found. And you're gonna cry, and now you're the one talking shit.
Okay.
the worst of them, and I want the court to instruct, he got up there and argued, why didn't you hear from Haji? The court knows, Your Honor, the court made a finding.
You're repeating yourself.
Well, will the court do something about it? Will the court instruct that that was improper argument? Can I respond?
No. Failure to call logical witnesses is permissible. You're going to have a rebuttal argument. You can address it in your rebuttal argument.
Yes, and that's the point the judge is correct. If you don't, the failure to call a witness that, yeah, if you guys didn't know that, I can do that. Why didn't they call this person? Why didn't they call that person? Why didn't you hear? Like, Tacopina could have brought up, why did we hear the fact of, and remember I brought up the whole idea of, we haven't heard about anybody owning these registered guns. They've never introduced that anybody owned a gun. I'm allowed to bring up things that they didn't introduce. But listen to him fucking cry, and the judge is like, no, you're wrong.
As to why you didn't call.
Your Honor, this is all I'm asking, Your Honor, and this last I'll say it. The court knows what happened. We've had many hearings on this, etc. They knew the evidence. They presented it late. They had repeated orders to turn over statements. He got up and said, that's not the statement of the witness. 1054-3 is very clear. What they gave us is supposed to be the statement of the witness. And when he's standing up saying, well, that's not his statement, that was his statement, that's what they had to turn over. So yeah, Your Honor, I can go back and I can go.
It's a summary of a statement, you fucking worm piece of shit.
And argue in court and say, well, it's just both sides are arguing. But Your Honor, there are rules for a reason, and we follow them. You have not found one instance in this case, not one, where the people did not comply with discovery, where the people did anything unethical. You've already found, you used the words, it was not inadvertent. Not inadvertent, Your Honor, means they lied and they intentionally did not give us what
I don't agree with that. That's not, it doesn't mean he lied.
Your Honor, not inadvertent.
Don't argue with me. I don't think it means he lied. I just said it was not inadvertent. That's the extent of my finding. It was not inadvertent. I'm not going to debate with you whether they were or were not lying. I don't believe it was a lie. I want to give the court reporter a break, and we'll take a break until 3.
Judge, I have to just respond to a few things, because there's a record here. One thing, I don't want.
And Takapina did a good job. You could see him fucking straining not to answer anything. But you let it go, and you're like, Your Honor, can I address? And he has the right to defend himself and his client.
I don't want to upset. So we can do it.
You're not going to upset me.
No, I'll be quick. I don't want to get over it, I'm sorry. But there were some things that were said that were just wrong. First of all, they called our witnesses liars in their summation. So I'm calling witnesses a liar, which he admitted to me, by the way. So, I mean, if our witnesses are lying, and I put them up there, obviously, they're saying we came up with this Tottenham story. So they're saying, I object, and they say I'm supporting her. That's what they're saying, number one. Number two, I can't say that they want to win at all costs. That's fine. I can't say that. I don't think that's an improper argument. If you say it is, I won't say it again. But the other thing, Your Honor, I didn't argue that that wasn't a statement. I said it's not a sworn statement of 12, and it's not a recorded statement. I said it's a summary. I'm accurate in describing it. It is a summary. I'm just going through what I said. They disparaged our entire defense, mocked it. So I'm giving them a little bit back. I don't think I'm doing something.
You want to interrupt him? He didn't interrupt you?
Fucking crybaby. This is the Chad right here. Look at this Chad. Look at this Chad. Look at it fucking Helter Skelter over here. Can't control his shit. He is cooked. Lewin should not be in this. He should be stepping off the case. This guy's lost his composure. He has fucking lost. Lewin has lost his composure. He's lost his composure. And here's Takapina. Freaking Iron Hand.
He said, though, first of all, I disagree. I think one fact of relevance would be a reasonable doubt. The jury finds he's incredible on one thing of importance, like the shell.
That's true. The jury only has to rely on one bit of evidence to find reasonable doubt. That's 100% true. Same thing to find doubt to find proof beyond a reasonable doubt. They only need one piece of evidence to do that. They only need to rely on one piece.
That's a reasonable doubt. If they so choose, it's up to them to decide what a reasonable doubt is. That could cause them to find not guilty. That's up to them. But it certainly is an argument that can be made. They can say, no, it's not a reasonable doubt. But I can make that argument. I know. But the last thing, I think Mr. Lewin's hearing failed for a second. Because the one thing, because I know he said he has an issue with it, the one thing I never said was they could have called Haji. I wouldn't do that. I didn't say that. They could check the record. What I said was they spoke to him that morning. They had a recording of Haji. That was brought out to Lululemon. I said, if Lululemon was inconsistent with Haji, we would have heard the tape. I didn't say they could have called Haji. I can show you where I said that. I would never have said that. We could have called Haji. He wasn't willing to come. So I never said that. I just simply said what was on the record.
Right. If it was said, Mr. Lewin can address it tomorrow. If it wasn't said, then there's nothing to address. All right, we're off the record. I want to give Kathy a break. So can you find
God, Llewellyn's a fucking bitch. He is bitch made. That was pathetic. That was pathetic. Pathetic. Absolutely pathetic. So let's move on. So I'm glad we listened to that chat, but that was absolutely disgusting. Listening to that grown man, the agent of the state, cry. That agent of the state just sit there and cry and piss and shit himself. Have some fucking dignity, Lewin. All right, real quick. Iman Rez is saying Silvio in the back making copies during this is hilarious. That's how court staff works generally. They're busy taking care of other shit. That guy's already on to the next 5 or 6 cases, the next trial. He's got other shit he's got to do. Attorneys are filing motions, taking care of everything. All that's being handled. That's why that guy's doing his job like that. Tech Guy South said the dude is roid rage. Why? How much roid do you think that guy's doing? He's probably like, he's having estrogen rage, soy rage. So, yeah. All right, hold on to that. Why is this not? Come on, I thought we switched. There we go. So we're still outside the jury's presence. He's checking the notes here to see who said what. So here we go.
Indirect reference, it's not even clear, to Relli and embracing perjury. So far, Kathy has not found the word suborn. Embracing perjury, I don't even know what that means. But from here on out, if any counsel wants to state that a witness is perjury, that's fair game. But I do not want either directly or indirectly any counsel accusing the other one of suborning perjury, encouraging perjury, touching on perjury. I don't want the word counsel and perjury being used together.
Already blind eye?
What?
Already blind eye?
Stay away from the they're winning it all.
But they do. These guys are winning at all cost. They are winning at all cost. Sorry, that's what the state does.
Well, it's their kind of evidence. Because they can say about the evidence, they cannot say prosecution is all they care about is winning their case. All they care about justice. That there's authority that says that.
Yeah, no, that's
The judge say, wait, you don't believe it's true.
no, I don't. And I know it's not.
That's
All right, so stay away from what the prosecution's motives are. Talk about the witnesses. Don't talk about the prosecution's motive. And when Mr. Lewin speaks, you're not to talk about the motives of Mr. Tacantino or Mr. Singh.
Joe, I won't feel free to comment on, hey, they didn't call this witness, et cetera, just not that yourself.
All right.
Well, my space is much shorter now.
What's that?
My space is much shorter now, so.
I doubt.
See, now that's a guy handling with class. Well, I guess I'll just have a shorter. I'll have a shorter closing.
Okay, we're gonna
So,
All right.
so that is. Here we go, chat. We're gonna skip ahead here.
I think someone may have a problem.
who's got a problem with
It's not for me. It's not for me.
So they're talking about who can make it there on time, but we're not gonna worry about that, chat. I don't care when these people can get there and not get there. So, we're just gonna skip ahead to the actual talking.
order?
You all, the,
So back in the record of parties council.
All right, here we go. Back into the fight. Back into the fight.
okay, folks, so I think we left off on discussing with you all the whole notion of the person who used to be Relli is not Relli anymore, apparently, who came back at 11:09 to the scene to retrieve shell casings. Now, again, the story changed. Ultimately, he said it wasn't him, so it's a mystery man showed up on the scene at 11:09, apparently. So, but one of two things happened here. Either that really was Relli, like you first said on the video, coming back at 11:09, staying for 2 minutes, returned to the scene, or, and he lied, of course, then about being there with his girlfriend, if that was him, and about taking photos of the shell casings while there, because those photos weren't taken until 11:40, 11:45. Or the prosecution has absolutely no evidence whatsoever that he ever returned to the scene, ever. Whichever one you choose, the prosecution has no evidence at all that Relli actually recovered those shell casings from the scene. You could call his girlfriend, Miss Parker, to back up his claim. Yes. She's probably busy doing what she does, but she didn't show up. Their burden, corroborated with witnesses. The word of Relli, I think, is a fair question. There are a lot of things in this case that are going to be easy to corroborate of his word, if they're true. I'm going to show you a little list of those sort of pull that together, but not yet. But there is no corroboration, and they couldn't. Lydia Parker could come in here and say, yes, I went back with him. We found 2 shell cases. She's still his girlfriend, apparently. No evidence whatsoever that he took the shell casing while at the scene. While on that point, by the way, the photos taken with Relli's iPhone of the alleged shell casing, allegedly taken at the scene, but not until 11:45, an hour and a half afterwards, they had time date stamps on them. But what you didn't see from the prosecution was GPS location data for those digital photos on Relli's phone line. I mean, they didn't show you, what else they didn't show you was GPS location data from Relli's iPhone to show you where Relli was on November 6, 2021. That would solve a lot of mysteries here. It's not like they couldn't have done it. GPS location data from Relli's iPhone, which they had. That would have answered all the questions. Could have corroborated or not. Everyone heard that law enforcement, in this case, went out of their way to get a search warrant to obtain GPS location data for ASAP Ill's iPhone, just to show that he was near Selma Avenue in Vista Del Mar about 10:12 p.m. on November 6th. It showed that in his location data. And he was near Rocky's residence at 11:11 p.m. that night. That's from Detective Flores' testimony, unless there be any confusion. The question was asked, and specifically, it's important because it showed they could have gotten GPS location data from their only witness who's not corroborated, and whose word may be a little shaky. And specifically, the T-Mobile information law enforcement obtained authorized to search Elijah Ulunger's, ASAP Ill's, his call detail records, and his GPS location. Detective Flores is correct. And the GPS location data, I should say, answer yes, okay. And those records, the GPS location data that you all were able to obtain, showed that Elijah Ulanger, ASAP Ill's cell phone was near Selma Avenue and Vista Del Mar at approximately 10:12 p.m. on November 6th. And I believe that's correct. Question. Those records also show that Ill's, I'm just going to refer to this Mr. Ill's for the purpose of moving this thing along a little bit. ASAP Ill's cell phone was near Mr. Mayers' residence at 11:11 p.m. later that night. Answer yes. Subsequently after yes. Well, what that shows you is that not only had they the ability to do that, they in fact did it. But why just for Relli? Why not for Relli? Who claims he came back and found shell casings? That would put an end to this mystery. Was he there? Was his girlfriend? Was he not there? You heard again. There was no dispute, by the way, about it, that he was at Selma, at least Delmar and Selma, that night during this. And you see him on video. And rather than looking to see where Hills was at 11 p.m., why didn't they use Relli's GPS data to show you where he was at 11 p.m.? Was that him? Was that not him? You ever go back at 11:45? This would have answered all your questions, either corroborated the story or not. Would have put the lock to it again. It would have also shown you where those iPhone photos of the shell casings were taken. Instead, you have to take his word for it. You just have to take his word for it. Yes, they could have done it. They did it with Hills for some reason, but not for Relli. So just take his word for it. If the word of any witness ever deserved to be tested, in this case, it's Terell Ephron. I mean, it's a man whose tongue is a stranger to the truth. And they could have easily corroborated his story or shown that his story was not true. They just didn't do it. I want to pause here so this really sinks in. Detective Flores told you that he wouldn't want anyone other than the police taking evidence from the scene because that could tamper and hinder an investigation. This is obviously fairly important. As a detective, I asked him, you'd agree when conducting an investigation of the alleged shooting, you wouldn't want anyone who's not law enforcement removing evidence or taking evidence from the scene, right? Answer correct. Because that could tamper and hinder your investigation. Answer, it can. And that makes sense. Because once evidence is contaminated, once an alleged crime scene is contaminated, there's no way to undo that. No way. You never get a second chance at it. If you want reliable information from a scene, it cannot be tampered with, it cannot be staged. If it's staged, it's useless. It's pointless to review it because whatever you see, you have to reject it. You have to. And that's exactly what Relli says he did here. And that's why it was even more important for the detectives to test his word by looking to corroborate it, but they never did that. To be clear, the prosecution just wants you to take Relli's word that he found shell casings at the scene. That's it, just take his word. After all, they presented to you nothing to corroborate it when they easily could have. And just ask yourselves, if Lydia Parker, Ms. Terell's girlfriend, could readily corroborate his claim, don't you take the word from her? The fact is, Relli didn't want her anywhere near the courtroom. Anywhere near the courtroom. Remember when I showed him a picture of Ms. Parker, his girlfriend? And I said, is that your girlfriend? He said, I don't know. Is this Ms. Parker? TV does it then, I was on but I was disturbed by that photo, but anyway, back to more important things. What he just said was, I don't know if that's my girlfriend. I mean, just, anything he tells the truth about, I don't know if that's my girlfriend. That's not, I don't know, that's either yes or no. He couldn't recognize his girlfriend when he said, oh, she had makeup on. I mean, we're not talking about time even. You're right. I mean, she literally said, my girlfriend. Why lie about that? Aside from his name, I don't even know if that's his real name. Did he not lie about anything in this case? I mean, you know,
that's pretty good.
Testimony. He didn't want the only person who could or couldn't corroborate his story to be anywhere near this courtroom. That's the need of the day. The judge told you, we, the defense does not have the burden to do anything in this case. They do. They had the burden. We don't have to prove anything. We didn't have to introduce a single piece of evidence. We didn't have to produce a witness. That's because the laws of the United States and the Constitution demand that. But as a matter of fact, we had more substantive witnesses in this case testified than the prosecution did. We wanted you to complete picture all the evidence because we want you to know the truth. And there's nothing to hide. Rocky did not find, not by a long shot. Why? Again, and need the answer as to why they didn't show you the GPS records of Relli. What it could have shown where he actually went after the incident. From the incident, where did he go for that hour and a half? And where did he take those pictures from? That would have been important, especially if there's any question that that video may not have been shown to Relli returning. If that wasn't him returning to the scene at 11:09, 11:11. So where was he really at that time? Unfortunately, we don't have anything because they didn't get his GPS location information. We're just supposed to accept his word that he didn't go somewhere else to get checked. So we just have to accept it. And the judge gave you instructions on this about the credibility of the witnesses, and it's in your evening take back review there. But it says that the witness lies to you on an important fact of the case or this testimony. You can feel free to disregard the entire testimony of that witness, or you can just disregard that one fact and leave the rest. But he lied to you about so many crucial things. I'm not talking about his inconsistencies. Again, we'd be here until the summer. He lied to you about the most crucial facts in this case. You know, by the way, this is not someone who's uncomfortable around guns. You heard he owns a 9mm, posted those pictures on the Instagram. It's 9mm sticking out of his waist, he said. You heard he owns 9mm semi-automatic. We've never seen proof or he actually obtained it. Second, he blatantly lied about his access to 9mm shell casings in Los Angeles. That's another kind of perjury. And that was a big one. And we have to talk about this. We have to spend a little time on this one because what happened there was very crucial. He lied about having access to 9mm shell casings 2 weeks before the incident on November 6th. He lied to them. He lied about being in Los Angeles. He lied about having access to shell casings. He lied about shooting. I'm going to show it to you. This next episode is not even one lie or one perjury. It was like a perjury miniseries. This next one. It was unbelievable. One lie piled onto the next one, onto the next one. You got caught with that, then he went for another. It was a glorious training. And you're going to see it. I mean, I asked him first if he fired a 9mm weapon before November 6, 2021. Sort of an important fact. Because you need to have access to 9mm shell casings. First he said, no, absolutely not. Then I wanted to make sure, I wanted to almost help him if he was truthful answer. I said, well, how about at a shooting range a few weeks before November 6th? You fired 9mm at a shooting range. All right, hit him on November 6, 2021. He said, definitely not. I repeat, I said, definitely not? And he got belligerent. He says, you heard me, definitely not. I didn't even own a firearm, he said. I only got my firearm license a year and a half later. Listen.
So let's move closer to the time of the incident on November 6th, 2021. A few weeks before November 6th, 2021. And a few weeks before, that's why we got showcases at the scene. Final showcasing. You fired 9mm weapons at a shooting range, correct? Definitely not. Definitely not. You heard me, definitely not. I didn't have my own. I got my own license. I didn't have to.
So you heard me. I think because he did not like me, clearly. Because I asked him to confirm that answer. You heard me. Well, you asked me. You heard me. Definitely not. I didn't even own a firearm. I only got my firearm license a year and a half later. Lies, 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 lies. And that's when we all saw the video of Mr. Ephron firing a 9mm semi-automatic weapon on October 19, 2021, 2 weeks before the incident on November 6th. And I pointed out to Mr. Ephron, I said, what you just told this jury was that before November 6, 2021, you didn't fire any guns because you didn't have your license. And he said, no, unless I was at a shooting range. And I said to him, sir, I just asked you, were you at a shooting range? And you said, definitely not. And I asked you again. And you said, you heard me, definitely not. He just made stuff up as he went along. Look at this.
Mr. Ephron, you just told the jury. I don't know what I'm doing. 216. Definitely not taking money out of here. Showing up. What you just told this jury was that before November 6, 2021, you didn't fire any guns. Because you didn't have license. It was just last I was on a shooting range.
I mean, you just saw his testimony, which was about 1.5 minutes earlier, where I said, was that a shooting range release? Maybe he did that? Definitely not. Twice that. And then explain why it was definitely not, because he didn't even have his firearm license. When he got busted with the video that he didn't think anyone had, because it was not put out on his direct, of course, I said, unless I was at a shooting range. He just thinks he can make that up in front of you. Like, he just told you definitely not at a shooting range, and then just in front of you. Like, I don't know, guys. I mean, there has to be a point in time where you have to be so offended by him just looking at you guys and lying. He's took an oath. An oath. You know an oath means absolutely nothing to him. Absolutely nothing. He didn't say that. That was blatant perjury, right there. He witnessed another count of blatant perjury. But what happened in this courtroom after that, I think made it worse. After You're gonna see it, what happened. Because this was now rolled out, okay, so now we got him firing a gun, don't put it there, please. We have him firing a gun before November 6, 2021. We have him firing a 9mm. He lied about it, repeated. And then, so after securing the date of the 9mm firing of October 19, 2021, I tried to ascertain the location of the shooting range. And the prosecution then asked for a stipulation. You're gonna hear that the shooting range was taken outside of California. And the witness also adopted that. Let's look at this.
And where is it? And where is it? We have a stipulation on that date. And that date is outside.
There was the stipulation, but at the time, I believe all parties in good faith believed that the shooting range was outside of California. No one is at fault. It's what the parties believed at that time.
Well, I didn't believe anything, so I didn't know. I'm not saying it was a fault, I'm just showing how it's played out with the witness. You pull out the witness.
Right.
How we
The
adopt.
prosecution asked for a stipulation based on what has happened so far up until this point. They believed in good faith that it was outside California. The fact that it wasn't came as a surprise, I believe everybody.
Well, it's a witness, which is not arguing.
Everybody accounted for it.
Yeah, not what everyone counted, I just wanted, let's play out. How we adopt.
Same objections, improper argument, little bits.
I explained to the jury. Go ahead.
Yeah, next line. Last line was not Los Angeles, or not. So anyway, the witness then said, the hearing, whatever we heard, in the court with the banter, he then said, well, maybe it was probably New Jersey, something like that, but it's not LA. I was in the sure, he knew that. So, understand what just happened there. The witness, all of a sudden, after lying about all those things we just went through, now, to repeat them again, then heard argument and said, oh, but it's not LA, it's maybe New Jersey. Because being in LA, that would have been a problem. But something happened over the weekend, little problem for Mr. Relli. See, on Sunday, between 2 p.m., he was on Friday, that was on Friday. On Sunday, between 2 p.m. and 11 p.m., someone on Twitter posted a screenshot that you saw, heard about, of a video showing Relli at the shooting range that was played before you, alongside a picture of the Los Angeles Gun Club. Locations right there. It was the same. Relli was tagged on that. It was tagged. So what did Relli do? Sometime between 2 o'clock and 2:50 that same day, immediately, he calls the prosecution and said, oh, I checked my Instagram account and I realized I was in Los Angeles on November 19, 2021. And I realized I was at a shooting range. And what's the reason the prosecution elicited from Relli as to why he made that discovery? Well, he was going back to check his Instagram account on whether the shooting range was in Los Angeles because he wanted to correct any mistakes he made. So it's true. I can say it straight, but that's literally what he said to me. He really was concerned about making any mistakes, so he wanted to make sure he checked his Instagram account to see if he made any mistakes. First of all, I asked him, see, Instagram account doesn't have anything about gun range. And he started saying, that's not my Instagram account. Well, aren't you Relli, boss? Yeah, but okay. Okay, close. I guess he didn't go bother checking all his other so-called mistakes that he made. Just that one that happened at a post busting him at 2 o'clock. Within minutes, he calls the prosecutor. He was tagged on the post. Within minutes, he called the prosecutor. What a coincidence. You know, what about all the other mistakes? What executives did you meet at Capitol Records and Universal Records that you no longer meet because of what happened here? You couldn't mention the name of anyone you met with. But he said they were on his phone. You can check his phone. Oh, there you go. He was checking his phone to correct the record here. That didn't happen. How about the Miami property, Mr. Relli, that you invested in? I mean, last year, sir. You invested in Miami property. You posted on your Instagram. I asked him, which property in Miami did you invest in? I don't remember which property. Why? I mean, no one invests in property because you remember which property. Unless you're a gazillionaire, and that doesn't matter. And he's not. And then I asked him, well, how much did you invest in property? I don't remember. He didn't go back and check that. So remember that, just remember that one, how that all played out here. When considering his credibility. Relli told you that there's so many things in the Miami robbery thing that was just nonsense. But this was horrific. He got caught live. It's made in New Jersey, definitely not LA. I went back and checked, it's definitely LA. That's clear perjury. So you know he checked his Instagram account by correct mistake about whether the shooting range was in LA. That wasn't truthful testimony. You've seen him testify in this courtroom. His witness who told you when he said definitely not, he was committing perjury because that was his then answer. He cleared that up. I'm sure this in a second. When he said definitely not to me, I questioned him. I said, "You said definitely not," because then he got busted with the Twitter thing, and he said, "Well, yeah, I just made that up because I didn't want to answer any of my questions, any of your questions anymore." He literally said to you each lie under oath on a very important fact, like whether he had access to none of the show cases, because he was tired of answering my questions. I'm just gonna lie to you.
Well, this one, on this lot, it's where I just a few minutes ago. Okay. Okay, yes, I did. Okay, say yes, yes. Did you look like you were confused by that question at all when you said definitely not? And to be honest, I just wanted to start talking to you.
So you look like you were confused by that question because he said he was confused by that also now. When you said definitely not, I didn't shoot a 9mm at a shooting range before November 6th. Definitely not. You look like you're confused. That's just, to be honest, here we go. There's a watershed moment. To be honest with you, I just want to stop with you. So I just said, Jesus. Just give me my 30 million and let's get this over with. He just told him to perjure himself. But you should believe him without corroboration. And we all know it wasn't mere coincidence that minutes after that post that he was tagged on, he told the DA. He called because he knew what was coming the next day on Monday morning. He knew what was coming. And that's what the prosecution wanting to correct that mistake. I'll hold that. Let me move on. But again, that is not a minor factor in this case. That's not a minor factor. And it's not a game. This is like whether their so-called victim, Terell Ephron, had access to 9mm shell casings just a few weeks before things were found 2 9mm shell casings in Los Angeles. Yes, he did in the same city. He had access in the same city. It's a funny thing about facts. Because facts weren't getting in his way. But the funny thing about facts is this, as John Adams once said in one of my favorite quotes. John Adams said, facts are stubborn things, and whatever may be our wishes, our inclinations, or the dictates of our passions, they cannot alter the state of facts and evidence. And you cannot alter the state of facts and evidence, no matter what Relli tells you, no matter how you want to interpret this testimony, no matter what they say. So with this evidence, ask yourselves, ladies and gentlemen, did Relli first lie to you about going to a shooting range where he had access to 9mm shell casings, and then lie to you again about having access to those 9mm shell casings here in Los Angeles? I mean, why did he do that? Why would he lie about those two things? There'd be no reason for him to lie about that unless it was to cover up something about those 9mm shell casings he claims he recovered. No reason to lie about that. You know exactly what happened, why he lied about it. As the police found when they got there, there was no shell casings there because he had a pop gun. He had a pop gun, as unimpeached witnesses told you. And he claims that he got these shell casings from the scene an hour and whatever later, a half later. And then he held them for 2 days, gave them to the police 2 days later, when his extortion defense failed. One thing's clear, the prosecution has not proven beyond a reasonable doubt that Relli did not get those shell casings from somewhere other than the scene. They did not prove that beyond a reasonable doubt. That's enough. That's enough. Beyond the fact that Relli had access to shell casings in Los Angeles now that we know, which he lied about, the prosecution presented no evidence, zero evidence whatsoever, trying to corroborate Relli's claim that he actually found those shell casings at the scene. None. Not Lydia Parker, not GPS location data, stuff that would have done it pretty quickly, pretty easy. Not a video. Relli first said that it was fake. When I showed him that video, it was fake. He didn't think anyone knew we had those videos of him at a firing range. By the way, not like master investigators. They were just on his phone. We just looked at every single thing on his phone. They had to. They gave it to us. We didn't hear about that on his direct testimony. It would have been something to bring out to deal with. That wasn't what happened. If we didn't cross-examine, we never would have known. He was in Los Angeles 2 weeks before. 9 of those shell casings popping back into his head as he's firing. And he lied about it, perjured himself. There's only one reason to lie about that. Heard about the magazine. I won't get that magazine. So Block 43, Mr. Chris Long spent a lot of time on today. And there was no effort made to test. Now, you heard the judge, he instructed that 2 weeks, I think 3 weeks ago now, he instructed there'll be no testing on that. 3 weeks ago, right after the trial started. 3 weeks ago, no testing. Here, going forward. Great. That's January 2025. What about 2021? 2022. Well, not 2021, because it was probably 2022. 2022, 2023, 2024. 3 years they had to take that magazine that they recovered and test it to the bullets recovered. They didn't do that. Instead, they spent their efforts having a ballistics expert come in, show you a very nice PowerPoint presentation, which in the end proved only that the shell casings possibly, there's that word again, possibly came from an aftermarket slide for a firearm frame that could possibly have been compatible with a Glock 43, or not possibly. I mean, literally, that was the import of that testimony. Possibly could have come from an aftermarket slide for a firearm frame that could have possibly, this is his testimony, possibly been compatible with a Glock 43 magazine, or possibly not. That was the ballistics expert's testimony. Possibly or possibly not is definitely not proof beyond reasonable doubt. In any event, Lou Levin told you that the Glock 43 magazine was his. He explained why it was his. Whether they want to mock him, mock his answer, he was in Rocky's house after they went to a shooting range. He told you he had bought it, he owned the Glock 42. And magazines are stored all next to each other, 42s, 43s, and all that stuff. Lou told you. I don't know anything about this stuff, personally. But he went to the store to buy accessories. He mistakenly read a Glock 43 magazine because they're all different models of Glock. The magazines are all stored together, so he told you he didn't realize it until he tried to load it at Rocky's house in preparation to go to a shooting range. And then when this .380 caliber Glock 42 ammunition didn't fit, he tried 9mm ammunition from his Smith & Wesson, which he did. It's from his testimony. And of course, that magazine didn't fit any of his firearms. He left at Rocky's house. Why? Why not return it? He told you. It was over an hour away where he purchased it. It would have cost more in gas than the $20 it cost for that magazine. But one thing you know, despite all the questions from the prosecution, Mr. Lewin, they did absolutely nothing to refute or contradict his testimony. Absolutely nothing. Because it's true. I mean, at one point, he told you that magazine was never used. He told you it was never used. You take this back, you have all the evidence with you. But the reason he told you it was never used, he just had a picture, then he looked at it. There's not a scratch on this thing. It's a piece of plastic. It's a cheap piece of plastic. That's why it costs $20. He told you it was never used because if you put this into a steel gun block, this is going to scratch.
There's no evidence to support that.
This is pure. It's virgin, as Levin said. There's no scratches on this thing. It's brand new. And they had 3 years to test it. 3 years to test this. They didn't do it. Not only did they not connect really shell casings to the magazine in Rocky's house, they didn't connect those shell casings to Rocky himself. And that's important. You heard that law enforcement submitted those shell casings for fingerprint analysis and found absolutely none on there. And I asked the before, so you could line fingerprints on a piece of metal, right? Pretty easily said yes. So they submitted Rocky's fingerprints for fingerprint analysis against the shell casings, and they found none. So they tried to make excuses for that. That's another fact that's not good. So they tried to make excuses, like, have those bullets. The shell is the one recovered. Claimed to be recovered at the scene by 11:45. With no GPS navigation. Anyway, they claim, David Flores said, yes, you do get fingerprints. My fingerprints are all over this right now. Okay? He said, yes, you'll get fingerprints on a shell case, molds, empties, kosher. But then they said, well, could there be a reason why you would get fingerprints? And he said, yeah, there could be. So that's one that was, yes, rain, water, cars, and even wind. Imagine that. Maybe wind wiped the fingerprints off the shell case. Imagine. So now my fingerprints are on this thing. Oh, there goes my fingerprints. Are you kidding me? Wind? Wind. Not the fingerprint off the shell case. That's an excuse. It's not fact. There was one other explanation by David Flores that makes a lot more sense. He said, well, human contamination, like someone wiping fingerprints off the shell casings, that could do it. And you know that after those shell casings were, yes. Alex, now where am I? All right, hold on. Human contamination, that's right. Human contamination. The detective said that human contamination, like someone wiping fingerprints off the shell casing, that could do it. And you know that after those shell casings were fired, the only person with an incentive to wipe it clean would have been Relli before he gave it to the police. Just like he wiped his phone clean of threatening messages to Rakim. We'll get to that. They didn't bring that out. We have to. So Relli wants you to believe his fingerprints weren't on them because he supposedly went to Dunkin' Donuts to get a bag to pick them up with. And you know that's not true. There's no Dunkin' Donuts open at 11 p.m. at night, especially during COVID.
Objection suspended. Objection suspended.
Well,
Yes.
you can decide if that testimony's correct.
There's no testimony. Mr.
No, there's that.
Objection sustained about when Dunkin' Donuts are open until.
That's
The
not.
jury's job is to decide the credibility of the witnesses, including all testimony that is given by that witness.
So here's what the witness said, and it's your job to decide. Bang. He said, I went to Dunkin' Donuts at 11 o'clock at night, got a paper bag from Dunkin' Donuts at 11 o'clock at night in Hollywood. And that's the bag I used to put the bullets in that had no fingerprints on it. You determine the credibility of that statement. He can't even told you that. You also heard that law enforcement took Rocky's DNA, they actually took his DNA, despite Detective Flores saying that DNA was necessary as part of that investigation. He had to swear that to the judge. They never compared it to the shell casings, or even the magazine recovered in Rocky's house. That might help. They didn't do that. For that matter, you know that Relli's 9mm shell casings were different than the 9mm shell cartridges found in that magazine. You've seen that picture a few times. Completely different brands. The ones in the Relli said he found were Federal cartridge. Blue Lemon's cartridges were made by 6 Sauer. Completely different. Again, on that point, your magazine was never used, was fully loaded, meaning 2 cartridges were not missing from it, but they were different bullets anyway, so it doesn't matter. There doesn't be any question that that Glock magazine in Rocky's house was not the magazine seen in the video on November 6, 2021. All you have to do is look at your eyes. All you have to do is look at your eyes. So at the end of this part, I think it's stop it. Let me just go through this last name. The Glock magazine seen in the video is different. The Glock magazine recovered, which we just showed you actually, is a Glock 43 and it's black. Black, that's the magazine. The magazine that you're going to see in Rocky's prop gun on November 6th was not black. It was extended, as Lou Levin told you, to look more intimidating, because it was a little thing, Glock. And if you look at it, you're going to see what it was. But don't forget, Trubby and Lou both said, and the prosecution sort of mocked somehow in their summation, they said, oh, conveniently, they both identified the belt and the extended magazine. So they both could identify, you know, the thing. They conveniently came up with these 2 different things to be able to say it was the same prop gun. Not conveniently. Look at the picture. That's what it was. Luke put it together and Kobe saw it. That's the magazine. And, okay, I know what we're doing here now. Okay. That's the use that point again in our arm.
Yeah, he's not screen.
What times do you want on the screen?
Yeah.
So, I'm screen. What you doing? Good. They want to see here. No, okay. Anyway, that's the magazine recovered. Here's the prop gun. I'm going to try and do this where. How about now? We're good? All right. That little thing at the end is the belt clip. That's a clip. And that's what Lou Levin described. Here's what you see. This thing, this clear, silvery looking thing, is the extended magazine that Lou Levin described, that Trelby described. It's part of this prop gun, and it's the extended magazine. So it makes this thing look bigger, and they both described it as clear. This is the first time, because if you play this in real time, you'll never see that thing. We stopped it. And so here is the magazine, the extended magazine, to make this thing look bigger, and it's clear. It's not that. It's clear. Okay.
Oh, great. Yeah, folks, we'll resume at 9 tomorrow. Do some specifications for yourself or anybody else. We'll see you tomorrow at 9. 9 a.m.
All right, chat. So we're to the end of that day. We're going to move on to the next day now. We're going to move on to day 13 today. There's a lot more tampon waggling apparently from Attorney Lewin. There's a lot more tampon waggling. Don't you worry. We're going to get to more tampon waggling. Yeah, that was finishing up what happened yesterday. We didn't get to finish up. So we're going to move on from here. I love KLF. Yes, I love this comment. Was Long Crime going to copyright strike them? That would have been hilarious. All right, but guys, now we're moving on to today, and we're going to catch up because a lot of downtime occurs. So here we go.
The jury. If there is a request for readback, all of you will know.
Okay, so they're getting dressed. It sounds like the day's over. Oh my God, we're going to be here forever, chat. But let's get through it together. All right. We got some music. Boom, 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 boom. All right, chat. So that is there.
What about,
We skipped 40 minutes, chat. That's how good we are. Here we go.
I
talk about it? No. Thanks. All right, we're back on the record. All jurors, counselor, jurors, counsel, parties are present. Mr. Takapina, for
Thank you very much. Good morning, ladies and gentlemen.
Pina.
Here we go. So pick up where I left off, which was talking about the picture of the extended magazine that we showed you, which described as clear or transparent, whatever it was not black, that extended thing that Lou and both photos had described. So in the end, the prosecution on this issue, all issues really want you to believe Relli beyond a reasonable doubt, but you don't believe here for his testimony. I would submit to you that perhaps the most unbelievable witness in the history of American jurisprudence. You guys have a front row seat to a perjury machine. Again, they could have corroborated a lot of his testimony if it were truthful. Lydia Parker. I mean, they sat in their hands for years. They could have tested to see if Relli's shell casings came from that magazine, Women's magazine. They didn't connect Rocky Relli's shell casings with Fingerprint DNA. And as a quick aside, if you accept their theory, I think I heard this on the opening summation, is that maybe Rocky forgot about the magazine. Why wouldn't he, if truly he had a gun and he was trying to get rid of the evidence of shooting from November 6th, why wouldn't he have got rid of the magazine also? Why keep it for 5 months in plain sight? I mean, that's where it was, right? It's not like it was hidden somewhere in the house that had 5. It was in a box in his bedroom with all the other ammunition for the legally registered guns. Plain view. They didn't show you, by the way, the shell casings that Relli claims he recovered at the scene don't match the 6 shell casings found in Rocky's house that belonged to Ms. Levin. We had showed that. We showed that. They produced, as we talked about, no GPS data to prove where Relli really got his shell casings from. There's no this would have been easy to do. Relli claims first he said he wasn't in Los Angeles weeks before. Certainly not a shooting range week. Won't go through that again. But he claims he left Los Angeles after he had a shooting range with those 9mm shell casings, and then he came back to Los Angeles 2 weeks later. They failed to prove that. I mean, you just have his word, right? That would have been easy enough to prove. I mean, how about an airplane ticket or anything else? They ever left Los Angeles and flew back ever? After having 9mm shell casings flying to his base at a shooting range just weeks before. The photos of the shell casings. I mean, that would have been an easy one to prove. Just bring his travel itinerary or an airplane ticket from Delta or wherever. He said he flew commercial. How about on his phone? Anything that would show he actually left Los Angeles. Nothing on the record. No evidence that he actually left Los Angeles after being at that shooting range on October 19th. So where did he get his shell casings from? At 11:45 p.m. that night, an hour and a half after the incident. Law enforcement didn't give us the means to answer that question. They never got Relli's GPS data. They could have given a definitive answer to you. They didn't, and that's not on him. That is not on him because they didn't give you the evidence you could have been comfortable to rely on, as opposed to just taking Relli's word, which is not a word that you take anything of importance in anyone's life. Whether we had him at some apartment in Los Angeles or at some friend's car or some place, who knows? We'll never know. We could have known, but we don't, and we never will. Because the prosecution gave you no one in this courtroom the ability to track where Relli went in the hour and a half after the incident. Only Ill's GPS data did get. It shows they could get it, they just didn't get his. They just want us to take his word on that, word of pathological lie. Look at all the things they failed to corroborate that they could have. To corroborate Ephron's account, they could have done any of the following. And we're giving you a sense of comfort, a sense that, hey, you know what? He did tell the truth about this anyway. They could have called Ephron's girlfriend, Libby Parker, who was allegedly with Ephron when he claims he retrieved the shell casings. They could have collected GPS data from that night from Ephron's phone to prove he returned to the scene. Again, they did use it for Ill's phone, but chose not for Ephron. To look at the metadata on the photographs that Ephron took of these shell casings, which would have shown exactly where he was when he took those photos. These are things they could have done to corroborate. Go ahead. They could have produced a plane ticket or receipt to show that Ephron actually left Los Angeles after he went to a shooting range 2 weeks before the incident. They didn't do that. They could have called Asap Bari to corroborate the conversation that he allegedly had, or that allegedly happened on November 5th, the day before the incident, with Bari and Rocky, in which Relli claims Rocky badmouthed him. No phone records of that, nothing. Then, of course, they could have tested Ephron's casings to see if they came from the magazine found at Rocky's house prior to the trial. Of course, they could have tested Rocky's DNA against those casings or the magazine, and they did neither. Those are just some of the things. I mean, those are deficiencies in the evidence. And they create reasonable doubts. They're reasonable doubts. And especially when you consider what Relli did with the photos of those shell casings. He go running to the police saying, hey, help, there's a victim of a crime. He tried to extort money out of Rocky, like when Rocky and his manager first. And I want to remind you that there are 2 hurdles the prosecution has to overcome to get conviction in this case. First, proving that Rocky did not carry the property. And then, of course, they can't do that beyond a reasonable doubt, right? Close. And then, of course, the judge instructions told you should stop right there if you find that and find him not guilty. But also, the judge instructed you that regardless of whether you possess a top prop gun or not, you must find him not guilty if the prosecution had not disproved that he acted in self-defense or defense of another beyond reasonable doubt. And in this case, there is clear evidence of self-defense on another. And by the way, I heard Mr. Relli say in his summation that's a new defense. It's not a new defense. We talked about in our summation, our opening statement a month ago. The judge gave me the instruction on it, not because he was doing me a favor. The judge gave me the instruction on it because there's a view of the evidence that supports it. Right there, property, you shouldn't even get to self-defense. But it's there. It's another layer that they have to overcome beyond a reasonable doubt. And Relli was the aggressor. There's no question. In their opening statement, they said Rocky was the aggressor. Rocky was the one who saw confrontation and they did everything possible at the trial to make believe that. Right from the beginning, they played their video of 16 spell mortgage capture the incident. But they eventually left something out of that. When they claimed that Relli used ills as a human shield, what they did not want you to see was after it was all done and Rocky's out of the picture and Relli's already running out, they cut Relli running back towards Ills and attacking Ills again. So the human shield thing is no longer there. I pulled out a picture, and Relli goes back and takes one more parting shot at Hills to the left before he goes off to the right. They cut that out of it. Of course, they don't want you to see that. That's very damning to their case. They actually cut it out of the video and show it. What else did they want you to see here? The first shot actually occurred on the 1616 Visa Del Mar video, which is why Detective Flores' testimony established that they mistimed the first shot. Remember, Detective Flores talked about this. As opposed to our video, which you know is the accurate timing based on two things, your eyes and 12. It's not a game. There's way too much at stake. His life is at stake. It's not a game. Detective Flores gave us uncomfortable testimony in that regard. It was a rough estimate, he said. They tried. That's not good enough. They gave a living example how their time was off by a full second. I showed you the video where one thing said 8 seconds. Yeah, the video was 9 seconds. And of course, yeah, it was. But I didn't make it. I didn't make the video. Let's go through the evidence that shows that Relli not watching the aggressor. Look, you can look at 3 things to show that. Communications, intent, and actions. So I want to just quickly get through that and then move on. But communications, intent, and actions. Let's start with communications. The prosecution wants you to believe that the events on November 6, 2021 started the day before when Relli claimed he was in the car with ASAP Rocky and supposedly heard Rocky say, at that end, Relli, I'll beat him up. First of all, I don't think Rocky is going to say he's going to beat Relli up in any lifetime. He's not, I think Relli called made fun of him, fun of his manhood, called him some derogatory names. He's not a gangster, he's not. Certainly, he's not thinking he's beating Relli up. And what's the proof of that? What's the proof of that conversation that started it all, that showed Rocky's the aggressor? No text messages, no phone records, no recorded statements, no other witnesses. And of course, the one guy who heard it, ASAP Rocky, who Relli says is still the aggressor. They have brought him in here to say, yeah, that's what Rocky said. So we just have to take Relli's word in here. Just his word. For so many reasons, you can't just take his word on anything. You saw him lie over and over to you. Over and over. You can't joke. It's offensive in a joke. It's not funny. Including about this very issue about being the aggressor. And they embraced his position on that. They embraced it. Remember what I showed you in the opening statement, text messages from Rocky to Relli on the way to the Playboy Cardi concert on November 6th, 2021 at 9:34. WYA is where you're at, where you at. Let's get through the stuff of my balls. It shows this. That's the, I think it's at 13. I have that right? It showed that. They wanted you to believe that these were sinister messages and that Rocky therefore was the aggressor. Personally, heard from 12-year-old Jamel Phillips, who said that there was nothing aggressive about these messages. He heard the calls. They were late for this Playboy Cardi concert, where that is, and they were trying to connect with Relli. But what else did you want? When the prosecution showed you those texts, they wanted you to believe that those were the first messages of November 6, 2021. What you learned was that Relli deleted the messages before that. The early messages that showed Relli's true character, his true animosity, his true aggression towards Rocky, his true intentions of meeting Rocky that night. He deleted messages before giving his phone to the police. On November 6, 2021, at 10:30 a.m., Relli texts Rocky first, saying this. Said it, Pete. You got all this fake animosity towards me, LOL, beat me up, and I wish you would. Give me a reason, and you can, whatever. You should have said that. Read that word. Relli made clear he wanted a reason to fight Rocky. He made it clear that. His testimony made it clear. He said, from his trial testimony, what do you say under that vote? Give me a reason, he answers. And then I say, a reason to do what? Fight you, or whatever, at this point. So when he says, give me a reason, he's explaining what that meant to fight Rocky. Those were the first messages of Edie. You didn't see that. They presented the other messages from Rocky as the only messages that day. And that one was their fault, because their witness lied to them, lied to the police, and deleted messages. Destroyed evidence in this case, which is fine to do. And when I asked Relli if he deleted those messages before turning his phone over to law enforcement, he lied to me at first. This is a big shock to me. At first he said, I don't recall. Then I showed him the messages. What did he say next? His go-to line. You see those messages? It's fake. It's fake. Anything that crushed him was fake. It's fake. You heard that a lot from him at this trial when confronted with his own words, whether text or recorded conversations, it's fake. But he openly admitted he sent those texts to Rocky that day. But obviously he didn't like the way it would have looked to the police, chose him to be the aggressor. So it didn't fit his narrative, so what did he do? Delete them. What other communications were there? We were on communication still, leading up to the November 6th altercation. You saw text messages from Relli to his friend Ty Y on October 16, 2021. And Relli was in LA, as we know. And he said, if Rocky don't, this is specific, if Rocky don't do shit with his boy funeral, I'm gonna beat that end up. So he's now threatening to beat Rocky up because he didn't think you heard what that was all about this ASAP member, ASAP Josh, who passed away. Rocky stepped up and paid for the body to be flown back to New York at the funeral expenses for the family. For some reason, Relli Zone just thought, well, Rocky didn't take care of that. No, so he went back. He did, he learned. So Relli sent that message on October 16th, threatening to beat Rocky up. Of course, when I first showed him that message, they objected. Not sure why that's his message, but they didn't want you to see that. Threatening to beat Rocky up. And why? Why did that not be relevant for you to see? It's offensive. That is offensive. That we had to bring that to you. Relli's willingness to lie to you over and over again without regard to his oath to tell the truth is offensive. When I asked Relli if he sent that message to, he sent the message about beating up Rocky, he lied again. Falling back on his usual answer, I don't recall. I don't recall what I said. So I showed him, and his response, what was his response here? What am I looking at? His text messages. He said, oh, it's hard to read that for you guys, it's hard to read for me. But what he says is, what am I looking at? That text? I don't recall that. I don't remember that. I wouldn't even write that, he said. And that's on the bottom of that red box. I wouldn't even write that. And when I explained to him that the text was given to us from his phone, from the district attorney's office, he changed his answer to, this means nothing. Even if it was okay, yes. I mean, just like that. Just like that. I don't write that. I don't write like that, too. Sir, this was given to us from your cell phone from the district attorney's office. Are you saying that's not yours? This means nothing, even if it was. Okay, yes. So in a matter of 5 seconds, he went from, that's not me, I don't write like that, to, oh, they gave it to you from my phone. Okay, yes, it is. That's perjury, ladies and gentlemen, that's perjury. Again, that's a crime, by the way, perjury. So I then asked Relli, if in that message that he sent, if the N-word in his text message, I'm gonna beat that N up, refers to Rocky. And you know what his answer was? I don't recall. Seriously. The message said, if Rocky don't do shit to this boy funeral, I'm gonna beat that N up. So why did he say I don't recall? Because he knew that that message showed his animosity towards Rocky, it showed his aggression, and it showed his intent. That's why we had to bring that message up to you. We had to show you that. That didn't come on direct. His intent, number 2. Relli's message made clear that he was the aggressor. They give you a little window into his intent, but so does his testimony. When I asked him if he was upset in his belief that Rocky didn't follow through his promise to take such a funeral, Relli suddenly didn't know what the word upset meant. That's literally what he said. I don't know what the word upset means. So I showed him his prior sworn testimony at the preliminary hearing, which was also under oath. That's good for him. Question: you were upset, right? Answer: yes. So what do you do? Again, he just changed his sworn testimony in this courtroom in front of you. I said, what a big deal. Yeah, I would be upset, he said. So the word he didn't even know what it meant a minute ago, he's like, yeah, of course I was upset. His oath to tell the truth means nothing to that man. Absolutely nothing. Remember, he told you I could say whatever I want. And he showed me that time again. When I asked him if he was, quote unquote, pissed on November 6, 2021, and he was going to meet Rocky, he once again said, I don't recall. I don't recall I was pissed. I once wanted to confront him with his prior statement to get the truth out of him, this time with a recorded statement to a district attorney, Mr. Siegel. Yeah, see, okay. Engel, Brett Engel from the District Attorney's Office back in 2022. And he said, oh yeah, I was pissed. Again, why did he first say I don't recall that he was pissed when he had said it in so many places over the years? But he didn't want to be pissed. He knows that makes him out to be pissed on November 6, 2021. And we were talking specifically about November 6, 2021, when he was pissed. You know he was angry on November 6, 2021. You know, he was now pissed and upset with Rocky. We know Relli was jealous of him. He made that very clear. You heard him tell that person while it's Jimmy. We'll get to that in a minute. He said, I made that. He used the N-word. I made that. You heard Relli criticize Rocky, saying it's been open-ended promises forever with him. Troll told you wasn't true, but he was very generous the minute he got his first record deal. He moved everyone, 20 guys from ASAP into his apartment in New York. You heard Relli complain that he couldn't be involved with Rocky in the music industry and that he wasn't even trying to be in August of 2021. But despite that, you saw messages in the group chat with Rocky, Relli, and Relli's business partners, Justin Benea, on August 6, 2021. You saw during that exchange, Relli trying to get Rocky to help him professionally, and Justin Benea asking him to jump on a call, which Rocky was happy to do, but apparently not fast enough. For Relli, let's see him respond fast enough. Relli sent a message to that group chat on August 5th, 2021, saying, exactly, here it is, exactly my point, LOL. July 24th, FU and ASAP, fake ass N, effing goofy. Make no mistake about this. Relli was jealous of Rocky and his success. He wanted the world to think he was successful. I mean, that's why he went with these Instagram posts of his, with his lavish lifestyle and his lots of cash and private planes and all the stuff he posted. However, the truth was anything but what he tried to make the world believe. He showed bank accounts. I mean, he was meant to be a multi-millionaire with $700,000 back. That was important, and that has to do with his jealousy and his greed. And there's no question he was jealous and angry about his success. And being as aggressive as he is, Relli, he didn't do much to hide his true feelings, except for wonder, oh, at least he tried first. He tried. Remember what he said about whether he would say F you to Rocky? He was actually asked by the prosecution on that one. Would you ever say F you to Rocky? And, you know, if you did, would you mean it? And he said, well, that's what he said. If I said F you, it was sort of wishy-washy with love. So he said, well, that wasn't true. Because I showed him this text to Rocky on September 18, 2021, which was him saying, no matter how much N try, you're not changing. And everything about you, you fake ass N, I hate you, suck it. I'm not even going to read this disgusting thing, but this is what he said. This is what he said. No, he doesn't say F you to Rocky. Only wishy-washy with love. There's nothing he doesn't lie about. There's absolutely nothing he doesn't lie about. That's his level of anger. What was Relli's response when he see that message? Look at his response. Yeah. Yeah. I said, yeah, it's from you. Okay, that's cool. That message was cool. That's what he said. That's cool. Bless you. That's cool. In which world was that message cool for anybody? That despicable message cool for anybody? It shows you who Relli is, who he was on November 6, 2021, an angry, jealous man for occasion. Third, his actions. His actions on November 6, 2021 make it clear. His actions in this court make it clear. When I was questioning him, he became hostile, volatile, and aggressive. He at one point flexed his muscles. He cursed in the courtroom. Fell first to me. He yelled. He thought I was disrespecting him by asking questions. He looked like he was ready to jump off that stand, man. And that was in front of you in the courtroom. And just imagine what he's like in the street. It doesn't take too much imagination when his actions were caught on video. I wouldn't show you that video, but he claimed he went back to the scene, by the way, to take photographs of cameras there after the incident. He said, I went back to take photographs of cameras. Well, you know if that were true, you would have seen those photographs. They didn't show you those photographs because they don't exist. They don't exist. Apart from his word, there's absolutely no evidence that Relli ever photographed a single camera at the scene. And that's because the last thing he wanted was for the police to see what was actually happening with these altercations. Listen, folks, I have to say this to you. I just hope I haven't taxed your patience by my persistence and my zeal. Yeah, I've never learned how to talk about human liberty or human faith concisely or complacently. I just don't have that ability. I just don't have that talent. And I know I'm covering a lot of material here, but I don't know like what we need here, what we don't need here. I don't know, you know, if I'm going through something that I guess you know that already. I know you can't say anything, but I just can't sit down with all that's on the line here and thinking I didn't cover something. So please bear with me. I know this is a long process, but it's my last chance to speak to you. And again, there's just so much riding on this that I just can't be brief. I can't cut corners here. So please accept my apology that I'm going on and on, but it's important. And I just don't know what's important for you guys. So please. So the one on Argyle Avenue, each of those two instances, the one on Argyle Avenue, the other one on the corner of East Del Mar, Relli was expressing both his anger, jealousy, and hate. And following through on his direct just a few weeks before, now I'm going to beat that up. Relli's testimony about his expectations on the way to meet Rocky was clear, and he was looking for a plan. And to use Relli's words, he thought if there was going to be an altercation, quote, there would be a bit of rum. In fact, although he again first tried to hide behind another one of his I don't recalls, he then admitted under oath that when men are angry, they fight. That's what he believes. When men are angry, they fight. And despite his initial effort to make it believe otherwise, on November 6, 2021, we now know he was angry. He saw that anger on display. During the opening statement, the prosecution said that you see on video Mr. Mayers immediately is aggressive toward Mr. Ephron. They told you that Rocky is pushing Ephron backwards as he pushes him off camera out of view. Well, let's see if that plays out. I'm going to show you this video. You can see for yourself. The first one reaching out is Ephron. He's the first one to make physical contact with Rocky with his left hand. And you also heard that from Troy. He was there. Boom. And Rocky's right hand's not even up yet. He then puts it up. And as Troy told you, consistent with that video, it was Relli who grabbed him first. In fact, Relli realized his actions in this video were a problem for him. So although he first testified that he was a lefty while watching himself in this video, he grabbed Rocky with his left hand, he suddenly switched to being a righty. I don't remember that. Someone said, I'm a lefty. I'm a righty. You could always ask for a read. He switched from being a lefty to a righty. He said, I can see I was stopping a little. Like I said, I'm a lefty. I'm a righty. But your left hand or right hand is not one of those things you forget. It's not one of those things you mix up. Why lie about that? Why try to minimize? Because the video showed him doing that, what you just saw, being the first aggressor, the one to make contact first. And despite the prosecution's promise about that video, it does not show Rocky as the one who is the aggressor or immediately grabs Relli. It doesn't. And what else does it show you? It does not show you the prosecution promised it to show you, which is Rocky pushing Relli off the screen. It shows the opposite. And I'm going to show you what I mean. You've all seen and heard about how much bigger control Relli is than Rocky. Not a fact in this video. Consistent with that, 12 we told you that Relli was pulling Rocky off the screen. But you know who else told you that? Relli told you that. He told you I was pulling you. That's his testimony. For his standard operating procedure, when I first asked Relli if he was pulling Rocky back, he said he didn't recall, he didn't know. Then, after being impeached with his prior testimony once more, he heard his answer. He was walking in, I tried pulling him back. That's Relli, that's the preliminary hearing. He tried pulling him back, and that's what he's doing on the video. He's pulling Rocky back. During their opening statement with respect to the first incident, the prosecution also noted that Rocky produced a similar amount of pistols and pointed at Relli. And said, I'm going to kill you. Let's break that down. You see the evidence really shows. First of all, the object was not the center of the pistol, it was a prop gun. That's pretty clear from the evidence. Now, the witness testimony, the fact that there's no evidence of shooting. But beyond that, Rocky certainly did not point at Relli. The video shows that, and 12 told you that. In fact, based on Relli's own testimony, the object was put away when two people walked by on the street. And as a result of that, whatever Relli claims Rocky did with it, while they were off camera to the right, meaning inside that parking garage, that's a problem for them because they were off camera in the parking garage for only seconds.
Good points here, chat.
Not long enough for Relli to have happened to him what he described after. What's the evidence show about this?
Tacopina, I feel like is kind of, they're good points, but I feel like he's beating it into the ground now. I know he's going to go on for a while, but holy shit, he should be out of here. He should bail now. This is way too long, chat. This is way too long, in my opinion. This goes on for a while. Look how long he goes. I think there's a lot of stuff he should have cut out.
That he, again, lied to you, changed the story about what happened, in that insert of the parking garage. It's not on camera. He testified here. He said, Relli said that Rocky just pointed the object at his head and his stomach, nothing more. He denied here that there was any physical contact with his body and the object. He denied that. But when he spoke to the district attorney about this in that prior recorded statement in 2022, he gave a completely different version. He said that Rocky actually pressed the barrel of the gun against his stomach and pushed. Why the different version of this court? Because when we talk about this, when you're lying, sometimes you just can't keep it straight. The truth never changes. In that regard, remember what Relli first said to the desk officer, Kirk Anderson, one of the last witnesses for the prosecution, maybe the last, when he reported this incident on November 8th, 2 days later. Officer Anderson told you that Relli said Rocky pulled out the gun from 5 to 10 feet away as he was approaching. We know that didn't happen. That's 2 days later. The video doesn't show that happening, but of course, Relli first reported this incident. He didn't know that there was video. In other words, Relli could not say whatever he wanted to say as he thinks. But he stopped from trying. Then he said that Rocky said during this incident, I'm going to kill you right now. That was his word to you all. I'm going to kill you right now. Now, folks, if someone says that to you, you're not likely to forget those words. That's going to be in your mind's eye for a long time. I'm going to kill you right now as a pointing gun. You're not going to forget them if they are truthful. If they're truthful. But when I confronted him with his prior statement to the district attorney recorded, so it can be taken. Only a year after the incident, in 2022, not 3.5 years later, like the trial testimony, only a year after, what did he say then about this? He told the district attorney on a recorded interview 1 year later. And then Rocky's like, he's saying something I don't remember because it was like a long time ago, and I don't remember what he was saying. First of all, it was a year later, and that was a long time ago. 3.5 years later, he remembers being given a death threat. A year later, he doesn't remember what he was saying because it was a long time ago. Again, the truth is not easy. Sorry, the truth is easy to keep straight. That's the truth. And when you're lying, when you're making up stories, you can't remember the lie all the time, and that's when these things happen. So what's Relli's explanation for a completely different answer on that? What's the explanation? Here's his explanation. Who told you all? When I asked him, I'm getting tired of talking to everyone, bro. That was this. I'm getting tired of talking to everyone. You said Rocky said he's going to kill you to destroy you. A year after this incident, you said. It was too long ago, you don't remember what he said. What's the story, Mr. Ephron? I'm getting tired of talking to everyone, bro. That's the answer. Just give my 30 million, my 30 M's. I gotta get out of here. I don't want to talk about this. This is the man they want you to believe beyond a reasonable doubt. And I think we know from using our God-given common sense, the truth doesn't keep changing. It doesn't keep changing. You don't get inconsistent version of the truth. You don't need to memorize the truth. One last thing on this point, that first incident. You heard Twelby explain how he believed, it was his observations, how he believed the prop gun came into Rocky's hand during that first altercation. To him, anyway, to Twelby, what it looked like was that Rocky's sweatpants were falling down, and you actually do see that in the video, and that Relli was lifting him off the ground, and you see that, and that Rocky grabbed the prop gun to adjust it, just had a little clip. That was Twelby's belief on what he saw in that chaotic moment. You have the video
We're
to
going to
watch
talk
yourself.
about that.
Along with that video, you have Twelby's testimony.
Oh my God, Tacopita killed me.
Rocky was being strong.
Go get the real
No
gun
question
and
about
shoot
that.
me now,
You see him being
guys.
choked at one point, Relli Twelby pointed out. He was grabbed, he was pulled, he was jostled.
Oh,
And
oh.
under those circumstances, Rocky's actions that reached were fully justified. His honor will be the law on self-defense. He has those sheets there. Jury instructions with you to take back. They have to disprove it beyond the reasonable doubt. They can't do that. That's a very heavy burden to carry. They won't be able to carry it.
Yeah, that's in your book.
And you know who tells you that? Not just the video, not just Twelby, not just the video that you saw, not just Twelby. You know who else tells you? It was self-defense. Relli. When Relli was talking to Wally Sejek, at the time he didn't think he was being recorded. You know, remember the recording is called fake. Here's what he said.
He tries to chest bump me. He tries to chest bump me and then pull out a gun for self-defense.
Well, so the guy wanting 30 million, the quote-unquote complaining witness in this case, the victim, is saying he pulled out a gun for self-defense. But somehow you are supposed to believe it wasn't in self-defense. That's his words. That was Twelby's words, and the video shows that. That's it. That's it. own so-called victim saying Rocky acted in self-defense. How could they prove otherwise beyond a reasonable doubt? They cannot. One last thing on this one, you watch the video, Rocky held the prop in his non-dominant left hand, or testimony Rocky's right. The entire time it's his left hand. Obviously, it was never meant to be more than anything but a deterrent. That thing's in his left hand all the time. Now, unfortunately, Relli wasn't deterred there. We heard about that after the first incident. We heard what happened. He followed Rocky, 12 Hills, all the way down to Argyle Avenue, around the corner to Selma, and then to Selma. Of course, when I questioned Relli about whether he followed them, he told you that he didn't. His answer was negative. Negative. So I tried to impeach him with his prior testimony, asking him whether he just said it was incorrect that he followed him. And what did Relli do? He became belligerent with me, asking me, when was that? What are you talking about? Because you tripped me. Like, I don't understand. That was the answer to me. Relli understood full well what was happening. They understood full well what was happening. Because when I tried to question Relli about this, there was an objection saying that the word following was vague. Following was vague. Anyone in this courtroom not understand the word following? Don't shield a witness like that. Relli said that previously under oath. They knew that. And despite efforts to not you hear that, Relli, you heard it yourself. Relli testified previously after the altercation by the parking garage that he followed Rocky 12 and it was followed. So why did Relli and the prosecution fight so hard? Record would hear that. Because they knew that's not the act of a victim.
No, that's improper.
And certainly not the one who claims to have just been knowingly assaulted with a real gun. That's not the act of a victim. That alone, folks, is another reasonable doubt. That puts a nail in the coffin in this case. That is not the action of a victim. Following someone who just pulled the gun on you, or the face, recollection, break the kill, and you know it's a real gun, you're following. Not only follow them, verbally assaulting them, as you follow them. We'll talk about that a bit soon, but right now, remember what Relli did as he followed Rocky 12 Hills. Relli was livid the entire time. He told you that, as a matter of fact. He was ready to hit 12. He said, ready to hit 12. But only after answering, this is my favorite, honestly. Were you ready to hit 12? Correct. Court said, yes, no, I don't remember. I don't know. Court was giving options. The witness's answer was, are you ready to hit 12? Was, yes, no, I don't recall. I don't know. Yes, no, I don't recall. I don't know. So, this is a game. Again, I remind everyone. This is their only complaining witness, their only witness to the events of that night, taking the witness stand, making serious accusations against somebody that have serious ramifications. You need to, and you get to assess his credibility. This man can give you a straight answer, not without having pulled from him, not without having the court admonish him. I mean, do you remember this one? He's telling me what to do. Literally, was telling me what to do as I'm trying to question him. That's why he was on the witness stand for 5 days. And the court won't want to say, no, don't tell Mr. Patrick what to do. His job is to ask questions. Your job is to answer questions. The guy was instructing me how I should ask, or what I should be doing while I was questioning him, as he's on the witness stand. In any event, Relli openly admitted that he was ready to hit Chloe. And after initially denying it, Relli also admitted he told the district attorney on 2022 and 2022 that he hated Ills. Here we all love Ills, told you. He told the DA 1 year later, I hated Ills. Hated. So with that hatred festering in him, he followed Rocky, 12 and Ills, and he screamed it all. And why did he do that? Why did he follow them all? Remember what he said about that? Because 12 put a knife away. That's why I thought. First of all, that doesn't make sense in any world. According to Relli, he decided to follow someone who he claimed had a gun and threatened to kill him because he saw a knife being put away. That's why he said he followed. That defies common sense. Second, you heard from Officer Anderson, who testified in the trial at the end. He was the guy who was lucky enough to receive Terell Ephron on November 8th, 2021, and heard him say, well, never mentioned anything about a knife when he first reported this case. Never. Back at point, Officer Anderson, Relli told him that 12 actually tried to de-escalate the situation. That's what Officer Anderson said Relli told him 2 days later. And third, beyond that, you heard from 12 himself. And he told you it wasn't true. He didn't carry a knife. And we don't believe, is there any real question about which of them is more believable, Relli or 12? You get to assess their credibility. Their credibility is based on everything. The way they answer questions. Did they get caught in lies? Were they impeached? Were they inconsistent? How was their demeanor? Yeah. Relli didn't follow Rocky 12 Mills because he saw a knife. He did it because he was angry and jealous. He did it because he wanted revenge. You heard what he was yelling at as he was following. He told Ills he was a crackhead. You heard that Ills does have some serious problems with that. You heard he said 12 he lived in the projects, mocking that whole thing. Like, how horrible. You're not as successful. You live in projects. And that Rocky had failed us all. Think about that last line. Rocky failed us all. Like, he was his warden. That last line shows you there's no question he was angry at us. And the second altercation, and those negative feelings came to a boiling point when Relli and everyone else reached that corner of East Delmar. According to them, when they reached the corner of East Delmar, Rocky just turned around and started firing. For no reason. He just started firing. And then Relli used Ills as a human shield, he said. The evidence shows you that's absolutely not what happened. The entire time that Relli was following Rocky was trying to get away from him. He was verbally assaulting Rocky. Like, it's a word. Not a word, you heard that. Relli even told you that, Relli told you that. He was just the first one walking away. It was Relli who was acting crazy and screaming according to 12. So why would Rocky suddenly go from 0 to 100 for no reason at all to shoot him? He wouldn't, he didn't, and it doesn't make sense. But what does make sense is what you saw for yourself on the video that we're going to show you again. And what do you see for yourself on the video? What 12 explained. That Relli was looking for a fight, as he already said. That he attacked Bills. And that Rocky fired a warning shot with a prop gun in self-defense and defense of another. And the prosecution played you a video called the sequence surveillance video. I'm going to show you that video at the end. Which placed the first shot from 6200 Hollywood Boulevard video over the 1660 East Delmar video. Before Relli grabbed Bills. That video placed the first shot before Relli grabbed Bills. That was Memphis Station. Because that did not happen that way. That's not what happened. You heard from Detective Flores on this. That sequence surveillance video, that's what it was called, sequence surveillance video, was made by hand, so the cursor bouncing around there. And it was a rough approximation, his word, rough approximation of what happened. Rough. Where every second here counts. That's a rough approximation. So we try to put the sound into the video. It was a rough approximation. No. Rough approximation is not proof beyond a reasonable doubt. Detective. He also told you the first shot depicted would have actually occurred at a later point because 6200 Hollywood video was fast. And what did we see the other day when he was testifying? When I cross-examined him? We looked at that video in real time, and it was really fast. It was fast. Like the floor said, oh yeah, one thing says 9 seconds, one says 8, you're right. So we know the sequence surveillance video was wrong. In fact, the detective Flores at that point distanced himself from it. He said, I was the one who made it. I didn't make it. Well, who did? I don't just believe Detective Flores. I know he didn't make it, but who did? Where did it come from? You were never told that. No one told you how they made it. That rough approximation that turned out to be wrong. We just threw it together, hoping that would be sufficient, that we'd all accept that as the video with the sound, and that's the time. Hoping no one would notice reaction. We did. That's what they're trying to pass off as evidence in a crucial issue in this case. Did Rocky fire before or after Relli lunged at Hills? Because that fact changes Rocky's mindset at that point. The prosecution wants you to believe Rocky shot first. For no reason. And that Relli then dove for Hills as human shield. That's not what happened. You heard from Relli, who looked at the enlarged video that we introduced. The one with the first shot happening after Relli lunged for Hills, after Relli hit Hills multiple times. And 12 told you, he narrated that video actually. You had your eye, you see. His arm go out with that first shot. And that's when the first shot is. It's well after Relli's in full-blown attack mode on Hills. And 12 told you what happened. When the prosecution cross-examined him, they did everything possible to not let him explain what happened. Yelled at him, demanded yes, no answers. They rated him. Anything but let him explain. They did that with 12, a compliant witness, a respectful witness, over and over. But when I asked questions of Relli, I got speeches, insults, not answers, but I didn't cut them off. I didn't demand yes or no. If you wanted to tie the noose on his own neck, let him go. But they kept cutting 12 you off because they didn't want you to hear what really happened.
No, that's the proper argument. You're not going to be able to.
Suffer, prosecutor.
That's why the prosecution and their case detectives didn't even try to speak to 12 for 3.5 years. They knew who it was. They knew where he lived. 3.5 years, they didn't try to speak to 12.
And see, guys, he's finally getting back to the stuff that really matters. 12, nobody talked to him. Nobody did anything. This is the shit he really should be focusing on. I think he pissed away a good amount of time here. He could have been using to hammer on this and make it tightened up. Tighten it up.
Yeah, who told the trial started? Or no, sorry, not even. As the trial started, they asked in court with the judge, "Do you want to speak to us?" Nah, I'm good. Okay, the trial had already started. It was a witness. 3.5 years, they didn't think to reach out. But they tried to make things otherwise. They asked Detective Flores on the rec whether 12 would agree to an interview. Detective Flores said no. That was it. No. Which would leave you with an impression I would understand that 12 was not cooperating. What you learned on cross-examination that Detective Flores only first tried to speak to 12 a couple of weeks ago in 2025. Come on. I asked Detective Flores, is January 2025 the first time you tried to interview 12 about what happened on November 6, 2021? His answer was, correct. Me personally, yes. So I had to follow up that one with you personally. You say you personally. How about anyone else from the police department? His answer was, no, that would be the first time. I mean, Detective Flores seriously think I was just asking about him personally? Of course not. That would be devastating. So I had to go through 3 layers of that. Oh, here it would be. We're putting it up in that. Move by it. It was up. It's a nice beach. It was a beach anyway, ladies and gentlemen. That doesn't prove it. Okay, that's so no one thinks I'm just saying, yep, that's what he said. 12 would be interviewed by you, and you said no, he wouldn't. Remember? Yes. Are you referring to 2 weeks ago in court here? Yes. Is that the first time you tried to interview him? Yes. So in January 2025 is the first time you tried to interview 12 about the incident that occurred on November 6, 2021? Correct. Me personally, yes. How about anyone else from your police department? Yes. No. That would be the first time. Correct. Why did I ever bring it out on cross? Why? Search for the truth. Why is that all coming out on the record? As opposed to leaving you with the impression, if I decided not to get up and cross-examine, or I was asleep, you'd be left with the impression, barely, that 12 was not compliant, he wasn't cooperative, he didn't want to speak, but he refused to be interviewed. That's not the case, as you say. And they 12 told you what happened. His testimony is consistent with what's seen on that video. Look, that's defense exhibit EE, and I would say this, thank God, there's a video. Thank God there's a video, he's still on. Before we play, hold on. When I was listening to Mr. Long's summation, the first summation that they get, it was as if he never saw this video. This is the exact right time of what happened. Based on the video, based on 12D's testimony, based on the Detective Flores saying that their video was a second too fast. You see those thrown haymakers in this video. Haymakers, expression, punches, repeated and showed you. Then Mr. Long said in his opening statement, in his opening summation, that I said in my opening that I promised you I was going to bring in pictures of ills to show you. Ladies and gentlemen, I don't make promises I can't keep. And I promise you, I never said that in my opening statement. As a matter of fact, they get to go again. I will not object if they put my opening statement up.
No, that's improper. It's a statement.
Show me anywhere where I promised pictures of ills. I never did. But that was argued to yesterday. And why will they take pictures of ills while he lived on November 6, 2021, just in case it was a trial in 2025? Okay, let's watch that defense exhibit EE. You'll see everything shown in described in the video. That Relli acted as the aggressor, that he repeatedly hit Ills. Only after that, Rocky tried to defend Ills by firing the first warning shot. Sergeant Cook sort of suggested on the body cam. You see his arm extending to fire the props when you hear the sound. It's clear and obvious. You had a live witness who was also there. Let's look at it now. This is the REE. There's Rocky, there's 12E, there's Ills, and then there's Relli. And you see him going after, then boom. Second shot. You see Relli still going after Ills. Still going after Ills. Rocky's gone. 12 is about to go. Ills is stuck in the upper left-hand corner there. Watch Relli go back after him one more time left before he goes right. goes right away, he falls. And then Relli goes off to the right. Now, we have to break that down a little slower, it's very fast. What happens, again, that's when you're deliberating, you get to see this. Right? So back in the room. Yeah. Do they, does this get to go back in the room with them? Yeah. Oh, good. So, you can see as much as you want, as long as you want, as slow as you want, as fast as you want. But look, that didn't stop Relli. I'm not going to yet. What you see is him repeatedly hitting those, move towards Relli and trying to hit it. And look, you see Relli literally cocking his arm back and slugging Hills. I'm going to try and show it to you here. I'm going to get that pointer. I'm going to sit in this chair so I don't block you all in the back. Can everyone back there see? Yep, big head. Okay. Wow. Be gentle on the screen. There's Rocky, there's 12B, there's Hills, and there's Relli. And boom, he's going after him. Look at him. He's tussling him. There's the first shot. There's the second. And look at his arm going back and forth here. Can you go back for a second, guys? Look, you see the arm going back and forth. Go back one more time, guys. A little further. Yes, thank you. Watch this arm. Boom, and you see the head of Bill's there, going back and forth. And why does 12 tell you he ran? One more time, guys, please. He said he sees Relli coming at him, and he has that something hernia, renal hernia, whatever that is, and he couldn't fight. Watch. He's right there. Then he sees him coming, and he runs because he can't fight. Look, it's over. Why is he still fighting? And he just knocks those down. DA comes off this part. Boom. One more. Good graces, and then he goes to the right and leaves. Well, the good news is you get to take that back in the video. The jury, right? So that's good. You can see as many times as you want. Go speak if you want. Stop working. I encourage you to do it. That's defense exhibit E. That's the right time. You see, Jack, do it one more time, just that shot part. It's out, it's what Relli told you, but again, you have eyes. Rocky's arm goes like that. That's where the shots are. Really describe that. So he's doing, he's shooting down himself. It's after Relli attacks him. Boom, he's hitting Hills. Boom, you hear the shot. Ladies and gentlemen, there's no real question that Relli was the aggressor here. The video from 16 Visa Del Mar makes that perfectly clear. Perfectly clear, real clear, not the rough one that was off by a second. That makes the shooting all the ridiculous. I mean, their video, you hear a shot, and they're Rocky Supers. That's the video that captured what happened. 12 narrated for you, your eyes are touching. He wasn't using Hills as human shield. He wasn't underneath or behind Hills. He was on top of Hills. That's not how you use human shield. And 12 told you. Now, he told Rocky to leave because of the noise, because of the status of the high-profile person. And Rocky ultimately left, but still, after that, Relli continued to attack Hills. They, as I mentioned to you, they cut off their video, so you didn't see that anymore. I'm hoping, oh no, so let's play their video real quick. Can we play theirs? It's their video. Watch what's cut off at the end. Rocky's going. 12 checking to make sure it was okay. Then he runs. That's it. 16 Visa Del Mar. 16 Visa Del Mar is cut off. Go back one more time, just where it gets cut off. Combined surveillance video. That's the one. What you know happens next is Relli, they're out of the picture now. Relli goes back and hits Hills again. 12 describe it for you. Why did that not make it to this video? Good. Boom. But I think this chair is a nail stick now, by the way. Just so you know.
That wasn't me.
I know that wasn't you, John. That one I don't blame. Is there a bill I can send for the suit that you sent me? Literally, it's a nail stick. Anyway, don't worry. Let me sit there. Not good. Okay. Anyway, the video, folks, the video itself by itself is reasonable doubt. It's a reasonable doubt in this case. Another reasonable doubt. It just makes clear that their case is not in water, that Relli was the aggressor, that Rocky acted justifiably in self-defense bills. He was carrying a shotgun, his Hills would be dead. That was a real gun on that second shot. And again, Judge David trusts no self-defense. I have to discuss it with you. What matters is the defendant's perspective is what matters. And and what he thought was right. I'm just giving instruction on that, reasonableness and all that stuff. You have to listen to that. The prosecution must prove beyond a reasonable doubt that he did not act reasonably. It has to prove beyond a reasonable doubt that he did not act in self-defense of another. If you have any questions in your mind as to whether he acted in self-defense or defense of another, if you have some doubt or some concern that he just may have acted in defense of himself or another, you have to stop. Not guilty.
It's like taking the law. It's true.
The same are?
Yes,
I'm sorry?
it's what you said, it's not accurate. Here's a jury instruction that's already been given to you. This applies to everybody. You must follow the law as I explained it to you, even if you disagree with it. If you believe that the attorney's comments on the law conflict with my instructions, you must follow my instructions.
But I think I understand what Mr. Lewin's objection was. He actually was right. I said some doubt. It's not some doubt. It's a reasonable doubt.
That is right.
It's a reasonable. Okay. So, no swap. So if you have a reasonable doubt that he may have acted in self-defense of another, you have to stop. Okay? And the judge again will define to you what that is. Even if you get that far, which you should, because the evidence is so long, that's fine. There's a possibility he acted in self-defense. You must find another. Rocky, now we've got to address this. Rocky didn't testify in this case. When you heard the judge's instruction about that the defendant has a constitutional right not to testify, we spoke to somebody in the jury selection about that. And that decision is not considered during your deliberations. With that said, during your deliberations, keep in mind that there was nothing more said than what was already explained to you by both our witnesses. So what we rated, you know that for a long time. You heard from 12B, who explained what happened that night. And Rocky carried the prop gun. You heard from 11, who explained how Rocky got possession of the prop gun, why he carried it, and where it went. There was really nothing more aside from the video of 12B and for Rocky to add to the truth about it.
That's an improper argument. It's just
Well, look, by the way, with regards to 12B and Lou, you heard the people say, and I expect they will say it again, the first time that we mentioned the prop gun was during this trial. This Detective Flores' testimony when they tried to ask him that or suggest that this had just come up. Question to Detective Flores. We're doing deposition criminal cases correctly. Question. So basically, what you were being asked are questions related to discovery disclosure in a criminal case. And he said, yes. Okay. So these discovery related matters, and because he received discovery notice, is not the same as it just surfaced at trial. Like it was just invented. That's not true. Lou and 12B they told us about this last year. And of course, Detective Flores told you law enforcement didn't have a chance to speak to Rocky. And he was arrested. And of course, there's no idea.
that mistakes.
No, who didn't say they didn't have a chance to.
Do not make.
You said mistakes, yeah.
As I said yesterday, I don't know what the evidence is. I don't think anybody remembers every word of every witness. If this is something significant, as I mentioned yesterday, you can ask the court reporter to read it back. The court reporter will have every word that has been spoken. Go ahead.
And of course, Detective Flores had no idea what was said by Rocky Cruz's attorneys back in 2022 when he was arrested.
That's also an improper argument. The real side of the evidence.
In any event, there's absolutely nothing new, as they're trying to suggest. And look, they also brought up something that I now have to address, that Rocky had an outburst, so to speak, in trial. Okay, knowing that he's innocent, he had to sit here and listen for more than 3 weeks. Listen to
No,
whether
this is improper argument.
It's addressing what Mr. Kozlovic had brought up in his argument.
he had to sit here for more than 3 weeks, listening to Relli say the most horrific, most offensive things about him, in messages, calling him horrific names. He didn't say a word. He sat in silence. Always composed and respectful to this court and to you all. At some point, during a minor, unrelated question, unrelated to November 6, 2021, Ms. Lou was asking 12B the meaning of an acronym in Rocky's bedroom. Rocky did something was a crime. He said, don't say it. It had to do with his kids. It was personal to his children. And he asked not to say, okay. He regrets doing that?
No, there's no evidence of this.
Can you read that back?
Mr. Jones was asking for you to make it an acronym. And if Rocky did something that it was private, said don't say it, it had to do with his kids. It was personal to his children. He asked him not to say it.
The jury heard what the question was. The jury heard what Mr. Mayers said.
That had absolutely nothing to do with the facts of this case. Truth, what happened on November 6, 2021, whether he carried a prop gun, he didn't commit a crime. The fact that they actually argued that to you in their summation is indicative, just like that's what they are. That was something worth mentioning to you in their summation. Let's talk about the crime of extortion by Relli. That was actually proven in this trial.
Your Honor, that's improper argument. Overall, he concluded time.
Overruled.
That's why Rakim told Relli in a text message that night.
God, just let him talk.
But Relli didn't, not until he got civil lawyers 2 days later, because it was never his intention to go to police. You heard that loud and clear. He said his end game was always to take Rocky's money based on false accusations. That was always his intention. And that's why that night, instead of getting the police involved, Relli, according to him, with his shell casing that he claims he found, texted the photos of his shell casings and knuckle scrapes to Rocky's manager, John Heyman, saying he was going to be rich. And that following message was sent to his own business partner, Justin Benet, saying, I want to get this end's money within minutes. That was in his mind. And you heard Relli complain in bitterness how Rocky didn't give him opportunities. So when the opportunity presented itself on November 6th, 2021, could have jumped all over. Right from the beginning, Relli tried to get Rocky's money. Right from the beginning, without going to the police, not even going to a civil lawyer. So you heard from his own mouth what he knew that to be. Words so catastrophic to his claims in this case that his immediate reaction was to lie and say the tapes were fake. Fake. Get those away from me. You have to tell me no. Fake. Look.
Did the whole thing because we were presenting fake evidence to you? Yes or no? I don't know. I don't know. It's just a wonderful. Why don't you guys keep playing fake audios and like fake stuff? I never said none of that shit. It doesn't even make sense. It doesn't fit with the tapes. We're trying to slip it in. Okay, stop. All right, answer the question.
Fake audio tapes. Fake audio tapes that the district attorney played yesterday with the Terell Ephron name. That's all his quotes. And the Terell Ephron was sitting here yesterday, he was screaming, those are fake! During Mr. Berzone's information. I heard Mr. Berzone say in his information, who cares what he said to Wally? Who cares? You need to forget the import of that conversation, that he committed perjury to you and said that they were fake when they were real. And, you know, during the cross-examination of Wally, the guy flew from Paris, by the way, honestly, because he had it here. Okay, literally a 13-hour flight to testify and then take another 13-hour flight back. And the question was, you flew business class, didn't you? Like, as if that were the reason he took 26 hours of plane to get here to testify. I had him on direct examination 10 minutes. Because he was here for 2 things. Do you know anything about this case? I know nothing about this case. Good. Is this tape real? Is that, did you make it? And is that your voice? And is that Relli's voice? Yes, it is. Bye-bye. Have a good flight back. Nope. 2.5 hours on cross-examination. But you know what was never asked on cross-examination? Not even once. Is the tape fake? Is the tape fake? Did you doctor the tape? Not even once. By the way, the tape they spent, I don't know, the portion of the destination playing for you yesterday, we provided to them. We provided them that tape. That they think so helpful to them. They know those tapes are dead. Dead to their case. First of all, the main witness once again committed perjury on a most important issue in this case. Those are fake. These are fake. Get those away. He's a clown. Those tapes are death for his claim and his credibility in their case. As well as Jimmy made clear that anything but fake, you heard Relli tell him that you ask for a bag without a lawyer, bro, it's called extortion.
You know what I'm saying? That's what back without a lawyer, bro, it's called extortion. Feel me?
But that's exactly what
Do everything accordingly.
That's exactly what Relli did. Because he didn't have a lawyer until November 8th, 2021. After he already tried to ask for money from Rocky and his manager. And after Relli lied about what he just told Wallace Jemmy, we called Mrs. Jemmy just to establish the authenticity of those recordings. Nothing more. He knew nothing about this case. And because of the evidentiary rules, we were only allowed to ask Mrs. Jemmy about statements that Relli denied making.
No, that is untrue.
So we had those 5 questions that we asked him. Did he say this? Did he say this? Did he say this? That's the prosecution played other parts of the recordings afterwards. It was not a gotcha moment. So we gave him those things. At the time of their discussions, remember this, the Wallace and Jennings discussions, that was in 2022, after Rocky's arrest already, after he filed his civil suit. Well, they were about the events of November 6, 2021. There were no significance at all what Relli said to him at that point regarding November 6th, at all, because he had already been arrested, Rocky. Relli had already been telling his story for months. He's fabricated his story for months. So that he said the truth while on a tape makes it more true. If you tell a lie 100 times, it doesn't make it more true. So in an effort to give weight to that story about the incident, those recordings, they played. Rocky was already arrested and he already had a civil suit, and permanent disabilities from a bullet wound, and he needs $30 million. That was his story by then. Big deal, he said to Wally, in part. He still had no qualms lying to Wally at all on those recordings. When it suited him, of course, telling Wally that he was a millionaire and that he made Rocky's career, that was on those recordings too. That wasn't true, neither of those things. But when Relli didn't lie about, however, what he didn't lie was about his intention to take Rocky's money, which is why he falsely said the recordings were fake. He knew what was coming. And he just said, I say they're fake, they can't play them. They're fake, get those away from me. In other words, get away from me. So Wallace Jr. was an IP guy who came in for one reason, authentic tape, period, end of story. First question I asked him, do you know anything about the facts of this case? No, I don't. He was not brought in here to talk about the facts of this case. But the prosecution, in 2.5 hours of cross-examination, asked him about his motives for making the tape. Is he better friends with Rocky? That's not being very good friend to Relli. It doesn't matter what he made the tape. Who cares? He could have, whatever his motives were, who cares? He made the tape. It was real. Those were really Relli's words that he said were fake. Whatever his motive was is irrelevant. He doesn't want to help Rocky. He told you that's how it was, is that Relli was trying to get involved, he was falling, whatever. But whatever his motives were, does he make the tape less real? Or Relli's statements less real? He was never asked one thing about those recordings being real, on cross, which means they accept the fact that they're witnessing the perjury to you when he said they're fake.
That's improper argument too.
Fair comment.
That should be offensive. And especially to you, the jury, trying to make a decision of such importance in this case. It's a lot on your shoulders. That should be, you should be offended by that, I would say. So what did Relli tell us on those messages? His earlier text messages to Rocky when his manager, when they were trying to get money before his lawsuit, that he never cared about the police. He still doesn't care about the police. Quote, the end game, I'm suing the shit out of him. That's my end game regardless. I don't give a F about no police, and those are his words on tape. In fact, Relli only went to the police after his effort to restore Rocky failed. And Relli's civil lawyer said, unless you go to the police, I'm not taking the case. That's why Relli showed up at the police station in Hollywood with a civil lawyer standing next to him 2 days later. What victim of crime was a police station report crime with an attorney next to him? Judge, want to do it now?
Very good point.
If you have 2 more minutes,
Right,
use
go
that,
ahead.
otherwise you can break.
Go.
Say again?
I'll do 2 more minutes, just tell me when to stop.
Then we're gonna take it.
Kill me
I
now!
heard,
Oh
by
my
the way, the
god!
prosecution questioned Relli about telling the police he heard 3 to 4 shots, but only giving them 2 shell casings before having seen the videos, as if somehow that makes him more credible. That makes no sense. He was there, of course. He knew it was 2 shots. By this time, he already saw the video. He knows it's 2 shots. And in fact, he would exaggerate when speaking to the police. It's not making him more credible. By the way, when we saw the Wally, he had up to 5 shots. He had up to 5 shots when we saw the Wally. So before Relli went to the police, even before he went to a civil lawyer, you saw the messages he sent, trying to get Rocky's money. Part of his plan to extort Rocky, Relli sent a text message to him, falsely accusing Rocky of trying to kill him. Obviously, Rocky knew that was false and was shocked that Relli would even make a claim, so which is why Rocky wrote back, I tried to lie. Stop making shit up, he wrote back. And now the prosecution has alluded to the fact that during this trial, Rocky didn't mention in his message anything about his pop gun. They don't consider one thing, though, about that. They don't consider one thing. Unlike Relli, Rocky didn't have a reason at the time he sent that message about stop making shit up. He didn't have a reason at the time, or think he needed a reason to create a record of events for some later date. At the time he sent those messages, Rocky thought they were between the 2 of them. And he knew why Relli understood his thing wasn't true, because it wasn't true. Rocky didn't shoot him and was aware that Relli knew he didn't shoot him Because a shotgun doesn't shoot bullets. A smart pistol doesn't shoot bullets.
Protecting.
Yes, sir.
You want to finish the thought?
If I could, just a
Finish the thought, and then we'll take
And
it.
then that's perfect. That's great. And that's why after learning soon thereafter that Relli was contacting his manager trying to extort money from him, Rocky was done.
He's not micro-napping. That's
Stop that.
I've seen judges do that, where they're kind of just focusing.
What kind of person? Tell someone to go to the police if they know they're in the I could resume from here. Come back.
All right, we'll take a break until 11 o'clock, folks. Please make a case amongst yourself and anybody else.
All right, chat. So we got a quick break here. So, Mark is saying, did Taco say he was doing a shorter closing because he called the prosecutor for perjury? No. When the judge said, quit talking about perjury, he said, fine, that'll shorten up things for me, which I don't know how much shorter it's really going to get, but I mean, I'm like, I want them to go find a gun for me. Go find this Glock. I can't do it. I can't do it. So guys, all welcome. I know there's a couple people here. I know some people have joined in. Day closing arguments are ASAP Rocky into the second day. That's James says, how are you doing, by the way? Are you afraid you'll ever accidentally call the jury chat? I've never thought about it, and now I'm terrified of the idea. Thank you. I didn't really need that today. But yes, in the future, like I said, we were supposed to be in trial this week, but we got a favorable resolution. But I'm like, now I'm terrified I'm gonna actually do that. Chat, welcome, chat. Let's get started. And they're gonna be like, what? And I'm like, oh shit. No, I hope I never do that. I hope I never do that. But now you've got me scared that it's gonna happen. So now I'm self-conscious. Matthew Felty says, the defense could have subpoenaed records too, but it probably didn't to preserve this defense strategy. Well, yeah. Why would you help? Why would you subpoena? Because if you file a subpoena, everybody knows you filed a subpoena. So then you might tip them off to go get a subpoena for those records too. So yeah, there's no, don't make it easy for the state. Never do that. Never do that. Damocles says, it's been a while since I caught you on live. Well, welcome. It's good to see you. Bama Law is a new member. He's chat. He joined up tonight. He did his part.
Fight for the future.
I'm doing my part.
I'm doing my part.
I'm doing my part.
I'm doing my part too.
They're doing their part. Are you?
He did his part, chat. He did his part. Thank you. Hope you're doing well, man. He says, this improper argument shit I've literally heard maybe twice in 15 years and hundreds of trials. Yeah, I am not impressed with Lewin. Lewin has lost his fucking mind. And chat, it only gets worse from here. There are some updates on what happens. Like, they only continue to fight. This Lewin guy is not impressing me. He should be held in contempt. The way he's acting and governing himself in this case is truly disgusting. And the fact he just doesn't accept, and just as many prosecutors, you're not entitled to a fair trial. And, as I've done cases now, I am really going to make sure that's a point when we're talking in jury instructions and things, that only one side's entitled to a fair trial. And you know what? I'm just going to say it. And you know what? From now on, I'm just going to let it ride, because that's how it should be. No more of this pussyfooting around and dealing with it. He says, this is for a sidebar. Ag, who's been a member for 22 months, says, I still have a job for now. Well, congratulations. You made the cut. Elon thinks you're useful. No, reality though, man, I think you're not teaching like blind transgender penguins how to read, so I think you'll be okay. Oh, 2.0 is still hired, guys. 2.0 still has a job. She's not been fired yet, either by the FBI. So she's still hanging in there. Yamal says, imagine being there for that. Probably so uncomfortable. Oh, no, it's not. Trust, dude. It's like when you're in it, it's like when you're going back and forth with the counsel, and like when the wheels, like, here's when it's uncomfortable. It's uncomfortable when you're sitting there and the other party is literally just like auguring into the ground, just like when they're crashing and burning, That's when it's awkward and uncomfortable. And you're just sitting there and you're watching the other side and they are just getting shellacked. And you're just like, and you just look at your client, you write on a notepad, just shut up and look forward. Look down at your notes. Don't say anything. Let's hope he doesn't catch. If we don't move, he won't see us. That's when it's awkward and uncomfortable. When you're in the middle of it and it's like, screw you, no, screw you. That's not uncomfortable. That's the heat of battle, man. That's like, that's jump ball. It's okay. It's okay. Some of you may be saying, when's the last time you jumped, Sean? I'm like, good point. Gordon G says pot crim. Yes, thank you. By the way, chat, just bring it up so we are aware. Sponsor of the show, this trial stream, is maf-arms.com. Buying all your wind chime needs in Southern Florida. Guys, use a promo code POTCRIM. You get 10% off. So that's a good callback. That's a good way to read that in there. Eric of the case says, hey, Sean, doing well. Happy Valentine's Day, man. Well, I hope you're doing well. Take care, man. Take care. I hope you're doing good. I'm doing well. Happy Single Awareness Day, as the joke goes. Tacopina's suit is not hanging well. Yeah, it's cut to be a certain way. So, yeah. Taco could have brought this down and ended greatly a day ago. I think so, but I understand the need. Sometimes you get wrapped up in wanting to fight. So, I get it. I get it. That shape says you're welcome. Thanks. Thank you. God, now I'm going to be thinking about that all the time. I got a guy, next week we got a guy, one of my clients, we're getting arraigned on a pretty decent drug case. And it's just like you walk into court for the arraignment. I'll walk in front of the magistrate. Chat, it's like, how do you wish to proceed? Thank you, chat. It's like, it's Your Honor. Like, I can only imagine. Oh my gosh. Oh my gosh. That makes me worried. Young says, can you play on your computer? Oh, you mean while you're in court? Yeah, I mean, like, it's not like they're playing like Counter-Strike or something, but yeah. And then I'll start yelling at the jury about the air compressor. Oh. Kat, how are you doing? Saying this is great. Well, I'm glad you guys are enjoying it. You missed the opportunity to show the Nazi flag at the end. Oh. KLF says, where's Ills? Why was he not called to the stand? That's a question for the prosecution. Why didn't they call him? Why didn't they call Ills? For some reason, they didn't want to do it. Oh, that's a shame, says I was practicing my opening statement and found myself saying it. I am sorry that it rubbed off on you. I am so sorry. Oh. How often have you had a judge had to bang a gavel to restore order? I've never had a judge bang a gavel, but I have had the judge go like, listen here, you guys need to cool it. Like, I've had those moments where the judge is like, enough. But I never kept pushing it. But like Tacopina, he's going to be like, I've been held in contempt. I've been chewed out. I make like $1 million, whatever. Me, like, I would never do that. Also, when I was a lowly assistant prosecutor, I would never do any of this because guess what happens before I get downstairs? My boss is going to hear about it, and then I might be like, you're fired. The way Lewin's acting, like, there's more than one office that I've dealt with would have fired his ass already for this. Like, this is absolutely abhorrent. So let me see here. KNW raid. Oh, hello, everybody. Thank you for being here. Hold on one second, chat. Happy Valentine's Day, mon chéri. That's right, chat. It's Valentine's Day. Say hi to your Valentines out there. I was about to drop gamer words in court. No, You can only do that when it's in discussion about testimony. Garrett says that rubbed off comment was your segue to the Stoney's read. Oh. All right, chat. Okay, but yes, tonight, chat. Tonight. Yes, at Stoney's Bar and Grill. If you guys are new to the show here, yes, Stoney's Bar and Grill at 1580 East Broadway Street in Rockville, Minnesota. And some of you might say, wait, you're an attorney in Cleveland. Why are you plugging a bar in the middle of Hee Hawville, Minnesota? And you're like, that's not for you to worry about. It's not for you to worry about, chat. It's not for you to worry about. Anyway, Stoney's your place to go, chat. They are open now. They opened up at 1 o'clock today, chat, for the winter hours. You could celebrate Valentine's Day at Stoney's, chat. Happy hours until 8 p.m. You still got 30 minutes to fire up your hog, get down there and get a couple happy hour road pops. They have the meat raffle tonight. They have the keys for cash. So having a key party. It's like Nick might be in attendance tonight, if you catch my drift. Then tonight they have the Unwanted as a band performing, guys. Stoney's celebrating 30 years as Minnesota's premier biker bar. All right, guys. So we're going to get back to this here. Yes, all the twisters, the circles on the twister mats are hearts for Valentine's Day. Oh. Darcy is saying, rumor, the new district attorney came in for Lewin's rebuttal closing. Good. Because this is not going to be good here. Bama's saying, doesn't Ohio have a split system of law and chancery? No, we do not. We don't have chancery courts. We have courts of general jurisdiction. We don't have a unified court system, but yeah, we don't have chancery courts. We're lucky because we're not like 13 colonies thing. Although I don't know in Alabama if you guys do. But no, we do not have chancery courts. Those were, I think, maybe way at the beginning, but we abolished those. We have courts of common pleas. That's what we have. That they handle everything. And then there's obviously municipal courts. So let's see. The meat raffle or the auctioning off Kayla in April. Oh no. That's a shame. Says, wait, what's a unified court system? So like in some places they have unified courts. Like I think in Minnesota they do, where like all the courts, like you might have juvenile, probate, felony, stuff like that. It all gets condensed. So there really aren't distinctions. Like that's a unified court system. That's how those things work. And other places may call it different things. But a unified court system works that way. It kind of all works together. It streamlines everything. That way there's not like separate courts going on. They feel like it kind of keeps things from overlapping, and there's reduction and redundancy issues. They argue it helps with that. You can also like consolidate courts. Like I think like New York has a unified court system. There's all kinds of states that do it. But anyways, like let me look at the Minnesota one here so I can see. But yeah, like we saw in the Nick case, like they have like all the courts are there. They do everything. Let me see here, chat. Looking for something. But anyways, like for example, though, if you go to just the way they do stuff, they have a lot of different court cases they'll come through, and they kind of all do them. They all do them all together. There really aren't distinctions between them. That James is just how cases are divvied up on judges. Okay. That's James says, I think ours are like that. I don't know. But I know here, like in Ohio, you have general court judges, you have juvie judges, probate judges. They're separate things. We don't unify our court system. So, yeah. But those are like how unified courts work. We don't do that stuff. Oh. But every state's a little different when it comes to it. We just don't do it. And I like that. I like having courts a separate jurisdiction like that. And yeah. So anyways, guys, we are going to keep moving on here. Let's keep going. They're on. They're on a break.
Mr. Tapachita mentioned, and I missed this.
So here you go. Apparently there was a mistake, so the court's going to just instruct the jury.
The prosecution accepts their witness committing perjury. I missed that. There was an objection. I overruled it. I didn't hear the whole statement. I'm not accusing anybody of doing it proper, but that statement puts the prosecutors in an unfair light. And that was improper. I overruled the objection. I should have sustained it. I don't want any side being disparaged or being put in a false light. So I made that mistake. I own it. I apologize.
Two things. One, I realized something. I said before that Mr. Ephron said he'd seen the video previously when he said there were 2 shots. What I was talking about was when he was speaking to Wally, getting ready to see the video. This was obviously after Rocky's arrest and after the civil suit was filed. So I wasn't suggesting he saw the video when he went to the police on November 8th, in case that came out unclear. I hope I'm supposed to do so. Anyway, now we're back on the Wally's subject case. Look, all I'm saying is
we missed an argument? Oh, okay, hold on here. So we need to go back. Apparently we missed something. What did we miss? I don't see any. Oh, okay, we missed something. Okay. Thank you for bringing that up, Young. All right. Here we go. Hold on. All right. This is the problem because it doesn't show you where you're at. Okay. Okay, here we go. Here we go. Here we go, chat.
It's improper, it's unethical, you said you're not going to tolerate it, and I object. And you make it clear to the jury that my objection you find annoying. It's very clear that the tone that we get when we make an objection that should be sustained is, what are you doing? That's what we said. You specifically
Lower your voice and don't yell at me. I told you before. I'll listen to what you say. Speak in a normal tone of voice.
Judge, we're doing the best we can.
This guy's losing his mind. Lewin has lost his mind. Getting like you are he's so invested in this case. He owns stock in it. He's a majority shareholder. You shouldn't be this invested in a couple of rappers shooting at each other. This isn't like a child murderer. This isn't like, a serial killer. Like, why are you so fired up about this, bro? Why are you so fired up?
To make sure that this trial is ethically correct. They have repeated, I objected, you told me it's improper. You overruled repeated objections where they are saying improper things. You just said a moment ago, this is a direct quote. The prosecution accepts their witness committing perjury. I object. You respond, that's appropriate comment on the evidence. It is not appropriate comment on the evidence, Your Honor. I don't know if you didn't hear it.
I didn't hear that.
So, Judge,
What I heard, I could have been wrong, what I heard was that Mr. Tacopina was describing Relli as committing perjury.
Judge, that's a direct quote. The direct quote was, the prosecution accepts their witness committing perjury. Here's another thing. Relli committed extortion. There is no legal.
Do you think the jury's going to ask for what the legal description of extortion is?
Your Honor.
Forcing someone to pay money, that is, quote, extortion.
Your Honor.
Go on to something else.
No, I want to make my record. I mean, you're going to do what you're going to do, but I have a right to make my record.
What a crybaby. The judge even says it. To any person on the street, that sounds like extortion. Exactly, Judge. Exactly. The judge is being the most reasonable man in the room right now. This judge is doing good. But he should hold this guy in contempt at some point. This is getting ridiculous.
No lawyer can get up here. No lawyer can get up here and tell the jury that a crime has been committed when there is no instruction on that crime. When in fact, Your Honor, that's not the legal definition of extortion. We've objected, and the court again is basically telling you, don't worry about it, doesn't matter. Your Honor, it does matter. After a while, when there are so many of these things, they add up. And when the court is saying, well, what they don't care about it.
No, I didn't say they don't care about it.
It's Your Honor, it's improper argument. The problem is.
I don't agree with you. I think using the word, quote, extortion to describe the conduct is not improper. I think it's fair comment on the evidence. You, in your rebuttal argument, you can say it wasn't extortion. You can address it.
Your Honor, the bigger issue, as I said, is the court was repeatedly told, do not connect the prosecution to committing crime.
I'll tell you what, I didn't hear that. I'm going to ask Kathy for the exact quote. If that's what was said, I'm going to sustain your objection, and I will apologize for overruling.
As the judge, I would also say, if that's not what was said, I'm going to descend upon you like an angry God in a land full of sinners for being whiny. Like that, there should be two ways on this. If you're right, great, but if you're wrong, you're going to pay.
Please, on that one issue, not everything else. What I said was, and I agree with what I said, but understand the context of it, okay? I didn't say this one perfect. I didn't say it yesterday, I didn't say it today. But one thing I said, and it was very confident, was the prosecution accepts their witness to perjury. What I mean by that is in regards to one thing, and it's indisputable, Your Honor. It was regarding Relli saying the tape was fake. The tape was fake. They got up, cross-examined Mr. Sajemi, did not ask him if the tape was fake or not, okay? They then put up transcripts of that tape recording with attributions to Mr. Ephron. So that means by that, just by that very fact, they accept the fact that he committed perjury. I'm not saying they support it, but they accept that witness committed perjury. They have to. Let me finish. There's no other way for them to move forward unless they say that wasn't perjury, but it was because he said that was fake. We know it wasn't fake. It was real. That was perjury. So by then moving forward with it, arguing that tape is important for the prosecution, that Ephron said these things, that when they cross-examined Mr. Jimmy, that wasn't being a good friend, Ephron made a tape. All that is doing is, I didn't say this is warranted, it's different. I would never say that, I didn't say it yesterday. What it is doing is accepting it, because they didn't say, we have an issue with witnesses in perjury. I said they accepted their witnesses committing perjury, that witness committing perjury on that one issue. That's very common, Your Honor. It's not inappropriate. It wasn't describing counsel. I didn't say Mr. Lewin. I just said they accepted, and that is true.
And that's a very good argument. That is a brilliant argument to make there. That is a brilliant argument. I had to have been a Marine drill instructor at some other point in another life, maybe. This is the same Lewin that prosecuted Robert Durst. Yes. Yes, chat. Yes, it is. So this is just ridiculous here. And real quick, we got 2 super chats. Jefferson says, I just looked in Massachusetts, says land, probate, housing, juvenile, etc. But the district courts can also handle those things. And that the way you guys do stuff out east is always a little different. The colonies are weird. The colonies are weird about that. And then Extremely Happy Simmer says, can you cover the Ohayokan versus Sekai Guild lawsuit? It's local to Ohio, and I'd love to see a lawyer's analysis. Well, welcome. I don't think I've seen you here before, so welcome to the channel. Let me Ohayokan. Ohayokan VSEIK Guild. Oh, the Ohaycon. It's a convention. Oh, and what are they? And they're suing somebody? Yeah, I could take a look at this. Can you email like potentially criminal at gmail.com? Can you give me some more information? Because I'm looking and I don't see anything about this right now. I don't see anything else about it right now. Is saying my idea of a brilliant argument is reading the transcript. No. Him pointing out that the prosecution is not contesting, like they gave tacit admissions that Relli was not telling the truth. That's the brilliant argument. The brilliant argument is being able to articulate, because they failed to show Relli was telling the truth, they're admitting he's lying. That's what I'm getting at there. So, Ohio, technically. Oh, okay. Yeah. Read Jade's comment above. Jade. It's Ohio, like Ohio, but good morning in Japanese. Ah, too weebified in Japan. Katie Nat Williams showed us that he falsely got someone convicted and took him to trial 6 times to throw Lewin away. Well, I know we're gonna get to the. I did see the comment about Lewin has been the Ninth Circuit Court of Appeals has determined that Lewin has on the record lied to juries before. So, let me see here. Sean totally skipped my milestone chat. Where's your milestone chat? Where's your? I don't even know what you're talking about. But yeah, we all know extort means demanding money. Yes. Carrie Morris's law office is permanently closed. Yeah, that could just be Google being goofy. Who knows? So, anyways, let's keep going here. Let's keep going. Thank you guys for those comments. Oh, suit alleges that SekiCon organizers, as former OhioCon staff, is appropriate comfortable. Okay. I'll take a look for this. This sounds interesting. Maybe I'll get invited to the con.
No other way around. It is not fair comment. It is completely unethical.
Well, I agree with you.
So, Your Honor,
I agree with you.
What's frightening is Mr. Takina just stood up here and basically defended.
He agrees with you. Why are you still talking? The judge agree. If the judge agrees with you, when the judge says, I agree, your next response should be, thank you, Your Honor. You don't keep going. I'm assuming he's gonna snatch defeat from the jaws of victory here. So,
And yeah, I said it, but I can say it. He doesn't know or care about the law. That is clear, right? Your Honor, when it's happened 25 times in this trial, with the hiding of evidence.
No, not yet.
With the late discovery, and with repeating, you told counsel before we started, do not disparage the other side. I said yesterday, you argue what you want about witnesses. You say a witness lied. You do not disparage counsel. You repeated it yesterday. He tried to explain how he didn't make mistakes yesterday, which he did. Now he gets up and he's now admitted, yes, I made that comment, here's why it's appropriate. Your Honor, it's not appropriate. It's completely unethical. It is immoral, and it's not professional. And again, Your Honor, the fact that he is getting up here and saying, "Yeah, I said it, here's why," just demonstrates again he doesn't know law or doesn't care.
You're disparaging him, right?
I'm disparaging him because, Your Honor, he's not following the
There
law.
is not to be any disparaging of either side.
During argument, the jury's not here. I have every right, obligation, and duty to stand up here and point out that he was being unethical. The first time the court catches me being unethical, Your Honor, the court knows that'd be the first time. Court knows I don't do that. Court knows first argument.
I've heard enough from both of you. I missed the prosecution accepts their witness committing perjury. I don't think that's fair comment on the evidence. I think that's an improper statement. It infers that the prosecution is allowing perjury to occur. I'm going to sustain your objection, and I'm going to apologize for overruling it, and then move on. If I were the two of you, I would just move on and not make bring it to the jury's attention. I would point out, though, I told you at the beginning of arguments that if an objection is made, I'm going to do my best to call it as I see it.
Real quick, Letty, how you doing? You mentioned yesterday too about the speaking objections, and I hope J-Rock kind of answered that question. I know I forgot to answer it. Typically, a speaking objection is you always have the right to say objection, Your Honor, hearsay, or objection, Your Honor, speculation. The speaking objection is then saying, Your Honor, that person has no idea what the witness is thinking. Your Honor, that person can't speculate as to an outcome they're not aware of. The speaking is where you're stating the actual reason why it should be objected. This extortion issue is that when all of this happened, Relli called ASAP, Relli called Rocky and said, give me $30 million and this goes away. And this is before he went to the police. He says, if you give me $30 million, I won't go to the police. So that's why they're considering extortion. And I think most people would consider it extortion. I totally think so. Like the average person would say, wow, you're shaking them down. So that's why they're considering it extortion. And I think that's a fair argument. The judge is saying, yes, in everybody's general parlance, this would be considered extortion. You're being ridiculous tonight, Mr. Lewin. So Yeah. So I hope that answers your question. You've been asking a lot of really good questions, so thank you for participating in chat. And guys, that goes for all of you. If you're new, I appreciate any questions you want to ask. There's no such thing as a dumb question. If I see it, I'll try to highlight it. I mean, if you do a super chat, it's guaranteed. But otherwise, I will try to highlight them when I see them. So, Bella's saying, now I see why the defense brought up they didn't object. Yeah. I mean, sometimes that's a tactic where you say, look, I haven't done it. Although the courts I'm in front of, they'd say, well, that's your fault. So, yes, Tacopina was tactical with his objections there. So, Kia Patrick saying, is it ever, if another lawyer thinks their partner's getting too hot under the collar, is it appropriate to say, hey, man, we need to go outside for a second? Yeah. That's the thing here. I know there's the two prosecutors. There's obviously the guy sitting down here, and then there's Lewin. Obviously this guy's the senior. He's the one in command. He's the sergeant. This guy's the private. So one of them's in charge, one of them's not. And I get that. But yes, if I'm the other dude, I would be tapping on his shoulder. I'd be like tap, 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 and I'd be like, Your Honor, may we have 5 minutes? And I would say we need to go to a room in the courthouse and we need to chill the fuck out for a second. Because this is not going well. Although, to be fair, this guy is in a situation where Lewin is very high up in that office. Probably, both these guys are going to be fairly high up in their office. But Lewin's going to have a lot of rank. And you got to be careful about how you do stuff in an office like this. It's going to be very political. But yes, somebody needs to have pulled him to the side and told him, you need to find Jesus right now, Lewin. You need to learn how to, you need Kalmite. You need Kalmite in your life. Somebody needs to give him a bottle of freaking melatonin and be like, take this before we start the next, take this at lunch. Because he is already losing his mind. And this is not pretty. And, people are upset at Tacopina as well. I'm not. Tacopina has every right to battle back. This is entirely the prosecution just losing their shit. So, no, calmate, not kumate. Calmate, calm, tranquilo. Oh, and Kat Williams with 5 subs doing her part, chat, to make this chat green. Grays, your days are numbered. We're going to come for you. We're going to take your teeth out. Just yank, yank, yank with this. You got nowhere to go. You got nowhere to go. You got nowhere to run. Oh, hold on. What's that? Did you say something? Oh, you're yelling at the dogs? Okay. See, chat's Valentine's Day, day 11. She's yelling at the dogs here. Okay. So I will do that there. Can we really pray the gray away? Yes, we can. We will pray the gray away. Sweet Bovine says tranquilo. I thought that was like how you say in Spanish, tranquil. Are you a fan of Tetsuya Naito and Los Ingobernales de Japón? No. Not sure what you're getting at there. Sorry, that's like over my head. So. All right. So let's keep going here. Let's see how this goes. Let's see how this goes here, chat.
You have made 17 objections. I have overruled 12. I have sustained 5. I'm doing the best I can. I will continue to do the best I can, and that's all I can say.
I just want to put on the record that, these remarks about being unethical is not just about everything.
I thought he was going to whip his, he's standing up. He's like, I'm going to pull my balls out right now. You guys think you're in charge? I'm the judge. I got the biggest, hairiest balls in the group. Tacopina just said, I'm sick of it. Here we go. Oh, God, this is going to get good.
Arguments that if an objection is made, I'm going to do my best to call it as I see it. You have made 17 objections. I have overruled 12. I have sustained 5. I'm doing the best I can. I will continue to do the best I can, and that's all I can say.
I just want to put on the record that, these remarks about being unethical, it's not just about everything. This from a lawyer who, and I just say this on it, this from a lawyer who asked in front of a jury for a stipulation that a shooting range was not in California, when either he knew it was in California or had no idea that it was in California. Okay, so he literally asked for a stipulation in front of a jury that he knew was not true or didn't know if it was true, and that's unethical. That's unethical. And this is a guy who, the Ninth Circuit just said lied to a jury in the Brantford case.
Your Honor,
So I don't care about him.
one more thing out of him, and we air everything that's happened in this case, which the court's aware of.
Stop.
He might want to stop.
I'm so correct.
You should be.
Ah! Look, he's walking. You should be scared. Oh, shut the fuck. Like, look at him. I know Tacopina wouldn't do it. I'd love to see Tacopina punch him in the face. You should be scared. Oh, fuck you. Fuck you, Lewin. Fuck you. Look at this guy. You shouldn't be scared. Stop making fun of me. Stop pointing out I got caught lying to a jury. No. Like, seriously, bro. Seriously. You should be scared. The judge needs to control this. This is getting ridiculous.
One more thing out of him, and we air everything that's happened in this case, which the court's aware of. Stop. He might want to stop.
I'm so correct.
You should be, Joe.
Oh,
Let's take a break.
You should be.
Oh, wow. I need to see him do that impotent strut in normal time. This is good, chat. We're going to go back here.
Yeah, it was true. And that's unethical. That's unethical. And this is a guy who, the Ninth Circuit just said lied to a jury in the Brantford case.
Your Honor,
So I don't care about him.
one more thing out of him, and we air everything that's happened in this case, which
Now, see, here's the big thing. If I'm the judge, I would have looked at Lewin and said, who the hell are you to decide what's going to get aired and what's not? I'm still the judge. You don't get to decide what comes in. I do. Judge Arnold here is kind of like letting some Binger like activity go on here. He's letting this guy run wild and he's not stopping him. This is fatherless behavior and it should be addressed.
the court's aware of.
Stop.
He might want to stop.
I'm so correct.
You should be, Joe.
Oh,
Let's take a break.
You should be.
don't tell the courts that told me I was a liar.
Oh my God. No courts of appeal has ever called me a liar. Woo! Oh God, that's a burn. That is a burn, chat. Oh. Suffer, prosecutor. Suffer. Oh. Yeah, Taco should have just said my dick ain't gonna suck itself. Come over here, Lewin. Oh. Yeah, these are the people that we trust him with power. And I am not confident that Lewin acts in a competent and professional manner as he prosecutes cases. If this is how he gets fired up, I have concerns for his fitness. This was disgusting. That was a vulgar display of power from an agent of the state. And that shouldn't be accepted. There's no reason to accept that conduct from a prosecutor right now. And, Lewin knows that. He should be ashamed of what he just did there. Yes, those were weak manlets. Weak manlets. He just threatened the judge. You should be scared. No, he was threatening Tacopina. He was not threatening the judge. This judge called him a liar too. Yes. I'm from California. I don't trust anyone with a suit, badge, or a robe. Brittany says, "Is this guy elected?" No, he's not he's not the district attorney. He's an assistant. So, yeah. Yamal is saying, yes, Lewin cried out against George Gascon because he, didn't do what he wanted. So, yeah, guys like Lewin are George Gascon happened. So, but yeah, that was disgusting from Lewin. Once again, guys, remember, one of them's the state, one of them's the defense. One of them is expected to act a certain way. But this was just disgusting. That was disgusting display of action by Lewin.
I'm so scared of you.
Stop it!
Tacopina's like, I'm so scared of you. Like, I think that's perfect. No, like, Lewin needs to get told that. Buddy, nobody's scared of you. That needs to happen. Like, homie, you don't scare anyone. That should happen. That should, like Tacopina needs to just laugh at him and say, buddy, nobody's scared. The lunch lady ain't scared of you. Like, that should happen like that. That's perfectly acceptable.
That was easy.
Here's a whole mistake, and I made a mistake, and I'm gonna tell you
All right, Chad, here we go.
what the mistake was.
We're going to speed back up now.
Mr. Tacopina mentioned, and I missed this, the prosecution accepts their witness committing perjury. I missed that. There was an objection. I overruled it. I didn't hear the whole statement. I'm not accusing anybody of doing it proper, but that statement puts the prosecutors in an unfair light. And that was improper. I overruled the objection. I should have sustained it. I don't want any side being disparaged or being put in a false one. So I made that mistake. I own it. I apologize.
Oh, Chad, hold on. What happened here? Why did it stop? Sorry.
Two things. One, I realized something. I said before that Mr. Ephron said he'd seen the video previously when he said there were 2 shots. What I was talking about was when he was speaking to Wally. He had already seen the video. This was obviously after Rocky's arrest and after the civil suit was filed. So I wasn't suggesting he saw the video when he went to the police on November 8th, in case that came out unclear. I hope I'm supposed to do this. Anyway, now we're back on the Wally's Jenny case. Look, all I'm saying is this. Their witness said those are fake. They played it as if they were real. So,
Okay, chat, remember that whole discussion we just had, the fighting, that was all outside the presence of the jury. The jury would not be present for any of that.
whatever that means. But here, I'm going to go back to the crux of the Wally's Jenny case, what we were allowed to play because they impeached the testimony of Ephron. And what I argued to you, and I'll say again, is the only crime that was proven here was Relli's extortion. He heard from his own mouth. And he boasted in this agenda that he was getting $30 million. He said, I already know I'm getting 30 M's. And I told you at the beginning of this case, I said in the opening, that there would be clear evidence of extortion and furious.
You know what I'm saying? That's what back when I was waiting for extortion. You feel me? You're gonna have to deal with that and his political ties and everything else. Because once I walk away, when I get my ties, the case gets way deeper. It's just like a domestic violence case. If you were to hit your bitch and your bitch wasn't keep on going through with the situation, you're going down. But if you're not there, then you're going against the state and it's way deeper.
Stop for a second, pause for a second. You know, what he's saying is obviously he's going to trade his cash for the case, some criminal case. So he'll get his cash and he'll disappear. The example he uses, the analogy he uses, is disgusting. Of course, that's who Terell Ephron is about a domestic violence case. And he references hitting. He's such a bitch, but that's how his mind thinks. That's his example that he could come up with. But it's really just supposed to show who he is and how despicable he is. And that was the example he gave. But what he's saying here is, get my cash, I'm gone. Get that. Play the next one, please.
If I'm not there, if he paid me out via through my lawsuit, I'll walk away. Basically, it's gonna be hard to be in front of me because I'm on another highway. Just relax. You get what I'm saying? They're gonna be scrambling to find me because now they have to go against Rocky, the state. And here they have evidence in saying that it's not gonna be the same when you present it to a jury and you don't have a complaining witness.
That's it. In, set, and match. That's extortion. That's him trying to sell a criminal case for $30 million. That he will go to an island, be relaxing, if he gets his money. Too bad for them. They'll have to go look for him. They have to find him. Imagine poor Detective Flores having to go search around for Terell Ephron on an island sipping pina coladas somewhere for his $30 million. That's it. That's evidence of extortion. It's his mindset. Doesn't care about this. He just wants money. And you're his vehicle. The only reason, and by the way, this transcript's a little tough to read, I think, but you'll have to go back with you and you'll have the transcripts. But again, remember, the only reason he's not on some island somewhere relaxing, and we're all here in this courtroom, is because Rocky refused to give victim his extortion defense. It's that simple. And that's why he's using this trial, really, using these prosecutors. Now he's trying to use you to get him his money. Because he knows that a conviction here will get him what he really wants in this case. That's it. This isn't about justice for him. It's about a payout and a payback. The last quote of some of the greats in our history, using some words for founding fathers, Thomas Jefferson, said the major trend is the bitterest of foes. So that comes here, life and color. Less than any questions about his true intentions, consider this. He sent an article, you heard this testimony, to Wally Sejek on December 24th, 2024, just before this trial started, entitled, Rihanna Fears Heartbreaking Consequence of APRocky Trial. And he sent it with a smiley face. A smiley face. This parasite is happy. If he can hurt that family, that woman, and her family, I send a smiley face. Like, that's funny. That's funny. Because she fears the heartbreaking consequence of the trial. So he doesn't care about the trial. He just wants his money. He wants to be an idle relaxing. And he's laughing and mocking what he can do to Rihanna family. And he needs you to get that done. The gentleman, prosecution has not proven this case not about one child. It's not even this literally. I'm not telling you what to do. It's you find it for. You take as much time as you need. I'm not trying to impede on your province. The only thing proven beyond reasonable doubt is that this Relli is the most pathological liar, a perjurer, and extortionist. That's proven beyond reasonable doubt. And they know that. They know that because they asked Nick Flores the question that I just never heard. I used to be a prosecutor. It was a question that they asked.
That's improper argument.
Which one? Which one?
They know it's urgent. You used to be a prosecutor, Your Honor. It's not part of the evidence.
Wait, what was the statement?
What?
I'm sorry, what was the statement? Sorry. What was the statement? I think. What part?
They know it's urgent.
I didn't say they knew. I didn't say they. I said what was proven beyond reasonable doubt. Because he's that level. I didn't say they knew. I understand court's rulings.
Yeah, we object regarding discussions between the prosecutors.
Okay. All right. So anyway, what they know, they asked Detective Flores this question. Would you agree, Detective Flores, that you don't need Mr. Ephron's truthful testimony to establish a shooting occurred? Well, first of all, you do need it. You do. Remember, after breaking it down with Detective Flores, he made it clear to you that nothing without him broke down him. I'll show you that transcript in a second. So you definitely need him, but he's just not credible. Why the heck do you think they asked that question? I mean, think about what that question screams out to you in the jury. We don't expect you to believe him, ladies and gentlemen, but it's okay. It's still true. No, it's not okay. No, it's not okay. If you had to make a decision, the most important in your life or that of your family is on his work, would you do it? Terell Ephron's work, would you do it? You all have answered that question.
And chat, that is a critical thing you do when you have a very sketchy witness come in. You have to say the most critical life decisions. Relli is going to sell you a car. Relli's your neighbor, man. Hey, you want to buy my car? It's a good car. Would you trust Relli? No way in hell. Would you trust Relli for a doctor's recommendation? Absolutely freaking not. So that's what he's going at. You would not trust Relli for a dog grooming reference for a dog groomer. So that's the point here. Relli is not trustworthy in any way. You would never trust him in your normal life.
What you're being asked to do is make that decision. The most important matter in his life. On his work. Please look at the evidence carefully. Please evaluate it cautiously.
Hey, David.
There's not proof beyond reason without. Rakim Mayers is innocent. It's not only not that he's innocent. An innocent man's on trial with absolutely no concrete evidence.
Hey, Gosney fans. Hello.
At all. Close to innocent. It's not the way this man will face the certain. Because there's absolutely no evidence of shooting. And that heavy burden should not be yours to have to live with. On this evidence, it should not be. It's not right, it's not fair. They ask you to do what the evidence won't, condemn this man. And by the way, remember this in your instructions, circumstantial evidence. If the evidence points to both guilt and innocence, you must, there's no option here, you must side with innocence. If there's two interpretations of the evidence, guilt or innocence, you must side with innocence. That's what the law is, Judge. It's in your little books. Jury instructions. You must, it's not an option. Terell Ephron, I mean, what kind of system, seriously, folks, do we have if this kind of witness can convict someone and destroy their life? With all you know about it at this point. I've talked about there not being any forensic evidence in this case, no fingerprints, no DNA, there's none. No independent evidence outside of Terell Ephron. And ladies and gentlemen, the judge told you it only takes one lie under oath to throw this case out of court by you, if you choose, your decision. But just one lie. It's justification for you to say, I disregard all this testimony. You can't even count the number of lies he told under oath in this case. You can't. He lied directly, lied to your face. He lied under oath over and over. He exaggerated. He gave around answers to try and avoid questions. He verbally assaulted me. He cursed in the courtroom. He threw a water bottle. Blessed his muscles. He said he had enough. He was going to leave. How many does it take for you to know that this case is a fraud? To use Relli's own words, Relli's a fake. And he's just trying to profit off extorting case equity. He's just waiting for one thing. River. But he's got it. And if they come up and say, well, Relli's not on trial, that thought crosses your mind. It's true, he's not on trial, but he should be. He should be. Perjury, extortion. But he's not on trial. But what is on trial is his credibility. His credibility is on trial. And that you have to assess, and you get to assess, you must assess. Trial rises and falls on his word. With that in mind, again, I ask, what kind of system do we have based on the word of that man? That man. With all you know about him. The issue in this case is the life, future, and liberty of Rakim. And that's what will be placed in your hands very shortly. And the question I have you before you first said, do you believe Terell Ephron beyond a reasonable doubt? Let me keep saying that because it's really what we need to discuss, is beyond a reasonable doubt or not. If you don't, Rakim has to go home. He has to. Submit upon this testimony you've heard, the perjury you've witnessed, the lies you've seen, the destruction of a piece of evidence you've observed, the fabrication of others, Mr. Ephron's trustworthiness. There's no way in the world that you can find that he's trustworthy beyond reasonable doubt. There's no way. On the important issues in this case. So let's see, I got it. He lied about the important issues. And if you can't do that, if anything they said to you, if anything they presented to you, caused you to pause or wonder what really happened, if you have a doubt, a reasonable doubt, Rakim must be acquitted. He must be. That's our legal system. You just witnessed extortion demands, threats, trial, the lies, the hiding of evidence, the line about being in Los Angeles 2 weeks before, since I know those shell casings, on and on and on. And if you think he was lying about these important issues, prosecution's case fails. Fails. So it's very simple, ladies and gentlemen. If you cannot believe Terell Ephron beyond reasonable doubt, he must be acquitted. That's the law. A defendant in a criminal case is presumed innocent until the contrary is proved. In this case, it's not been proved. In the case of reasonable doubt, whether guilt is satisfactorily shown through the evidence, and the presumption placed upon the people that heavy burden of proving guilt beyond reasonable doubt. And why is that standard called beyond reasonable doubt? Why? Look, there are many, I just want to give you some sort of knowledge on this, but there are many legal systems around the world who don't have this proof beyond reasonable doubt standard. They don't use juries, they use judges 1, 2, 3, sometimes 4. But our country has philosophy, and that is we cannot convict people who are innocent. We cannot ruin their lives because what happens is so harmful, devastating, brutal, based on anything but the strongest evidence. And what is being attempted here? It's so harmful, so brutal, so potentially devastating to him. That's why it's such a high standard. Standard is higher than what you find in civil cases when you have disputes over money or property. If you have a reasonable doubt about this case, about the testimony, about the double talk, about the lies, the perjury, the manipulation of evidence, the destruction of evidence, Ephron's motives, it's over. It's over. You must acquit Rakim. According to the law, is that true? Our system isn't perfect. We saw examples of people who were convicted in DNA that exonerates them because well-meaning juries didn't have evidence.
It's an improper argument.
So you have those impervials, it's like 250 less, and there's nothing to do with this case, right? But it's by George meant well, and they were subsequently exonerated by DNA evidence. Nonetheless, we have a system, and it's the best system in the world. It's the best system in the world here. You can't be perfect because human beings aren't perfect. But I'm begging you to honor that principle. Honor that principle of proof beyond reasonable doubt. Rakim must be acquitted under that standard with all the problems of falsehoods and the issues we've addressed. They cannot overcome them. They cannot overcome them. They can exaggerate. They can invert. They can mock terminology of our witnesses. They can be sarcastic, repeating their unimpeached testimony. They do whatever they want. They can't do this case beyond reasonable doubt. This case never should be brought to begin with, based on Terell Ephron, what they're going through he was. These are what we call burdens of proof in our legal system. In a civil case, again, which is dispute over money property, the one side that proves hundreds of the evidence, that's standard. They get the burden. Okay? And it's often described in very simple terms. If you have a scale of justice, if it just goes 51% to 49% in favor of one party, they win. That's a civil case. That's what the ponderance of the evidence. That's enough to bankrupt somebody. That's enough to take away the business, leave them penniless. It is not enough to convict them of crime. There's even a higher standard than that law called clear and convincing evidence. And clear and convincing evidence, for example, in custody disputes, for example, where the custody of a child is at stake. Clear and convincing evidence in some custody disputes, you can take a child away from a parent if you prove by clear and convincing evidence that that parent should not have custody.
Hi, Hella. You could join if you
They have
like.
not met the standard for the legal system requires a parent. Clear and convincing evidence. Clear and convincing evidence alone is not enough to convict someone of a crime in the legal system.
Okay. All right. Here's the thing. I'm a little offended because I would hope if me and Nick had a baby, it would have my swarthy, thick, luscious Italian hair, not his wiry Polish, Scandinavian prude, Talmudic hair. No, it would have that thick hair. Takapina, for being for a fellow WAP, he's got some thinning hair, and I'm a little concerned how that's happening. But whatever. So I'm just saying, I would hope my kid had thicker hair than this. I hope we'd have thicker hair. Stop whining. It's a fucking joke, honey. If you're going to make jokes, I can make jokes. Jesus.
Let me ask you this. Do you think you've seen clear and convincing evidence in this case that Terell Ephron is truthful, that he's believable, that he's honest, that he's honorable, that does not have financial motive in this case, that is to be believed and trusted? They can't even meet the clear and convincing standard, let alone the highest standard in our legal system, which is beyond a reasonable doubt. It's not even close. To further explain beyond a reasonable doubt, the judge gave some great examples in his preliminary instructions and how high that standard is. If you think someone may be guilty, that's not enough. If you think perhaps they're guilty, that's not enough. If you suspect they might be guilty, that's not enough. Possibly guilty, it's not enough. Probably guilty, not enough. Guilty likely, not enough. Guilty highly likely, not enough. It has to be guilty beyond a reasonable doubt. Ladies and gentlemen, when you get into that jury room, ask yourself, do we have a reasonable doubt about Terell Ephron in this case? Any. Because all it takes is one. Just one. Just one. You have 100. All it takes is one. Look, my time is almost up. I want to apologize to you at the end of the night that this journey is taken. But you're seeking justice that really want to show us. If you trade desperately, you want to fight hard and vigorously, especially if it was for a person who's maintained their innocence from the get-go, from day one. And I hope and I trust that you all stand that in a journey towards justice that there are no shortcuts.
Yes, 1.3 speed.
See now. They have to right away for lunch, I think, maybe now. The prosecution will go again for another submission, for rebuttal submission. We had this one opportunity to address you, but they have to start heavy burden, so they go first and last. They will seek to rebut, which I brought up.
We'll be here all night otherwise.
They won't be back up here talking about all sorts of new things, or they'll face objection. But they have to seek to rebut what's being argued right now. And let me tell you up front, I'm loath to object during someone else's argument. I won't do this. I can do it once before. I'm trying to do it. But if something new is brought up, it may be important. Let me tell you also this. If he brings up anything new, you may be precluded from standing up again and saying, wait a minute, here's an answer to that. Wait a minute, ladies and gentlemen, you have an answer. But you can substitute your common sense. You all can substitute your common sense. Your judgment in that place, and that's required for this jury. In the Supreme Court of Justice, you can substitute your common sense. You will respond for it. It's not out loud, don't do that. You can respond. I'd like to remind you of something, Judge Arnold told you. By the way, before I do that, I just want to also tell you that we're all very fortunate to have in this judge. I've been before many, many judges. His patience with us in particular, his humility, he's an inspiring role model for what a judge should be. So you're all very lucky in this world. I feel it. Anyway, his Honor told you in the beginning that Mr. Liu will have the opportunity, the prosecution, Mr. Liu will have the opportunity to sum up last. It's not because I lost the pointless. It's not because of that. At the beginning of this thing. It's because that's the rules. They have the very heavy burden, and those rules satisfy the state. So because they have the heavy burden of proving someone guilty beyond reasonable doubt, they go last, and that's a burden that never shifts to us. We have no burden. When a prosecutor has a particularly weak case like this, which stands or falls on evidence not worthy of belief, they always make some sort of pitch like, oh, the witnesses are on trial. I defy them to get up here and convince you that the evidence shows beyond a reasonable doubt that Rocky didn't act in self-defense, or defense of another, or that Star pistol was a real thing, beyond reasonable doubt. I defy them to explain to you why. Watch for acts of defense, watch for questions posed by him, knowing we're not allowed to respond. The law says you can't respond for me. Another thing I'm going to pose to them right now. Remember yesterday I was telling you about this issue regarding cartridges from a prop gun. Because you heard about prop gun, can't eject, does eject, some sort of a casing. And I said to you, there's absolutely no evidence whatsoever regarding what blank casing from a prop gun looked like. You heard evidence that from Blue Evidence, the only one that says about it. There's paper and plastic in a prop gun bullet, so to speak. There's no evidence of how far or what direction they would be ejected to from the prop gun, whether it would still be intact or not. Be split open. There's no evidence of that in this record at all. And certainly, there's no evidence that they would look anything like something that would be absorbed by things like those silver, shiny, metallic casings from a real firearm. No evidence whatsoever. I was told yesterday there was an objection. I was told I was missing the evidence. I then said, first of all, I don't mistake the evidence, and I challenged the prosecution. Okay, if I'm mistaking the evidence today, when they get up, show the jury.
Your Honor, this is improper argument.
If I mistake the evidence, show the jury when we stand up. If I mistake the evidence, show them the evidence in this record that cartridges from a pop gun are metal or metallic or anything. Anything. There's no evidence in the record at all. So let me state the evidence. They could punish her. Now, it comes a time for me now to conclude my remarks, and I may never have another opportunity to speak to you again, certainly not this second, maybe when the case is over. And you've been told many, many times there are very heavy burdens based upon the prosecution of people for good reasons. Prove this case beyond reasonable doubt. And as such, it is Steward's duty to answer for you as best it can any legitimate questions arising from the evidence which we believe is cast out on Rocky's guilt. There may be 1,000 such questions in a case like this, which we could put to them, but we intend no such exercise. We'll be here until the summer. I do think after careful deliberation, that it might be fair to suggest 10 questions that literally hang in the air in this courtroom at this very moment. And as the time approaches for you to decide this case, I'll also hand it on to you as well. I offer these questions now as the most important challenge to the prosecution. Prosecution claim it's met its burden in this case. They claim that. Well, if the burden has in fact been met, then you'll be given logical, sensible, credible, satisfying answers to each of these 10 questions. On the other hand, the questions are overwhelming or unanswerable. Those questions will be ignored, or you'll be told that the prosecution has no obligation to answer our questions. If you're giving anything less than complete, sensible, satisfactory responses to these 10 questions, beyond a reasonable doubt, you'll quickly realize that the case is transparent and false, We prove real hard things for you, things you can see, things you can take back to the jury room. And that is you have to find it, Rocky not doing. And when I'm concluded, and for Mr. Lewin's convenience, I should decide to deal with these very troublesome questions. I'm going to leave him the written list up here of questions when I conclude. I'm going to show you those 10 questions today. Let me go over them with you one by one. Very briefly. Question number 1. Other than Relli's word, what evidence is there that he photographed shell casings at the scene? Okay, there is none. We know that. Because even though they have photographs from his phone, they didn't get the metadata to show where those photos were taken. We also know they think that his GPS location at 11:45 had shown where he was when he took those photos. Number two, other than Relli's word, what evidence is there that the shell casings even came from the scene? No evidence other than his word. Willie Parker's not here. Let's talk about the metadata and the GPS location. Third question I asked him to answer. Other than Relli's word, what evidence is there that he even went back to the scene? Because now we know he swears that at 11:09, that's not him. That's not him anymore. And there is no video of him going back to the scene. So now we're left with his word again. Because they didn't have Bill's GPS location, but not Relli's. Number four. Other than Relli's word, what evidence is there that he ever left Los Angeles after going to the shooting range, shooting off 9mm, by the way, 2 weeks before the incident? Again, it's just his word that he left Los Angeles 2 weeks before. So he took flight, and he took flight back. That would have been a very easy one to prove. But we just have his word. Number five. Other than Relli's word, what evidence is there that the scrapes on his knuckles were punch-out wounds? He didn't have time on that. Number six. Other than Relli's word, what evidence is there that a conversation ever happened on November 5th, to set the tone for November 6th, between ASAP Bari and Rocky? Other than his word, there was no ASAP Bari, no phone records, so we just have to take Relli's word that happened. Number seven. In light of Lou Levin's testimony, in light of Lou Levin and Twelby's unimpeached testimony, other than Relli's word, what evidence is there that Rocky did not carry from him? Other than Relli's word? There's none. No evidence of shooting. Nothing from either video says that's not a problem. None. Number eight. Other than Relli's word, what evidence is there that he was shot by an operable semi-automatic firearm? Again, other than his word, no evidence whatsoever. Number nine, this one's my personal favorite. Number nine. How is it that you do not need Relli's truthful testimony from that question to establish a shooting occurred when Detective Flores told you, A, the parking garage video does not show an operable gun? That's his testimony. So let me break it down this way. Video one alone, you don't know if the gun's operable. Correct? Correct. B, the video from 1616 BCLR does not show if there's any gun at all. To answer that was specifically just looking at that and not looking at anything else? No. Well, that's the video. Just looking at that? No. And C, the sound heard on the video from 6200 Hollywood Boulevard may have come from a replica firearm or two, Detective Flores. So, no evidence of an operable gun in one video. No evidence of the gun at all or any shooting in the second video. And the pop, according to that case, detective could have come from a replica. So, do you need Relli's testimony? Because if you just don't have it, if you take it out, like was suggested in that question, Detective Flores told you there's no evidence. No evidence that there was a shooting or an operable firearm. And number 10, given that Relli told you he can lie whenever he wants, you saw him commit perjury multiple times. Relli told you he will commit perjury when he doesn't want to answer a question. How can you trust Relli with a matter of importance in your life, the life of a loved one, or the life you sit in judgment of? I don't know how they answer those questions. They can't. I believe these 10 questions right here. We'll see if you get answers. I don't think so. You have the capacity to transform his very dark 3.5 years into a bright tomorrow. You have that capacity. You have the power in your hands. It's up to you now. You're going to pass the baton to you now, or very soon anyway. And you will do the right thing, I'm sure. You made that commitment for justice. You'll do the right thing. I will go someday on other cases.
It should have been done 20 minutes ago. Way too long.
No doubt, Mr. Lewin, Mr. Siegel, this moment has happened. We will, the jar will try another case someday. But this is Rocky's one-day quote. By your decision, you control this very life of hands. Treat it fairly. Treat it fairly. Be fair. Do the right thing. Remember the testimony of Terell Ephron and ask yourselves if you would trust them with any matter of importance in your life. And if the answer is no, you can't. Trust them with a matter of importance in his life. Case rises and falls just so it. all you can do is try and get about these like that. Imagine living under despicable accusation 3.5 years. Facing what he's facing, knowing he didn't do a thing wrong. It's been my privilege, my absolute privilege, and honor to represent someone that I admire as much as. And I thank his amazing family for putting trust in me. You ask questions, jury selection. If you had a doubt, would you have any problem saying not guilty? Would you have the courage to say not guilty? Did you have the mental fortitude to walk back into the courtroom and fail to prove guilty? You had the courage to walk back in here and say, I'm not guilty. You all said you could do that. You all said it. That's why you were here. That's why it sits in you are here.
I am too.
You know, that's part of your job. You said you could do it. I'm going to hold you to that. I hope you hold yourself to it. That's what makes this system great. Your courage, your willingness to stand up for what's right. Look, this courtroom says Mark S. Arnold, judge. He's the judge. Judge Arnold's courtroom. But when it comes to the facts in this case, it's your court. When it comes to what's right in this case, it's your court. When it comes to what's fair in this case, it's your court. No one think that. This is your court right now. I'm going to tell you something. What happened here is a pretty. Think about that. What's the message we're going to be sent out? That proof like this is not to convict one of us, one of our citizens. None of us have a chance. Ladies and gentlemen, thank you for your patience. Thank you.
Right now, folks, please be outside the courtroom at 1 o'clock, at which time we will hear.
God, that was way too long. That was way too long, Takapina. You had a chance and you just kept it going. He pulled a Trump. You got to land the plane. You have to land the plane at some point. And I get it. You've only got one shot at the jury. They get another shot. You're trying to make sure you fill in all the gaps. But you got to land a plane sometimes. You're going to leave a door open. It just happens. It just happens. Is he delivering a closing or auditioning for an SVU spinoff? Guys, it's theater. It's sales. It's theater. You're selling stories. You have to do that. It's the thing. It's the thing. You also said my chat was digitally modified before being displayed on the screen. Yes. J-Rock says, even the best surgeon can make one too many cuts. Yeah. You got to know when you got to leave good enough alone. Got to know when to leave good enough alone. Let's see. Trump once says, can the prosecutor's actions be cause for an appeal? If he said things in front of the jury, yes, but ultimately if he's saying stuff outside the jury's presence, not too much, not as much as you think, not as much as you think. Keopathic says, I've never been threatened because they know I hide knives outside the courthouse. Yeah. And then Tridio, it's good to see you, man. It says ASAP Rocky is more like on time in comparison to everyone else in my tribe, Rocky. And then Shredder S07 is saying, check out the Tammy King murder in Tejas. Her granddaughter and boyfriend are charged with first-degree murder. They stole guns and tried to sell them. That's a common thing. Don't be careful when you murder people. What you try to fence, chat. Be careful what you try to fence. That's just my advice. So that's the free advice. Y'all are gonna fall asleep when Lewin speaks. Yeah. So the guy who's been crying the whole time for the prosecutor's office is gonna do the rebuttal. So here we go, chat. Here we go. Hold on to your butts. It's time. It's gonna be time. Okay, so we got the 319 till I mean, is he really gonna go for 2 hours here? Is he really gonna go for 2 hours? Oh my god, we're gonna die, chat. We're gonna die. Why does he not control it? You do not need multi-hour rebuttals. Oh my god, chat, I'm so sorry. I'm so sorry. But let's start. Let's start.
And this trial.
All right, chat.
Parties adjourned.
Here we go.
Are present. Mr. Lewin, are you ready?
Yes, sir, Your Honor.
Floor is yours.
Good afternoon, everybody. Over lunch, I had a nightmare that when I was going to come back up here, that Mr. Packard was only half done. I think, I'm not sure, but I believe I had a birthday and at least one grandchild during that closing. And I bring that up for a specific reason, and that is, do not confuse the length of that argument with the persuasiveness of it. What we kind of have gotten away from is why we're here. So this is the case of People versus Rakim Mayers. This is not People versus Mr. Ephron. It's not People versus John Lewin. It's People versus Rakim Mayers. And the reason that I point that out is because if you didn't know better and you listened to the closing, you would think that either Relli was on trial, maybe I was on trial, and we're not on trial. And I think it's important when you are listening and really going through these arguments that you understand what this case is about. And for that reason, I'd love to say that I'm going to be very brief up here.
Death by PowerPoint, chat. We're so fucked.
And the reason I'm not going to be is that, unfortunately, I've got an obligation to make sure that I address the points that defense counsel made. Whether those points are relevant, whether those points are persuasive. I can tell you this, I won't be as long as Mr. Packard was. And I'm confident that you will get the case today, this afternoon. But that's where we are. I want to start with, this is Randy's Donuts. This is Randy's Donuts. This is on the corner. You're looking at Randy's. This is in Inglewood.
We need to switch to something very quickly, chat. This is from the Fred Durst murder trial. I'm sorry, Robert Durst, not Fred Durst. This is from a trial that occurred during COVID. Robert Durst. You're going to see a voice and you're going to hear somebody. Just check it out.
As many of you, probably maybe all of you have noticed, I am not the thinnest guy in the world. I tend to be whatever prosecution team I'm on, I'm usually the heaviest. In this case, I got to be the oldest and the heaviest. And for many years, 25 years, that's been my enemy. Before it was famous, before anybody knew what Randy's Donuts was.
Okay, so this is in a trial. This is in a trial. And now we're going to go back to now he's talking about Randy's Donuts in this case. He's now, to be fair, as defense attorneys, I recycle stuff too, but this is just tacky here. Here we go. Chat, what do you mean it's muted? Like, you guys are screaming muted, muted, muted. Like, was I just muted now or no? Oh, shit. It's on. Oh, crap, chat. I'm sorry. It froze up. I'm sorry. I was listening to it here. This is. Sorry. I understand. I understand now. So, we're going to just. I forgot to switch over here. Here we go. And this is now where.
So this is the case of People versus Rakim Mayers. This is not People versus Mr. Ephron. It's not People versus John Lewin. It's People versus Rakim Mayers. And the reason that I point that out is because if you didn't know better and you listened to the closing, you would think that either Relli was on trial, maybe I was on trial, and we're not on trial. And I think it's important when you are.
But you are, though. You are on trial.
These arguments that you understand what this case is about. And for that reason, I'd love to say that I'm going to be very brief up here. And the reason I'm not going to is that, unfortunately, I've got an obligation to make sure that I address the points that defense counsel made. Whether those points are relevant, whether those points are persuasive. I can tell you this, I won't be as long as Mr. Capino was. And I'm confident that you will get the case today, this afternoon.
Spoiler alert, that's a lie. They will not get the case today.
But that's where we are. I want to start with, this is Randy's Donuts. This is Randy's Donuts. This is on the corner. You're looking at Randy's. This is in Inglewood, on the corner of basically Florence and, Manchester and Los Angeles. This is the exit from the 405. You come in, we're looking northbound. And 30 years ago, when I was a young deputy DA in Torrance, I used to drive from home, and I would have to take this route on the 405. And I would, every day, I would get off on the 405, and I would tell myself that if God wanted me to get a donut, he would make sure that the light that you can't see right here was red. As you can see, God wanted me to have a lot of donuts. I ended up most of the time, I stopped. But there came a time where it just wasn't good enough for me to take the chance on the light. So what I would do is, it's a really long straightaway, and you can see when you're getting off the freeway, you can see that light. So what I would do is literally, I would coast my car at 20 or 25 miles an hour, making sure that I hit the red, and then I could go in and I'd get that donut. And I bring this up because passing up that donut was extremely difficult for me. Very, very hard. And most days I wasn't able to do it. And I always thought that that's probably one of the hardest things that I would have to do. And then I became a trial lawyer. Then I started trying cases. Then I started trying serious cases. And I can tell you that what it takes to pass up that donut is nothing compared to what it's like when I have to sit here during a closing argument, the defense is up, and I have to listen. And I want to get up and I want to scream, I want to yell. I can't do it. I try to do different things, try to focus on something else.
How is this a permissible argument? This is highly improper. Saying, oh, I can't, like, basically he's disparaging defense counsel and shit. This is bullshit argument. He should not be allowed to do this.
Try to go to a little happy place. It's really, really hard. It's especially hard when, as in this case, Mr. Tacopina makes an argument. And I want to be clear about something. I'm going to attack the arguments that Mr. Tacopina made. Because that's what lawyers do. That's what's fair. I'm going to attack the arguments that he made. I'm going to attack the case that the defense put on.
That preamble was 100% improper. That was 100% improper. That should not be allowed.
I'm not going to attack Mr. Tacopina personally. I'm not going to cast aspersions on evidence that he put on. In the end, witnesses, we don't vouch for our witnesses, ladies and gentlemen. What that means is that we put on witnesses, and those witnesses testify.
You are vouching for your witnesses. If you thought they weren't trustworthy or they weren't credible and you put them up there, you are suborning perjury. You are vouching for your witnesses. If you didn't trust them or you didn't believe in them, they wouldn't be witnesses. I mean, because otherwise, you know they're lying. So you are vouching for them. If you put them up there, you are vouching for them.
What they're going to testify to. So I'm going to go through, and I'm going to very critically point out what this case is about and what it isn't about. And kind of before I get there, I want to talk a little bit about your role as jurors. So you 16 people, we started in what year? And I know many of you, probably most, maybe all of you, none of you wanted to be here. And I get it. It's understandable. But you were chosen. It wasn't simply magic that you ended up as jurors. Both sides chose you. And honestly, and one of the few things Mr. Patrick and I probably agree on is that in our country, it's an incredible honor to be able to be a juror, because in other countries, we don't have jury trials. We don't have any system of justice. But you were selected, and it literally is an honor. But along with that honor comes a duty and a responsibility. And I'm not going to understate it. I'm not going to pretend it's anything other than it's not. I will tell you, Mr. President and I, we have done our duty, our responsibility in putting on this case. We have given you a case, and we have proven it beyond a reasonable doubt. It's going to end up going into your hands, and I'm going to explain to you what the evidence demonstrates and what the verdict in the case should be. Some of you might be saying, wait a minute, I don't understand why we had a trial. Because let's face it, no matter how much the defense wants to talk about how this is all about Relli's credibility, it isn't. It's on video. What's amazing about this case is how little, in the end, Relli's credibility or anything that matters in the case is really an issue. Now, it certainly could have been an issue. There could have been a defense in this case. There could have been, where the defense put on evidence and they said, hey, listen, Relli, you can't see it, but Relli, when he came, had a weapon. And he said, I'm going to kill you. And the defendant at that point in time pulled a gun to defend himself. And the situation ended, and Relli followed. And he threatened again, and he pulled out another gun. And that would have been difficult for us to counter, not because it's true, but because the evidence that you would have been given would have been much more problematic, much more difficult. That's not the defense they chose. The defense they chose, and I'm going to get into this in a little more time and more detail, but I want to make sure you all
Apparently,
understand.
Tacopina doesn't like objecting, guys, so.
This case comes down to one issue and one issue only. They are saying it's a prop gun. If it's a prop gun, he is absolutely not guilty of the charges. Not because he didn't pull it, not because he didn't fire it, but because under the law, if it's not a real firearm, it's not a violation of Penal Code Section 245, and it's not personal use of a firearm. Now, here's what's interesting. Now, again, I'm going to explain this in more detail. Mr. Tacopina got up here and he says, absolutely, hey, listen, he did not have a real gun. It's a prop gun. But it's still self-defense. That's not true. If it is a prop gun, there is no self-defense. And the only way you can get to self-defense in this case is you have to find, one, that it was a real gun, which it clearly wasn't a real gun. There's no question there. It was a real gun. The prop gun is a figment of the defense and the witnesses who testified to it. You have to find that not only is it a real gun and that it was fired, but that the defendant was defending other individuals or himself, and that the force that he used was necessary. And ladies and gentlemen, he wasn't defending anybody else. The force was not necessary. It's a sad situation, and I'm going to confront this head on. It would be easy for you all as jurors to say, wait a minute, I don't get it. This is a guy who's got everything. He has everything. He's successful. He's got a beautiful wife. He's got 2 children who were here. And some of you might be saying, gosh, you know what? Why would he risk that? And that's a very good question. It's just not a question that is for you to consider. Because in the end, the issue is not why did he risk it? Why did he do what he did? Because what the evidence shows is that's what he did. This is also not, let me repeat, not about Relli and his civil suit. And let's talk about that for a moment. And let's talk about exactly what we are dealing with.
Except it is. It's part of it.
I want to move forward here. As I'm talking, again, some of you might say, hey, listen, Mr. Lewin, we've been listening to this case. Why are you even up here arguing? We get it. If I were in charge of courses, which I'm not, I would make an adjustment. And what would happen is there would be a scoreboard right on top of between where juror number 4 and juror number 5 is. And I can look up and I can see, okay, we're up 42-0. I can take a knee. I can run the clock out. But on that scoreboard, I have no idea what you 12 jurors are thinking. I have no idea. I have no idea if some of the crazy arguments by the defense, gosh, maybe somebody believes them. One of the most difficult, frustrating things that can happen is, and I try not to do this, but I will see jurors taking notes, writing things down at certain points where I'm thinking, oh my gosh, Why are they writing that? That doesn't make any sense. Of course, I don't know what you're writing. I have no idea. You could be writing down a point, you could be writing down, that doesn't make any sense at all. I have no idea. But here's what I do know. I've got an obligation to make sure that I address everything that the defense has brought up. Good points, bad points, irrelevant points, nonsensical points. I have to address it all because I don't know where each one of you are at. And the reason is pretty simple. There is no way that I can ask you 12 jurors to do your job if I haven't done mine. So that's kind of the background of where we find ourselves.
He literally just said some of you jurors might have retarded positions. He literally just said that some of you might have the wrong idea, might be completely in the weeds. I don't see how this guy is able to get convictions other than he gets people in there and say, oh, the defendant did it because he's the defendant. Being a prosecutor is easy mode, chat. You've already got the benefit of the doubt on your side. That's why you could do shit like what this guy does and you can get away with it. Shitty closing arguments and the jury buys it anyway.
All right, let's talk for a second about the defense closing argument. I think it's important. So what they've done.
The whole thing's been improper.
Relli, in a lot of ways, was a very problematic victim. Why is he problematic? Well, one, in a lot of ways, he's not very sympathetic. And I'm not here to get you to like Relli, to get you to say, you know what, Relli deserves $30 million. Because unlike what Mr. Takafuna said, you're not here to decide that. You are not here. I'm not Relli's lawyer, and you're not the jury who's going to decide what damages he's going to get. Evidence to show he has a civil suit. You're aware of that. I'm not telling you anything that's not a part of the evidence. And if that civil suit goes to trial, as you all know, there will be a jury that will decide what anything he gets. That is not E12. I don't mean to shortchange you alternates. Being alternates is really, I'm not going to lie, it's a crummy job. You get to sit through everything, and then you don't get to vote. I think I said this on Body. I would have held my hand up and said I cannot be an alternate. I can't do it. I need to be able to vote. So when I say U12, I really mean U16. You never know who's going to end up on a jury. But what is important to keep in mind is that you're not here representing Relli. But you know what I do want to explain? I want to explain for a second what happened with Relli and who he is and what he's been through. And I think it's really important, and this kind of goes to what the defense is in this case. This is a picture that if you look at it, it's pretty blurry, okay? You can't see what's going on. Why is that? Because what the defense wants to do is they want to zoom up so close on every irrelevant fact that you forget why we're even here. And what's an example now? I'll tell you right now. Mr. Takafuna spent time pointing out the fact that Relli was not honest about buying a property in Miami. Now you need to ask yourselves, what does his property in Miami have to do with what happened on November 6th? Nothing. But he would say, well, but wait a minute. If Relli is not being truthful about that, you don't have to believe about anything. I'm going to get to why that is not what the instructions actually direct you to. But I want to do something more. I want to do something better. I want to explain to you from the evidence why Relli was up there doing what he did. So let's first talk about the fact that Mr. Takafuna spent a lot of time talking about, hey, the defendant, he just sat there, he was dignified, he didn't make any fuss, etc.
Special guest chat, Clyde T-Dog.
The defendant is an extremely powerful
Special guest chat, Clyde T-Dog.
individual. His wife is even more powerful. Relli found himself in a situation where he was on the wrong side of that power line. And by the way, it doesn't matter why he got there, but you know why. You heard it. There was a disagreement about ASAP Josh and about what happened to him and what was going to be paid for and what wasn't. And what's important is that Relli and the defendant had a disagreement about it. That's what happened. And because of that disagreement, and because of ego, this is what happened. Now, some of you might be saying to yourself, well, wait a minute. I mean, in the end, what really happened in this case? Okay, it wasn't a prop gun, obviously. The evidence demonstrates, and by the way, we don't have to prove that Relli got shot. The reasonable inference from the evidence is that he's got a wound on his hand that he didn't have beforehand. I'm going to address this again, but every time you hear the defense say, where was the witness to testify to that? You need to remember something. They are the ones that are arguing that this was a prop gun. They are the ones that are arguing that Relli didn't actually sustain these injuries from a gunshot. They are the ones arguing that casings would not have been found. You've got how many lawyers over there? How many people? There was a point in time during jury selection where they almost had a football huddle. There were like 8 or 9 of them over there. Do you think for one moment, 1 millisecond, that if those individuals have something positive to say to help the defendant, that they would have called those individuals?
This is improper as fuck. It's not his job to introduce evidence. It's not Rocky's job to introduce evidence. I get Tacopina's old school. Tacopina strikes me an old school guy. Like, old school attorneys don't object during openings or closings, but it's got to happen. He's got to step up and protect Rocky. It doesn't matter. It's not his job to bring in any witnesses. It's your burden.
If, for instance, that if those individuals have something positive to say to help the defendant, that they would have called those individuals. If, for instance, Relli's injuries could not have been caused by a graze wound, they would have called a witness. So what you're left with is, Relli didn't have that wound when it started. He testified that he felt heat going through his hands instantly. So the idea that, well, it's a minor wound, and that's true. But we're not here to talk about the consequences. I want to really point out something that's really important. This was 10 p.m. on a busy Saturday night in the middle of Hollywood. And what happened? And you know this. Well, I'm going to go through this evidence at length. But the short story is that the defendant, because he was angry, because of ego, because of the fact that he is who he is, he decided that he was going to have a confrontation with Relli. That's what happened. We'll go through the video. It's very clear. The defendant goes there with a gun. He's got 2 guys with him. He grabs Relli. He initiated this incident. And what I don't think is being addressed enough, and Relli talked about it, is that, remember, Relli has no idea before this is happening. He doesn't think it's this severe of an issue. They've known each other half their lives. They understand they're upset with each other. That's clear. You have to text back and forth. But at that moment, and I'm not talking about when the defendant fires a gun. I'm talking about the parking garage. When the defendant pulls out the gun, Relli's entire future flashes before his eyes. And do you know what that future is? He's done. It's over. What makes it over? Well, he understands that if the defendant is upset with him enough to pull a gun on him, that he's going to ruin him. As he told you, that means no more articles signed with him. That means record deals will go over. He's done. And he doesn't know this is coming. He doesn't have time to contemplate it. And what's his response? It's shock and it's anger. And it's not really thinking about what is smart. The argument that Mr. Tacopina makes is, well, who would go after somebody who's pulled a gun on them? Well, that's not quite a fair argument, because it's not somebody who's pulled a gun on them. It's someone who was a close friend. And Relli,
is he really going to make an argument really had nothing to lose at that point because his life was over? I don't think that's a slick move there. That's a bad argument to make.
I told you he really wasn't thinking about the consequences. He was angry. He also told you, you know what? Rocky had pulled a gun on him and he put it back. So he realized at that point, his life as he knew it is over. By the way, he was right. So we're not here to talk about what damages Relli should get, what damages he shouldn't get. But let's remember something. That man shot him. That man took away the career that he had. I don't know what that's worth. 30 million sounds a bit excessive to me, but I'm not the lawyer in that trial and you're not the jury. So that will be hashed out, that will be debated, and that will be eventually decided upon. But there's no question in that moment, he realized that he was losing something very, very important, very precious. And so what does he do? He follows, and we have the second incident. Now, what started the second incident? We'll never know. We know that Relli is yelling at him. Relli is saying very unkind things. And we know there's no question, the defendant is proud, okay? And I'm gonna give you another word because I'm not gonna hide from it. He's entitled, all right? Everybody runs around. He is a big, important man, and everybody serves him. This is just a small example, but it's important. The witnesses who came in are dependent upon him financially. They're dependent upon him for their careers. And what happened in the middle of a trial with 12 on the stand? 12's asked a question. Has anyone ever seen or heard a defendant yell out to a witness in front of the jury, "Don't answer that"?
That is still a massive problem for Rocky. That little retarded little gay omerta thing they have, like Fight Club. You can't talk about AWGE. That was you can't take your gay meme LARPs into a courtroom chat because it doesn't translate. All the jury hears is a guy telling him to shut his mouth. So yeah, that could hurt Rocky. This could kill him. This could kill his defense.
That's what happens when you have a lot of power. And no one has ever told you, you know what? You can't do that. So why did he take out the gun and fire those shots? I don't know. But you don't have to figure that out either. Because in the end, and I covered this in jury selection, I asked each one of you, if I prove to you, Mr. Zlenik and I, if we prove to you what happened in this case, beyond a reasonable doubt, and you don't understand why it happened, it still happened. But that's not where the story ends, because that act, and the first act's important too. When he pulls the gun out, we go through the video, but it's very clear that that incident ends because a couple of people walk by. That's very clear. There are witnesses. One of the witnesses, I think 12, I believe, even mentioned, yeah, there's people walking by, but that's not what ended. Well, you can see where they are, and you can see that right after, that's when he puts the gun back. When they get to the second scene, something happens. And one of the things that makes no sense in the defense argument, zero sense, is that they keep talking about the timing of the shots. Okay? It's not when the first shot was fired, and you're going to see it. You can see, you can't tell what it is, but you can see Rocky make a movement behind his back and pull out a firearm. Pull out, you can't tell what it is, but he's going to pull the item out. And at that point in time, he's going to start advancing to where Relli and Gills are. That is what Relli responds to, is that firearm being pulled out. Yes, he grabs Gills before the first shot is fired because he's trying to avoid getting shot. So again, the timing of which shot it is it 1 second before or after? That's an irrelevancy. It doesn't matter. It's not even the defense theory. And the other thing that's really, really important, again, I'm going to call it out. I'm not going to hide behind it. That man decided that his ego and his vendetta and his anger at Relli was important enough that he was going to risk not only Relli's life or Ill's life, but he was going to fire 2 shots from a 9mm firearm in the middle of Hollywood. Now, I don't have to tell you, because you all know it's common sense. Bullets travel until they hit something. That's what happens. They're fired at very, very high velocity. They're coming out at an incredible speed. And they travel until they hit something. Sometimes what they hit is the ground. And they ricochet. Sometimes what they hit is a car. Sometimes what they hit is the person they're aiming at. And sometimes some tourist walking down Hollywood Boulevard with her family all of a sudden drops dead because they've been shot in the head by a bullet that somebody selfishly fired to settle a childish dispute. That's what he did. That's the conduct in this case. It's not about what injury Relli received. It's not about how much money he's going to sue for. Those are not in the jury instructions. You're not going to see a jury instruction on, quote, extortion. Because that's not what you're here to decide. That's what happened in this case. That man decided, you know what? I'm angry. And I'm going to show him. The defense argument, as I listened, it was almost like Mr. Tacopina took off in a plane with no flight plan. And he flew around in circles. Circle after circle after circle. And eventually, he kind of just ran out of gas and kind of just crashed the plane. There wasn't much direction. There wasn't much focus. And there wasn't an emphasis on the actual facts you're here to decide. Now listen, he's got a tough case. In opening statement, my partner got up here and he told me this is a simple case. It is a simple case. I'm going to tell you, this case could and easily could be a 5-minute verdict. And here's why. Because once you decide that this was not a prop gun, and ladies and gentlemen, it's not a prop gun. I'm going to go through all the reasons. And once you decide that, this case is done. It's over. Because that's the defense in the case. Not, as Mr. Tacopina tried to argue, well, in self-defense. You notice, Mr. Tacopina didn't actually reach the next step. He talked about self-defense, but he never explained to you, for it to be self-defense, you have to find that it was a real gun. That's what you have to find. If you have a question about that, you ask the court. You have to find, to get to self-defense, that it was a real gun. And their defense in this case was, it was a prop gun. That's the issue in this case. Was it a prop gun or was it not? If you find it's a prop gun, all I can say is, you know what? You really need to examine why you're getting there. And I'm going to bring up something that's really important. The defendant is a celebrity. His wife's an even bigger celebrity. Many of you know who they are. They brought in 2 adorable children yesterday for closing argument. Now, they haven't been here at any other time.
This is improper. This is improper.
And you have to ask yourselves, those kids have a right to be there. Why children that age would be here in a situation like this, don't know. But you have to.
Jesus, Tacopina, I get your old school homie, but you have to take this. You have to take this cuck of a man to the woodshed, brother. You can't let him do this.
Ask yourselves, am I going to let my feelings of not wanting to convict the defendant? And Mr. Tacopina made it very clear. You notice in closing.
Not gonna lie, I hope they do it just to fucking make you mad and seethe. I hope they vote not guilty in 5 minutes just to piss you off.
He literally brought up Rihanna. He brought up the defendant's family, and he basically was saying, "Hey, listen, if you convict him, it's going to be very difficult on the family. That is not something you are allowed to consider." So I'm not telling you I don't think you should consider it. You are not allowed to consider it.
It's not his
If you
job
think
to
you are allowed
step in.
consider it, ask the question to the judge when you go back. You can send out notes. You can ask questions. You are not allowed to consider how this might affect Rihanna or his kids. And there's a very simple reason. We are all in the world responsible for what we do. And I'm going to add something else, too. There was testimony from...
That's actually not true. And Jose Baez said it best. On a jury, that is the one time, actually, in any of your life, for those of you out there, a jury is the one time, really, where you can make a decision and you don't have to worry about the consequence. It's not your job to worry about the consequence. So to say, we all have to live with our consequences of our decisions. Juries don't. They move on.
ASAP Lou. And ASAP Lou, even though it wasn't a question, ASAP Lou wanted to get in front of you, I think 2 times at minimum, that the defendant is looking at 24 years in prison. The defendant is looking at whatever Judge Arnold decides he's going to give you. So you are not allowed, by the way, to consider.
This should be objected to. This should be objected to right here as well. And Porcelain thought you were saying, why isn't the judge stepping in? It's not his job to step in. It's for Tacopina to raise objections.
Oh my gosh, if I convict, you get 24 years. You're not allowed to consider, even if that was true. But in the end, Judge Arnold will decide what the sentence in this case is. So if any of you go back there and say, well, you know what, I just don't think that this crime, I'm just not comfortable with 24 years, you can't do that. If one of the rest of you does it, guys, it's misconduct. You can't do it. You got to stop yourself, you got to stop the person next to you, you got to say, you know what, we can't do that. All right.
It's actually not misconduct. They can, you don't get to stop them. If they make whatever decision they make, you have to fucking deal with it.
You've got to base your decision on this case on the facts that have been proved from the evidence. Now, this is really important. The instruction does not say on the facts that have been proved from the people's evidence. That is hugely important in this case. There is no question whatsoever that our case got immeasurably stronger because the defense chose to put on the case. No question. Even if some of you were saying to yourselves, you know what, I don't think based on just what the prosecution put on that I would have convicted. And let's think about that for a second. Until the defense case, now they mentioned in opening, but remember, opening is not evidence. Until the defense case, we don't know what the defense is. It could have been self-defense. It could have been any number of things. It wasn't. They chose to put on a defense. They didn't have to. You remember what I asked you all, are you going to give any points to the defense if they choose to put on the defense in their case when they don't have to? Or are you going to look at their evidence as critically, as importantly as you for our evidence? You all said you would do it. They elected to put on a defense that killed their case. It destroyed it. And I'll go through it. It started with Wally. The best evidence from the victim. This is probably the second thing I agree with Mr. Tacopina. Mr. Tacopina put on Wally to impeach the defendant. I'm sorry, to impeach the victim on an issue of whether it was his voice. And obviously, it was Relli's voice. And obviously, he was uncooperative. But let's take a step back and ask ourselves, why was Relli uncooperative in this case? Relli told you, and you saw evidence of it, in April of 2022, when it came out that Relli was the individual who reported the defendant to the police, he's facing death threats. His family is facing death threats. So he is up there not wanting to answer any question about his family. He doesn't even want to give his girlfriend's name. He doesn't want to say where he lives. He doesn't want to identify anything about my aunt. You got to ask yourselves, first of all, is it understandable why he didn't want to answer the question? Well, of course it is. You have to ask yourselves, Mr. Tacopina repeatedly asked those questions. Listen, that's his right as a lawyer. He can certainly do that. But it was very clear that the result of that, if not the intention, was to get Relli upset, to get him agitated, and to shut him down. And that's what happened. But even more importantly, none of those questions, none of those answers mattered. And what's amazing is the defense, their witness, they put on the evidence from Wally, which is some of the most crucial evidence in the case. And again, I'm going to get there. So the defense had no obligation to put on a case. They could have done nothing. But do not be mistaken. Some jurors go back and they say, you know what? Well, because if I only look at the people's case, they haven't proven it beyond a reasonable doubt. That's why this says prove from the evidence, not prove from the people's evidence, all of the evidence in the case. So we've got a duty, and we don't hide behind it at all. We have a duty to prove the defendant guilty beyond a reasonable doubt. And by the way, it's interesting. Mr. Tacopina keeps talking about, quote, reasonable doubts. There's no such thing as reasonable doubts. They are not individual pieces. Reasonable doubt is an overall view from all of the evidence. So when he says, well, listen, if you have...
That's not true. You can have one piece of evidence, and that creates reasonable doubt. And it could stand out from everything else. That is not a proper statement of law. That is a misstatement of law. That's not true. Isn't that true? It's not true. Not true.
a reasonable doubt about Relli's credibility, then that means it's not guilty. That's not true at all. The question is, when you look at all of the evidence, if you find that Relli's credibility is really material, if you find that there isn't other evidence that overcomes it, does the overall collection of the evidence cause you to have a reasonable doubt? There is no such thing as reasonable doubts. They are not like pieces of a cookie where you pick up one and go, oh, here's a reasonable doubt. It's not how it works. And you got the instruction that shows it. We have to prove every element of the crime charge. No question, that's our burden. But this is really important. Not every element in every case is in dispute or reasonably in dispute. So what does that mean? So for instance, we would have had to prove that it was the defendant who was at the scene. That's our burden. But the defense has already conceded that. We would have had to prove that the defendant had a gun. They've already conceded he had a gun. They say it's a prop gun. We would have had to concede, we would have to prove, that the defendant assaulted Relli with the gun. Well, they've conceded that. They just say it was a prop gun. We don't have to prove whatsoever that the defendant shot Relli, although that's what the evidence demonstrates. So very little in this case is in dispute, and that is hugely important. So let's talk about the relevant evidence in this case. So the day before the shooting, November 5th, 2021, Relli's in a car with Bari. Again, I got to talk about Bari for a second, ASAP Bari. The defense is saying, well, why didn't you bring Bari in to us? Bari is the guy, if you remember, who posted, who is calling Relli a rat or a snitch. I can't remember which it is right now. The people's position is that Bari is not credible. If the defense wanted to bring him in.
Objection. It's not the defense's burden. It's not their burden. If the defendants wanted, it doesn't matter what they want to do. It's what you did or didn't do. God, Tacopina, stand up for your boy. Please. Tacopina, stand up for your boy, for the love of God. Please, they're going to kill him. Come on.
Is that Bari is not credible. If the defense wanted to bring him in, if they thought that he had evidence to add to their case, they would have brought him in. They flew in a guy from France, okay? Let's just take a step back. They flew in an individual from France at tremendous expense on almost no notice. And they flew him in because they wanted to prove that that was Relli's voice on the tape. Now, one has to ask themselves, do they listen to the tapes? Because the tape is some of the best evidence we have in this case. And you know that they only played for you a little snippet. I'm going to play the whole first part of that call, uninterrupted. I'm not going to give a snippet. So what happened in this case? Day before the shooting, there's an issue between the two of them. Okay? The defendant is upset with Relli. That's not a dispute. He's upset with him. I have no idea whether Relli was right about this dispute or the defendant was right about the dispute. But here's what I know for sure. It does not matter. It's not an issue for you to even consider. If, let's assume that Relli paid for every part of ASAP Josh's funeral. Okay? The most expensive funeral in the history of mankind. He paid $20 million for the funeral. Let's assume that happened. It doesn't change the fact that he can't assault him with a firearm. I don't know. We have no idea who was right on this. But it's very clear it doesn't matter. But what's important is there is a dispute. And by the way, if that call did not take place, do you believe for a second that they would not have brought ASAP Bari in? And what do you think would have been the response for the defense if we would have brought ASAP Bari in? And ASAP Bari would have lied the same way that Welby lied, and Wally lied, and ASAP Lou lied. So he's his close friend. If that guy was going to help him, they would have called him. And they have the power of the subpoena just like we do. And in fact,
Objection! You gotta step in now. This is not allowed. This is not allowed. Why is Tacopina not standing up to this? Bruh, third time shifting the burden. Third time. This is mistrial. Mistrial with prejudice. Tacopina. Yeah, no, this because if you don't raise the objection, it's deemed waived. Now, Rocky could argue ineffective assistance of counsel, but it's going to be tough. But God, yeah, LA must be different. I know Bama's out there. I know Bama's in Bama. J-Rock's in Georgia. That's a Shame is in Indiana. Old Line Reds in Maryland. You know, we got a lot of attorneys here. I'm in Ohio. You ain't doing this in Ohio. You ain't doing it. You ain't doing this in Ohio. You ain't doing this in Ohio. God, Tacopina, stand up for your boy. I know there's judges that would put the brakes on this. I think there might be a judge or two that I deal with who jump in, but most of them will let you get away with stuff once in a while. But if I was a judge, I'd step in. I don't want them destroying the record. But something has to be done here. This is bad.
He's the defendant's friend. They know where he is. They're able to access him. So the fact that he's not here, do not get caught up in that game. But again, the relevance of this is simply that they had a dispute the day before. And the defendant, who is clearly a proud individual, got embarrassed by the fact that Relli is hearing him talking about him behind his back, which, let's face it, it's not very manly, okay? It's just not. And it's clear that the defendant is embarrassed by this. He's embarrassed.
Because you're the definition of manliness, brother. You're the definition of what's manly. We watched you being the manliest Chad McChatterson, just bullying Tacopina, huh? You know, the man's man right here, Chad.
Embarrassed by the fact that Relli knows he is talking about him behind his back. And Relli doesn't like it, clearly. So this is the day before the shooting. You can see what's going on. I'm not going to repeat the language. This is what we have. By the way, at this point in time, this is a stupid little incident, okay? The man's a multi-millionaire. Why on earth is he going to take it
Wait
to
till
the
he does, I
level
guess.
that he took it? I don't know, but that's exactly what he did. So what happens? Well, the day of the shooting, we know that Relli is receiving a bunch of calls from the defendant, from Ills, and from 12. And if you don't think that Ills and 12 know what's going on, I got a bridge to sell you. Okay? If you think, as the defense argued, that those were credible witnesses, Relli was angry and he was hostile. They weren't angry or hostile. They were just liars. Start to finish. So what happens? Well, we know shortly before the shooting, let's get to it. Stop ducking my calls. Now, by the way, Relli says, hey, listen, I'm not really sure what's going to happen. And when you look at it, it looks like they're going to have a disagreement. But this is really important. Relli can kick the defendant's ass all day, okay? That's clear. But if Relli does that, he loses his life. He doesn't have any interest in doing that. He knows it. The defendant knows it. Everybody knows it. Even those lying witnesses, 12 and Luke, eventually had to concede that the defendant has a lot of power in the industry. The industry where Relli works, the industry that he is dependent upon for his livelihood. So he's got not only no motivation for getting into a fight with the defendant, he can't do it. He's got to sit back and take whatever he's going to take because he's power. That's who he is. He's got power. There's Rocky.
Very true. Make
and
the
there's
extortion
Relli.
plausible again.
Rocky knows it and Relli knows it. That's just the facts of life. So what happens? We have this incident. Now, thank God we have video in this case. Okay? Because without video, we all be in trouble. This video is very clear. And when Relli is walking, there's a couple things you want to consider. I'm going to get to this again. The idea that the defendant is bringing a gun to this meeting makes no sense at all. He's got two guys with him. He's not afraid of Relli. Relli's not looking for a fight. And you're going to see that the first action is the defendant grabbing Relli. That's what you're going to see as they're walking up. And I have this is slowed down so you can see. So what you saw, the defendant grabs his arm. Now the defendant is pushing him forward. Relli is holding him back. Now this is really important. Stop it for a minute, please. You want to stop it for a minute? So this is really important. Some stuff in the trial is almost funny. I would ask 12, so what was the weather like that night? Man, it's cold. And Relli, he's huge. He's got muscles all over his body. They made Relli out to be the Hulk. They made that happen because that's the narrative they wanted to create. But the problem is if you watch, Relli clearly is stronger than Rocky is. He's stronger than Ills is. Yet he's letting Rocky push him back. If he had wanted to, he had his hand available to punch Rocky. He didn't do it. Probably not because he didn't want to, because he's a grown man who understands that if he does that, it's over. He's got no career. He's done. What he doesn't understand is that in the next moment, Rocky's going to take out a gun, and Relli is going to realize, oh my God, it's over anyway. Please play it. Stop it. Stop. I don't know if you remember, but when I had
Making Relli sound like a desperate man doesn't make him more convincing.
Welby on cross-examination, and he is saying that he's trying to pull the Relli off of Rocky. And I think this same image, and I'm asking him, well, wait a minute, how are you trying to pull Relli off of Rocky when you're in the middle? You're trying to keep Rocky off of Relli. No, I'm not in the middle. Of course he's in the middle. Keep playing it. And now watch the gun. Stop. It is true, we do not see the gun come out. But we know from before that the gun was not in Rocky's hand because we saw his hand before. Now, if you remember, what was 12's version of how the gun came out? I mean, guys, I'm not making this up. He said that Relli lifts Rocky off the ground. His pants fall down, and Relli reaches back to pull his pants up and happens to end up with the gun and what looks like his finger on the trigger. That is more absurd than, again, the tornado example with Booker. It's absurd. It insults your intelligence. And the only value that it has is if you are going to try to find a way to let this man get away with what he's done. And this goes back to what your duty is. You're here to call balls and strikes. What happens to Rocky is not your responsibility. Not whatsoever. Your responsibility is determining what happened. It's almost like what an umpire does, okay? When an umpire calls a strike or calls a ball, he doesn't own what happens in the game. The players decide the game. He's just making the calls according to the rules. Do not be fooled into the idea that, quote, Rocky's life is in your hands. Rocky's life is not in your hands. The determination of what Rocky did is. And what happens from there, that's on him, and that's up to the judge. So what happens? So he's got the gun out. Continue to play, please. Stop. So if he was trying to put the gun back, why is the gun now from behind him to in front of him? So they're going to say, well, you don't see what he does with the gun. Well, if his gun fell out accidentally, why doesn't he put it back? Well, it's because it didn't fall out accidentally. He pulled it out, and now he's going to assault Relli with it. And the fact that you don't see the assault because of the cameras, ask yourselves, logically, he took the gun out. He switched hands. The gun is now in front of him. What's he doing with the gun? He's doing exactly what Relli said he was doing with it. And by the way, nobody said that the defendant tried to murder Relli, intended to murder Relli. You're not charged with that. So the gun comes out. Continue to play. Stop. Okay, now, if you notice, he's about to put the gun back. And you're going to see the people crossing because, keep playing. So the gun went back because you see the people that are on top? They are walking from the direction where Rocky just was. Now, why Rocky put that gun away, we're never going to know. I can't prove to you beyond a reasonable doubt why he put the gun away. No one can. I can tell you that the evidence suggests, clearly, it's undisputed, there's a couple of people walking right by. It's in the middle of Hollywood, and Rock's a pretty famous person, and if he was planning on shooting the gun at that point in time, that would really seem to be an ill-advised place to do it. You have to ask yourself, do you think it's a coincidence that when Rocky ends up actually shooting the gun, that the gun is shot in a place where Rocky reasonably doesn't believe anybody's watching him? He didn't know about the cameras. He knows there's a crowd of people here. Jimmy, play, please. So this is how the first incident ends. Okay, this is how it ends. So when we're looking at this, that's count one. That's the assault with a firearm. That's the personal use of the firearm. We don't have to prove any more than what you've just seen. Now, we do have to prove that it's a real gun. And here's what's interesting. Why are we unable to determine definitively? We certainly have strong evidence that it's a real gun based on what happens in that scene. But who was in control of that gun? And let's think about what the argument is. They're saying that's a prop gun. Where's the prop gun? How are we supposed to prove that it's not a prop gun when they've got the gun and they got rid of it? It's impossible. There's no way for us to do anything more than what we've done. So what happens at the next scene? Part 2 of this. Now this is going to be important because what you're going to see here is you're going to see that the incident starts before Relli ever grabs Ills. By the way, Ills is the guy he likes. He doesn't like 12-8. So you want to just ask yourself for a second. He never tells anybody, hey, Ills had a gun, Ills had a knife. Here's why I assaulted Ills. He's not assaulting Ills. He's not punching. He's not doing Ills. He's using Ills as a shield, just like he's going to say. But let's look at the not let what's going to happen. Oh, okay. So here we go. Back it up again. Start this one over. So when you're watching this, what you're going to see is not as the defense described, that Relli grabs Ills and then Rocky defends him. What you're going to see is Rocky is going to reach behind and then he's going to advance towards Relli. That is clearly when Relli sees the firearm, and that's when he ends up grabbing Ills. So the idea that, well, the gunshot doesn't happen until after he grabs Ills, it doesn't matter. Relli's responding to the fact that Rocky's pulled a gun on him for the second time. And by the way, this is a lot scarier than the first time because now they're by themselves, and clearly Relli is concerned he's about to get shot. Now, I'm going to get to it and I'm going to address it, but this doesn't even begin to cover the idea that their defense is not just this was a prop gun, which is absurd. It's an absurd defense. Their defense is it's a prop gun, and Relli knew it was a prop gun. And even though Relli knew it was a prop gun, Rocky pulled it on him to scare him, even though by their own admission, he knows it's fake. And you can see Relli running around, and you can see what 12 does, and you can see what Rocky does, and no one is acting like it's a prop gun because it isn't. So let's watch it. Boom, guns out. By the way, at one point in time, one of the witnesses, I think it was 12, said that the defendant fired a warning shot. You don't fire a warning shot with a prop gun, it doesn't fire anything. Also, you can see that on that shot, the defendant has the gun out, facing forward, appearing to target Relli. And by the way, he moves into a better position in between the shots. And the only reasonable conclusion you can reach from that is that he is trying to get a line of fire onto Relli. Relli didn't suffer the minor injury because the defendant didn't try to shoot him. He suffered the minor injury because he used Ills as a shield, and for whatever reason, the defendant didn't hit him. At least didn't hit him other than in his hand. But the idea that you need to look at the gunshot and the fact that Relli is already grabbing Ills as a shield, that's just misleading. It just doesn't work. I'm going to play this now in half speed. Let's give you the same. And the idea, by the way, that Ills, that 12 is running away because Relli is trying to attack him is absurd. If you knew nothing, all you saw was this video and somebody told you, hey, listen, that's a fake gun, and everybody knows it's a fake gun. You would go, well, wait a minute. If it's a fake gun, why is everybody running around? Why is Relli grabbing Ills as a shield? Why is 12 running away? By the way, how does this incident end? This incident ends not because the defendant voluntarily says it's over. 12 literally is blocking him and pushing him away. The defendant is fired up. He's angry. He don't know what was going to happen next. But it's not as if the defendant decided on his own, you know what, I'm done. 12 pushes him away. So this is the close-up. And again, this is a little bit harder. This is going to be played at half speed. I got it. It's going to be played at half speed. Again, we already know that you've got. By the way, the only thing that Mr. Tacopini did not accuse Relli of was planting the nail on the seat. And I was waiting for it. I was waiting for him to say, Relli planted the nail. He was trying to get me. So we know who we have, defendant, 12, and we've got, which is hard to see, we've got Relli and Ills. So what happens? You watch for yourself. You're going to see Relli reach and then move. When Relli reaches and moves, when the defendant reaches and moves, That's when the gun is out. Whoops. Sorry. Okay. So here we go, boom, you see him reach, guns out. 12, he moves. Relli is running, trying to get behind Ills. He's not beating Ills. And what is Rocky doing? He's running around, trying to get a shot, and he's gonna fire. And when he fires a second time, the gun is outstretched, aiming at Relli. And now look, there's 12 grabbing him and making the defendant go away. That's how this thing ends. Again, and I understand it. You guys don't want to believe that this man who has everything, is going to give it all up for this. I get it. But that's a decision he made. I didn't make it for him. You didn't make it for him. The judge didn't. Mr. Capapina didn't. He made that decision on November 6th. And what's crazy is that apparently Relli would have been more than willing to take the money and not cooperate with anybody. And by the way, why is that? Do you think that if you are in the hip-hop rap community, that going to the police and filing a case against APRocky is going to help your career? It's done. When Rocky was saying, and you heard it before, hey, I'd be on the beach, he would have been on the beach. So not only did the defendant commit this violent crime, but in the end, his attitude was, no, I'm not giving anything. Now, that's arrogant, but it's what happened. And I want to make sure that no matter how successful he is, how famous his wife is, how cute his kids are, how much they giggle here during closing arguments, that you guys are not going to say, you know what? We're going to give him a little extra. He needs to be treated like you would treat any other person. Because in the end, that's all that he is entitled to. He doesn't get to be the big celebrity in a jury trial. He's a defendant like anyone else. Okay, so what happens after the shooting? Immediately, Relli understands what's going on. So we had, and this was very interesting, we had the officers called, and the whole idea is, we know that this incident never happened, meaning it was only a fake gun because they didn't find the casings. What became very clear, ladies and gentlemen, is the defense did not realize until we called our witness, started questioning Lou Levin. They did not realize, it turns out that the prop gun, which was apparently a 9mm prop gun using 9mm ammunition, prop ammunition, is going to have the same brass, maybe lighter, but it's going to eject the casing the same way a real 9mm does, because as Lou Levin told you, and I think it's 12 he told you who knows less about guns, the point of those prop guns is they're supposed to look realistic. And if they don't eject the casing, they're not realistic. And any of you who've ever seen a firearm, any semi-automatic firearm, understands that in order for a second shot to be fired, unless you're going to manually take a round out and put it in, which you don't do in a semi-automatic, it's got a chamber and cycle around. That's what it does. They didn't realize that. So what happened is they spent a bunch of time talking about the incredible investigation that the LAPD officer did on scene. I asked you during voir dire, are you going to be able, in this case, are you going to be able, if you don't have every question answered, to come to a verdict, if the evidence demonstrates to you beyond a reasonable doubt that the case is proven? Each one of you said, no, you know what, I don't need every question answered. Let me tell you a question we can't answer. I cannot tell you why LAPD did not find the cases that night. Don't know. They certainly looked. But here's what we know. They didn't find any casings, meaning if the defendant's position is correct, if the defense position was the prop gun is correct, there should have been casings there for the prop gun. They weren't. And what we know is Relli went back and he found them. And I'm going to go through and explain to you why that's credible evidence. So what happens? He goes back, he texts and he says, hey, you tried to kill me. Okay? What are you talking about? Why?
Oh my God, this is just, chat. I think he's gonna kill the jury here with boredom, because I mean I'm struggling to stay in this. Like, there's no need for this to be this long. There is no need for this to be this long, chat.
Telling people I shot you, what the defendant says. By the way, the defendant's position now, their defense is that he shot him and it was just a prop gun. So the question isn't that the defendant is lying here. He clearly is lying. He's just saying, oh no, it's prop gun. So Relli says, you tried to set me up and take me from my daughter. He is saying, you tried to kill me. That night, in that text, Relli doesn't know we're going to trial. And what's the defendant's response? Not, hey, that was a prop gun. It's stop making shit up. So, this is what they say is the big evidence in this case. Yes, Relli decided that rather than cooperating with the police, he was going to try to get a bunch of money. Is that the honorable thing to do? Is that the good civic mind thing to do? Of course not. Because the defendant firing his gun in the middle of Hollywood jeopardized everybody. It's not just a crime against Relli, it's a crime against us all. But Relli didn't care about that. And by the way, eventually, when there's a civil trial, I'm sure that the civil lawyers will be arguing that Relli doesn't deserve anything. Luckily, that's not my job. We don't represent Relli. We represent the people of the state of California. And we're here because the defendant committed a violent crime. We're not here asking for money for him. I'm not gonna sit up here and tell you what he deserves. I have no idea. So what's important here is he's explaining in his text that he wants to get the money, but he's explaining why. He shot at me. Relli never, ever, ever has been inconsistent in the fact that the defendant shot him, that he got hit. Never. Sure, was he not upfront about owning property in Miami? Some of the questions. How did you make money in 2021? Is this a picture of your girlfriend? Imagine if you are sitting here on a case that is being live streamed. You got the camera here. You've already been threatened. Your family's been threatened. Your daughter's been threatened. Your girlfriend's been threatened. And now someone is going to ask the defense attorney, what's your girlfriend's name? Let me show you a picture of her for the world to see. What do you expect Relli to do? Okay, now we're going to get to the most important statement that Relli gives in this case. And let me tell you why it's so important. And again, some of you might be asking yourselves, why did the defense bring in this evidence? And let's be clear. When the defense says, well, we only brought Wally out here to testify to one thing, that's true. They easily could have played the call. There's no magic form where we got to play and they don't. They're arguing that Relli is inconsistent.
The objection to not play that will go.
I couldn't hear you. What was around?
The entire call.
We played.
By the defense.
Well, that's what I'm saying. The defense could have played the entire call. They didn't.
That was the objection.
So we decided that we were going to play the entire call. And you can listen to this call. And let me tell you what's so important about the call. Relli does not have any idea that he is being recorded. He's not talking to cops. He's not talking to a prosecutor. He's talking to someone who he thinks is his friend. Now, that person isn't actually his friend. That person is an agent of Rocky. How do we know he's an agent of Rocky? Well, we know it for a couple of reasons. One, and again, this is how just lack of credibility filled Wally's testimony. Wally says that basically he just happened to record him. When I'm asking, wait, why are you recording him? Well, he had like 10 missed calls from me. Wait a minute. So your friend, you have 10 missed calls, you decide I'm going to record this call. He recorded him because he was trying to get information to help Rocky. And you know that because what does he admit that he did right afterwards? He calls Rocky and tells him what he said. But here's what's incredible. When you listen, I'm going to play it. Wally's testimony was he knew nothing about this incident before this phone call. Yet, you're going to hear him say, I'm not here to pick sides. So that's a straight lie. Of course he knew about it. He's Rocky's good friend. It's already been in the media. It's been blown up in hip-hop websites. Of course he knows about it. And when you listen, what is so crucial about this
Yes, Chet, that was the first.
This is Relli.
Finally, an objection. Finally.
Live, not in a courtroom, not to a police officer, to a friend where he's got no motive to make up anything, where he's explaining what happened. And he is literally incredulous. When you listen to this, what's going on is Wally is trying to get him to try to settle this thing for money. That's what's going on when you listen. And Relli's like, hey, I tried to settle it for money. He didn't want to do it. But in terms of the facts of what happened, he is crystal clear and consistent about everything that matters. So listen.
Yo, bro. Yo. Shit, Rose, my bad. I'm with my girl and shit like that. So, what happened, Rose? You know, I'm not trying to pick sides. I'm mad at both of y'all niggas for letting that shit happen. For me.
Oh, it ain't no picking sides. That nigga 100% crazy and wrong.
Yeah.
100% wrong. And he got 12 years mixed bro. I'm not, you gotta understand, Rakim been on his high horse for a very long time, you feel me? He didn't have to do what he did. I don't have, he forced my hand, you feel me? I got over 20 missed calls between him and Hills. Why is Rocky going out of his way to do anything like that? You get what I'm saying? I'm pretty sure you didn't hear the story or whatever it is. But you gotta look at it like this. Why is he going out of his way to call me 20 times after Hills and 12 you with him? Text messages saying link up, where you at? And all of this is because of I pressed him about Josh, him not doing right by Josh, and he spoke to Josh Martin live. You get what I'm saying? So I wrote him about that. He hit up Bari later about that, but I'm with Bari. Bari got the phone on speaker. You get what I'm saying? This shit didn't fit well with me. So Rocky talks about me within that conversation because he sees I text him about Josh. You feel me? He told him taking ASAP out my name. This is 7 months ago. I took ASAP out my name. You feel me? Yeah. He's a bitch, so he goes ahead and hits Bari because Bari influenced him a whole week later doing that complex cop shit. You feel what I'm saying? Just so happened I'm with Bari while Rocky hits up. Rocky says my name. You get what I'm saying? Real Money, 12-year bills is at his house. I hit Real Money the next morning, tell Real Money. I heard Rocky bitch ass tell him I don't fuck with him. Whoopty whoop, whoopty whoop, whoopty whoop. You feel me? No fighting words, none of that. Just basically, nigga, I heard you. But in Rocky's head, he was like a bitch because Bari had him on speaker. Rocky don't know who else heard that conversation, but he know I heard him talk about me. I told Rocky over the years, nigga, if you have a problem with me, let me know. Stop rocking me to sleep. You feel me? Boom, boom, boom. Next thing you know, I guess that was enough for him. He felt like a bitch because he knew I heard that conversation. I was supposed to get that conversation with Rocky. I never heard him say curse words or even have that type of energy towards me. You know what I'm saying? So now I know the real him. I tell Real Money, tell that nigga fuck him. You feel me? Boom, boom, boom. Shit is related to him. Next thing you know, I get over 20, 30 missed calls between him, Ills, and Rocky. Text messages. I'm saying that the most. I tell him he calls me. I finally answer because I'm sleeping. Yeah. I answer. He's like, where you at? With his slip voice. I'm like, huh? Where you at? Nigga, I'm at the W. I'm not really at the Lowe's. You feel me? You know, Hollywood Boulevard. They all look the same. You're like, no, you're not. Nigga, that's a bum ass hotel. I'm like, huh? He said, show me outside. Okay. All of it look the same. I showed him outside. What he does, be in 5 minutes. I'm like, all right. My girl, like, what the fuck is going on? I'm like, I don't know. Yeah. He calls me. Those calls me. Yeah, I got all these text messages, bro. You niggas is dumb. You and a couple other people heard this story. Rocky out here thinking it's all sweet, but his life is really, and bro,
that's what I wanted to ask you, bro. Like, my boys, though, you feel me? Why take it to you know, the guys, you feel me?
Who, me?
Yeah, they know how to do it.
Why wouldn't I, bro? He's a multi-millionaire. He blamed that. I'm no longer on his level. Everybody turned on me. Everybody, bro. Rocky had everybody turned on me that day. Plus, what the fuck am I doing? Spin on his life, go shoot him up? Or do I cripple him? Because he's a multi-millionaire, bro. I'm not having nobody shoot at me, but I'm taking him on the chin. And two, I'm not about to spin on Rocky's block. I'm already a millionaire, nigga. You get what I'm saying?
So what you looking for?
You think you're a black nigga? I'm teaching everybody how to get money, how to do this. Do Rocky do that? Do you have a foundation for black people? Do you have a foundation for anybody? No, this nigga's greed. You get what I'm saying? So I can't sit here and be like, oh, how do you meet somebody like that, bro? You take away what they have, dogs. You feel what I'm saying? I'm not doing it on something like this, that, and the third, or some holy shit. I would have had to die lawyer the same day because he weird at me 4 or 5 times. I had to use ills as a shield while I'd be dead.
I feel niggas ain't trying to, like, you feel me? Not trying to end splash and shit, get some paper or something, or what, you know? Like,
bro, it's too late. He told me, suck I did. Boom, boom, boom. I love John the same day. Bro, that's all on him. He had nothing but time, bro. When I got the best lawyer in LA and worry about my business. You feel me? He told John to try to contact me. I sent him the bullets, sent him the text messages of him, letting him know how serious this is. You know what he said? Nigga, fuck you. So what am I supposed to do? I sent the nigga shooting at me 4 or 5 times, but I almost died. Or shoot his head. Now coming with suing, of course, the severity of the case, he's trying to kill me. So that's what he gotta read. You feel me?
There ain't no way niggas this fine, like, you feel me? No name, no nothing, bro. Like, you feel me? Like,
bro, he's a grown, he's 33 years old. He got other things talking for him. You know what he did? You know what I'm saying? He had more than enough time. This shit happened 7 months later. He was trying to reach out to me. He still didn't reach out to me.
Legal shit before not a boy, you know, so.
That's what happened. I didn't want to go out there without having a lawyer. When you get a lawyer, that has nothing to do with boys. And Jabari is his friend. He might as well thank him for him not being leading the people. Because but those allegations, you feel me? He got enough in you part of the PR team. He would have had enough people to block that if Jabari didn't say nothing, bro. Those allegations. Jabari made it official.
So what's the next, bro?
And you've already been sued too. You've already been sued for defamation of character.
Cause everybody look bad, bro. No, I'm just trying to.
He was bad. He did that, bro. I didn't have a gun. He left his Hollywood house. Everybody saying everybody look bad. Why don't everybody put the finger? Because when if I take, bro, I got Hollywood. I got so many people.
They grew up together, bro. They grew up
That's why
together, bro.
niggas hanging. He's in a mansion. And I make my way around him every single time. That's him. He uses niggas. He used 12 year ills, nigga. That was the whole joke about the whole shit with Barbie and then the whole thing. You know what I'm saying? The nigga asked his Barbie, is he not to the complex car? Nigga, Barbie laughed at him. Like, nigga, I'm not using me. Nigga, the next conversation want to know how he got 12 and feels on his jet on some whole shit.
Because y'all niggas grew up together, man. Like, you feel me? Like,
I made that nigga fuck growing up. I made that nigga. I know 12, I know jams. He ain't no jams. He ain't popped up at my crib. On purple swag, I made that nigga. That's why you feel like that, bro. I've been powerful. I've been that. Jabari never did, bro. I put ugly ass
I just want y'all niggas to kind of end this shit, you know,
he could have ended it when he shot at who ends anything when a nigga shoot at you 4 or 5 times, you gotta grab another member to protect yourself. He called me out my living space. Called me, told me stop ducking him. He played it. That's called premeditated, bro. You feel what I'm saying? He didn't give me a chance. He told me I'm come down. I came to meet him to see what the fuck his status was about. He pulls out. He tried to chest bump me. He tried to chest bump me and then pull out a gun for self-defense. He's a pussy boy. And then Ills is standing in between while he's trying to shoot me. He didn't give me no second. First thing I got like that. And I got it all on camera. You don't want that. Like, trust me, champ. He did it all on camera, champ. So the world looking at me because of bars, you know, right now, but in a few seconds, I want to do what HBO and community did. His whole career is fucked. Everybody's looking at me like a man.
That's what you, I like what's your, I guess it was the end game here, bro. Like,
I'm suing this shit out of him. That was my game, and regardless, I ain't gonna give a fuck about no police, nigga. I'm going against a multi-millionaire that's trying to kill me.
So, really, you're trying to move on and shit.
Besides suing somebody like that, you know what I mean? That, you gotta face the consequences up with that because he wanted to be a gangster and run out his screen like that. That has nothing to do with me. You feel me? I did my part. And what else am I supposed to do?
Yeah, I mean, like, watch that shit in the streets type shit, like, man.
Ain't no street nigga. Bro, what the fuck? You know who my family is? This ain't no street nigga. Ain't that 3 or 4 bodyguards, bro. Come on, don't do that. Don't do that. Don't do that. This man running around with, come on. What street shit do he do, bro? This is a street nigga. You already know what would happen. Everybody know what would happen. We're talking about APRocky, bro. The face of Dior, come on, stop it.
No, I'm just trying to because I fuck with you heavy, bro. You know, I was on his love every time, nigga, and I fuck with you.
I'm trying to let you know, and the ones who's close by him. This ain't no, he ain't no gangster or rebel one. Bro, this ain't no gangster. This was a gangster that's gonna be handled in the streets.
So how niggas like
got 3 or 4 bodyguards from 24/7.
So like what's next though, bro? Like niggas go to court, you feel me? Like why not just
he's finished. He's finished.
Why not just ask for the bag or, you know?
I tried already, bro. You don't ask for the bag because that's extortion, bro. You got somebody that's shooting at you, you gotta look like I'm smart, bro. You gotta understand I'm not a dumb black nigga, bro. You know what I'm saying? You ask for a bag without a lawyer first for extortion. You feel me? You're gonna do everything accordingly. Everything accordingly, or it's gonna catch up with you.
All right, folks, this time take 10 minutes. Please be outside the courtroom doors at 2:45.
Oh my God, Dad. Oh my God. That was awful. Oh. So yeah, this is just complete garbage, chat. Complete garbage. That's a shame. Just why do the prosecutors love gator masks? I don't know. Wearing gators. Jefferson Post says improper arguments list is Lewin's closing notes. Yes. Rowan Coward for 5 subs doing his part to combat the gray menace. Thank you, Rowan. I appreciate the support. Thank you for your generosity. And then Rowan again says, get in the rail car, Grays. I'm taking you to the camp. That's right. Get on board. It's a one-way ticket to Greensville. Oh. Yeah, I'm not been impressed. I'm not been impressed with this. That's Shane says, oh my God. Tell us you'll address them and just fucking address them. Yes. Yes, this was improper too. Many times. Objection. Many, many times. Many times. Says technically you can bring a witness to disprove their credibility. Yeah, but they didn't do that. They didn't say Relli was going to be untrustworthy. They're vouching for Relli. So that's the state suborning perjury. Shredder dropping 5 more subs, chat. 5 more. Doing her part, doing his part to take care of the Green Menace. Green or get out, chat. Yes. Yeah, okay, guys, yes. The Spectre trial, or the Robert Durst trial, that was a COVID trial. That was a trial where, like, Robert Durst was, like, so old it was, like, dying already. And yeah, everybody's wearing neck gaiters in the trial. So we're gonna move on here, guys. We're gonna get this rolling. I'm sorry, I misgendered you. Can we be done? Jesus.
He made reference to Rihanna being in the courtroom and the kids being in the courtroom. The manner in which you did it, I don't think was improper. However, the balance of your argument from here on out, there is to be no mention of Rihanna being in the courtroom or the kids being in the courtroom.
Just them not being in the courtroom, like you mentioned, here's the problem, Your Honor. The defense got up and they talked about
Suffer. It doesn't matter what they got to do. It's not fair. It's not meant to be fair.
impact this case on Rihanna.
I said in the courtroom.
Oh, just don't mention them.
Do not mention, again, Rihanna being in the courtroom or the babies being in the courtroom. There's be no mention of that.
Right, I'm just trying to understand, but I can mention the issue, we're just not talking about being in court.
Mr. Tacopina went into that.
Okay.
You're entitled to.
I was
No mention.
I was
Okay,
trying
being
to
in the court.
report, I just wanted to understand what we got.
There's no mention.
We'll do it.
Yeah. Try to be very, very careful.
What time do you go?
Oh,
We won't go beyond. You don't have to take that one. All right,
could not have been more plain in what he said. Could not have been more credible regarding the issues that matter. And what are the issues that matter? The defendant shot him. The defendant brought a gun, a real gun, to the scene. What's interesting is that it's very clear, and you heard the testimony from Wally. Wally said he was, quote, mediating, which, please. At one point in time, what you heard him say, he changed the word, which I think is good. Also, I'll think of it in a second. This is what happens when you get on the board. Mitigating, thank you. Later on, he said, no, he was trying to mitigate. Sometimes that's called a gaffe. A gaffe is something that you don't mean to say, but which turns out to be true. He was trying to mitigate for Rocky. And how do you know? Because he called Rocky immediately afterward. And then he's saying, I don't remember what Rocky said. I couldn't tell you. Why is he calling him? Why is he taking this? And why during this call, repeatedly, he is telling Relli, ask for a bag, meaning ask for money. Relli's telling him, I asked for money. He doesn't want to give it to me. Wally continually says, hey, basically, why are you taking it to the guys? Why take it to the boys? Meaning, why'd you bring the cops in? He is doing the bidding for the defendant. And what's amazing, and again, it's not right, but the defendant, according to Relli, could have eliminated this whole situation by simply taking care of it with Relli. It wouldn't have been right. It wouldn't have changed what he did. But Relli apparently would have been on an island where we couldn't have found him. He didn't want to do it. His choice, his option, his consequences. Now, the defense said that we believe, this is a quote, that tape is, quote, death to our case. I don't know what he means by death. That is not death to our case. That tape was the key to Relli's credibility if you believe it is important. In other words, that tape backs up every material point that Relli has made. Okay, believability of witnesses. In determining the believability of a witness, this is California 226, you may consider anything that has a tendency to prove or disprove the truthfulness of the witness. Again, I'm very clear. 12E and ASAP Lou came in there, and they repeatedly lied just about almost everything. I'm not going to go through all the inconsistencies. 12E didn't want to concede that he's reliant on the defendant, didn't want to admit that he's talked to the defendant. If you believe 12E and Lou, they've had almost no conversations about what happened in this case since the start. And if you believe Wally, even though Wally is, quote, mediating the situation, he's never talked to Rocky about it. He's never talked to 12E about it. How do you mediate a situation when you're only talking to one party? It's just not true. They lied. The difference between Relli and the defense witnesses is Relli was hostile. Relli was angry. Relli threw things. Listen, that wasn't appropriate conduct. You saw the judge. The judge was very frustrated with it. Everybody was frustrated with it. Listen, Mr. President, that was his witness. That's no easy task for him. But in the end, his credibility about what counts in this case was absolutely proven, and it was proven through their own witness. The evidence in this case, remember, we didn't have that tape. That tape came from Wally. We heard that tape only slightly before you did. Wally comes in and testifies, they play a snippet, and we play the rest. So when you're looking at the factors, you're looking at what witnesses are to be believed. They called 3 witnesses. All 3 of them perjured themselves. All 3 of them lied. All 3 of them came in to protect the defendant. And although they were calmer and more respectful, they perjured themselves in material areas. Relli, on the other hand, was truthful about everything that counted. So the defense focused on the fact that basically you can reject the testimony of Relli if you find that he lied about anything. However, California 226 tells you do not automatically reject testimony just because of inconsistencies or conflicts. Consider whether the differences are important or not. So listen, is it true that Relli, at points in time, was untruthful during his testimony? Absolutely. When he's saying, I don't know my girlfriend's name, of course he knows his girlfriend's name. When he's saying he doesn't know about a place in Miami that he purchased, of course he knows. But those differences, those inconsistencies, those conflicts, they're not only not important, they are completely irrelevant. In talking about ASAP Lou for a second, I'm going to come back to that. Okay, let's talk about the injuries to Relli's hand. Now, the defense said, hey, prosecution, you did not call a witness to come in here and say that that is a wound from a gun. How is somebody going to be able to come look at an injury and tell you where it came from? Now, here's what you have to ask yourself. If there was something about that injury that was inconsistent, where it could not have come from a firearm.
Is this an exhibit? It's not evidence.
I believe this is the correct exhibit. Is this oh, you know what? Hold on, let me back it up. That's my fault. I have the wrong picture. Excuse me. The same. Let me change it. Thank you. Okay, this is the correct exhibit. So we're still talking about the injury of the hand. And you know, without question, that if was an expert who could come in here and testify, you know what? Those injuries could not have come from a graze wound. They would have called that witness. And again, how do you know? Look at the team that's standing over there. Look at the fact that they called in Wally. The purpose of calling Wally, bring him out from France for thousands of dollars, obviously, was to simply impeach Relli with the fact that it was his voice. So if there was a medical professional who could come in here and tell you, well, that didn't come from a gunshot, you would have heard from them. And the failure to call a logical witness is something you can consider, and you should consider. And when the defense says, wait a minute, the people didn't call somebody in to testify, well, you have to ask yourself, if we call someone in to testify, what are we going to be able to get from them? Do you think, common sense, you don't have to be an expert, who can look at an injury like this and say, yeah, that came from a bullet? You can't. You can look at it and go, okay, could it be a graze wound? Sure. So if the defense had an expert that was going to say what they wanted, you heard them.
Once
Okay,
again,
let's
that's
talk
a
about
burden
guilt for a
shift.
second.
Once
This was,
again, a
the
burden
defense
shift.
went all in on a couple of things.
That's a burden shift.
One of the things that went all in was that if there were casings at the scene, LAPD would have found them. Well, they didn't realize that the prop gun put out casings as well, and therefore the question isn't that LAPD missed the 9mm casings in this case. The issue is that without question, whether it was the 9mm or the prop gun, it would have left casings, and LAPD missed it. Why? We'll never know. Why did Relli find it? Well, he had the advantage of knowing exactly where it was. Same thing with Ills. Again, the plan was clearly from these witnesses, and particularly from 12E, we're going to build up the fact that Relli gave Ills a beatdown. This had to do with his strength, how strong he is. He's punching him in the fist. Remember the judge? I still think there's a difference between a closed fist and a regular fist. But the judge, if you remember, when I mentioned closed fist, the judge said, well,
Objection.
it doesn't really matter. Their testimony was, and even today,
Jesus Christ.
you got
Why
the
are you
defense
arguing
saying
with the
how
judge here?
Relli is landing haymakers on Ills. They said that he was bleeding. Okay? Relli's a big guy. He's very strong. They said he was punched in the face at least 3 times. Well, I guess they didn't realize we were going to have a video the next day, less than 24 hours later. And this is from the video. Look at his face. No injuries. No injuries. Nothing. 0. Still photo from the video. Nothing. That is not the face of somebody that was punched in the face repeatedly, given a beating by a large, strong man less than 24 hours before. Someone who they said was bleeding from an injury to the lip when we see nothing. And by the way, where is Ills? Ills is his friend, Rocky's friend. If you think for a moment that Ills would have had something helpful to say in this case, they would have called him. And when they said, wait a minute, the people needed to call him. Why on earth would it make sense for the people to call one of the 3 individuals who was clearly involved in ambushing Relli in the first place and who is reliant on the defendant for his career? If Ills had anything helpful, they would have called him. So I brought this up in voir dire, and this is really important, an idea that I wanted to make sure you guys understand. We mentioned that we might have to be a little bit aggressive on cross-examination. And I wanted to make sure, and I asked you all in advance, hey, listen, if we have to be aggressive in cross-examination with witnesses, are you going to hold that against us? You all said that you wouldn't. Now, whether you all found Mr. Presented to be too aggressive, too loud, too mean, I can't control this man. I can try, but it's impossible. And again, I make that joke because obviously, I'm an intense guy. This is a serious situation we're in. And Mr. Pacapino got up here, he explained to you what it's like to be a defense attorney, what it's like to have what he says against a client. Let me tell you something. I want you to imagine right now that someone you cared about was a victim. What kind of prosecutor would you want? Would you want somebody who takes what they're doing seriously, who is aggressive, who does their job, and who goes after witnesses who need going after? So I'm not asking you guys to like me. It'd be nice if you did.
Once again, object. This is all bull. This is all fluffy nonsense. Why is he allowed to do this? God, judge, step in. This is nonsense. You're not making your, like, I'm sure he thinks he's a nice guy and very likable. God, this is cringe.
That's not what this case is about. It's not about me, my personality. It's not about Mr. Pacapino's personality. It's about what the evidence in the case is. And there's a great quote. Professor John Henry Whitmore, Northwestern Law School dean, he also wrote a series of books, legal books. He was a scholar. And what he said was, cross-examination is beyond any doubt the greatest legal engine ever invented for the discovery of truth. The defense put up 3 witnesses who lied about basically every material fact they were asked about. those lives were exposed to cross-examination. Was it gentle? It wasn't. But that's what it took. And I want to apologize for it. I said before, I can't expect you all to do your job if I don't do mine. All right, let's talk about what the elements are of assault with a semi-automatic firearm, 245. One, you don't need to actually touch someone with it. So the fact that did the defendant touch Relli with the gun on the first incident, it doesn't matter. By the way, he pulls the gun out. If any of you are buying the idea, as 12 said, that it fell out when his pants were being pulled up, then I'm up here wasting my breath. I would add that you're all intelligent people, and if anybody is even remotely considering that, I would ask you to ask yourselves and to ask them, is that what you think, or are you trying to find a way to not convict this man because of who he is? The issue of treating everybody equally, it's paramount.
Chad, I need to go back. Sorry, 2.0, we're talking for a second here.
Did the defendant touch Relli with the gun on the first incident? It doesn't matter. By the way, he pulls the gun out. If any of you are buying the idea, as 12 said, that it fell out when his pants were being pulled up, then I'm up here wasting my breath. I would add that you're all intelligent people, and if anybody is even remotely considering that, I would ask you to ask yourselves and to ask them, is that what you think, or are you trying to find a way to not convict this man because of who he is? The issue of treating everybody equally, it's paramount to our criminal justice system. So, again, back to the elements, you don't need to actually touch someone. The evidence is that he did. You do not need to intend to use the force, meaning you don't have to pull that gun, meaning that you're planning on shooting. You don't actually need to injure someone. You don't need to fire the gun. You don't even need to point the gun at the victim. This is in the instruction. And that also goes for the personal use of the firearm. Now, the one thing is, it has to be a firearm. And again, I'm going to go back to this because it's so important. The defense is it was a prop gun. That's the issue in this case. They say it's a prop gun. They say, oh, we have to show it's a prop gun. We say it's firearm. Once you decide that it is a firearm, that means that their entire defense has fallen apart. And now what Mr. Takapina apparently wants you to do is say, well, even if the witnesses we put on lied, even if it was a real gun, here's why it was self-defense. There's an old story about it's a civil case, civil lawyer, and he has a dog bite case, and he is defending his client with the dog, and they're being sued. The client is being sued because his dog has allegedly bitten somebody. He gets up and closes an argument, and he says as follows: hey, listen, my client's dog, there's no way he could have done any kind of damage to the plaintiff because he was unleashed. He was in the yard, could not have gotten to where he says he got. But if you find that he was loose, the dog's old, and he couldn't have done any damage with those old teeth of his. But okay, if you find that he was off leash and he had some big teeth, well, my final defense is my client doesn't own a dog. That's what we have here. It's no different. It's a prop gun, absolutely a prop gun. Evidence doesn't show it's a prop gun, but it's a prop gun. But if you find it's not a prop gun, here's why Rocky fired a real gun in self-defense. It is almost insulting because it is so inconsistent. So when a defendant equips and positions himself to carry out a battery, he has the present ability required, even if some steps remain to be taken. This is basically saying once he's taken that gun out and he's committed the assault, when that gun comes out, that point in time, the assault's done. So this is the 3470, the right to self-defense. And this is really important because remember, it only applies if it is a real gun and not a prop gun. But it's a little more than that because what it basically says is you have to show that they are acting in lawful self-defense or defense of another. The defense position in this case is that the defendant was acting to protect Relli and Gills. But it's more than that, okay? So basically they're saying that they believe that he, Gills, and Twelby were in imminent danger imminent danger, okay, of suffering bodily injury. And by the way, and you all know this, if someone is in danger of being touched unlawfully, you can't shoot them, okay? You don't have to actually go through jury instructions to figure that out, okay? If I go and I slap one of you guys, you can't shoot me. And why is that? Because he's got to believe that the immediate use of force was necessary to defend against the danger, and that it was no more force than was reasonably necessary to defend against the danger. So what does all this mean? Well, they're basically claiming that the defendant used a prop gun, which means self-defense doesn't apply. So as soon as you find that out, you're done. But they're also arguing, hey, if you find, well, then it was a gun, even though that's not our argument. And Mr. Tacopina wouldn't come out and say it. But that's what the law is. If you don't believe me, you can ask the judge. Self-defense only applies in this case if it's a real gun. And the problem is, it also only applies if the force used was no more than reasonably necessary to defend against that danger. And now let's look at what that alleged danger is. There is no beating up of Bills, okay? There was no beating up of Bills. It's a lie. It's not true. You see the video. But even if somehow you wanted to argue, you know it's a lie, because you can see that the gun, you can't see what the item is. So let's be clear. You can see Rocky pulling something out. You can't tell what it is, but you can then see that what he takes, he ends up putting out in front of him and aiming and shooting. That is what prompts Relli to grab Bills. They say, well, he had to use, I guess, and Mr. Tech can never argue this. He can't because it's inconsistent with his theory. But the theory would have to be that Rocky ended up firing the gun at Relli, because Bills was in imminent danger. What imminent danger? He's got no injury. It's made up. The defense is created. It didn't happen. Very important. Belief in future harm is not sufficient. So even if you somehow believe that Relli was going to cause future harm, it doesn't work. He has to have believed at the time that there was imminent danger of bodily injury. Imminent danger of bodily injury. Okay? That's what you need. It has to be reasonable, and he has to act because of that belief. You don't have it, ladies and gentlemen. That's why the defense didn't really argue it, because they are riding the boat. Their position is the dog was off the leash. So the dog was on the leash. Not that the dog had no teeth, and not that the guy didn't own the dog. But in the end, that's what their argument requires. You have to believe inconsistent defenses. It just doesn't work. Now again, the slightest touching, we're not talking about the slightest touching. They're basically saying that in the first incident, they're trying to argue that Relli is the aggressor when the facts in the video don't show it. Even if he grabbed his arm, no one says he has a weapon. You cannot pull a gun on somebody who doesn't have a weapon, who's not physically hurting you. You can't threaten him with a firearm. I mean, I don't have to explain that to you all. You understand that. You can't do it. It doesn't work. So we have the burden of proving that beyond a reasonable doubt. However, again, it doesn't come into existence until you find that it was a real gun. And once you find it's a real gun, it means their entire defense was fabricated. It wasn't true. Automatically, there was no way that it could be a real gun and the defense was not fabricated. Those are impossible. Those are mutually inconsistent possibilities. And when I say possibilities, meaning alternatives. So a person who starts a fight has a right to self-defense. Relli did not start this fight. The defendant started this fight. And he has to actually, in good faith, he's got to try to stop fighting, which he doesn't. He's the aggressor. Both incidents. And in no way is element 2 satisfied either. So you can play games debating how a self-defense claim.
Just killing me now, Lord. Kill me with this
doesn't
case.
apply to the case. But you know that. Their defense is, no question, it's prop gun. A person also cannot claim self-defense if they are the one that provokes a fight or
Oh,
quarrel
Jesus.
with the intent to create an excuse to use force. And that's what happened here. Relli didn't even use any force. Basically, the defendant assaults him with a firearm because he had him. Shoots at him again because either Relli said something or he's still angry. So, in the end, the statements, Terell gave a lot of statements in this case. And about all the issues that mattered, he was consistent. Now, they want to say, but wait a minute. He originally said it was 3 to 4 shots. And imagine for a second. Remember, he doesn't know in advance the defendant is going to shoot. So his memory And you can all, it's not hard to imagine, you're in a situation where you believe you're fighting for your life. How do you know that Relli was fighting for his life? He's telling Wally he was fighting for his life. He's saying, the defendant tried to take it from his daughter. He believes at the time the defendant has fired 3 or 4 shots. And when he talks to Wally, he says 5 shots. That doesn't matter. That's not a question of credibility, and here's why. If Relli were making this up, and remember what they're saying. They're also saying that Relli had to have planted the 9mm casings, okay? And let's talk about that for a second, because it's important. They are saying, hey, listen, Relli was out here 2 weeks before this shooting, and we don't know that he went back home. So apparently, Relli planned this out in advance. He got 9mm casings from when he went target shooting, knowing that 2 weeks later, the defendant would be upset with him, would text him repeatedly, and would assault him with a 9mm firearm, and he would have casings ready to put at the scene. But just to make it extra difficult, he's going to tell the cops, you know what, I got shot 3 or 4, there were 3 or 4 gunshots, but he's only going to turn in 2 casings. So remember, if he's making up this whole thing, which of course he isn't, he is certainly going to produce the amount of casings at the scene that he is saying happened. That's an irrefutable concept. And that's not what occurs. And the idea that somehow Relli is Nostradamus and knows all these things are going to happen. And let's look at what had to occur. It's 10 p.m. on a Saturday night in Hollywood. Relli doesn't live here. We know from ASAP Blue, he can't go out and buy ammunition. He doesn't have a gun. So he certainly could not have, after this incident, bought a gun, fired the ammunition, and dumped it at the scene. So that means that he's carrying around 9mm casings just in case the defendant assaults him. It's absurd. Then they say, well, wait a minute. You know that it's made up because look at the magazine that's found at the defendant's house. And now we go back to ASAP Blue. Listen, ASAP Blue, Proslemik, he really covered it pretty accurately. He's a Swiss Army knife of assistants, advisors, security stuff. You need a personal assistant, lose your guy. You need someone to give you advice on security, lose your guy. You need someone to come over to stay for a search warrant, lose your guy. You need someone to help you get a prop gun, lose your guy. You need someone to get rid of that prop gun after an incident where that prop gun will prove you to be innocent, lose your guy. Lou's version of what happened is nearly impossible. What is that version? And this is really important because remember, we didn't find out about it at the time. So here's what we know. The evidence in this case that you have, and I confronted the witnesses, is that 12E testified that what he told the defense, what was in the statement we were given, was that the defendant decided to carry a prop gun because he had been the victim of home invasions and violence. Let's just look at that for a moment. Nothing about any particular incidents. And then he gets on the stand and he starts testifying about all these incidents, but he says, oh, well, I told them. I told them about it. I think I told them. I guess I don't know. These alleged incidents of prior violence. And supposedly there's a security person. Just think about this for a moment. 12 testifies that the defendant and he were stabbed at a club with a knife. That there's been a crazy stalker inside the defendant's house. That he's been the victim of other violence. And we're to believe that a security consultant said, hey, you know what you should do? You should carry a fake gun. Because individuals who are going to, and by the way, a home invasion, defense counsel, wait, it's different when you're at your home. That's what 12E said. Those were his words, home invasions and violence. Someone comes in your home. How is a prop gun going to help you? How is a prop gun going to help you against anybody? As soon as you pull a prop gun on somebody, they are going to believe that that prop gun is real. And if they have their own weapon, out of necessity, they're going to have to fire back. It's not just bad advice. It's complete insanity and it's made up. But the situation here is even worse. Because remember, they're saying that Relli knew it was a prop gun from the start. If he knows it's a prop gun, then what is the use in Rocky pulling it out in the first place? It would have no value. Relli said, of course I didn't know it was a prop gun. It wasn't a prop gun. It shot me. But the idea, you don't even need Relli's testimony. The idea, they're the ones saying, their defense is, Relli knew it was a prop gun. He stands up and says, put that fake-ass gun away. You look at him in the second incident. Is he acting like that's a fake-ass gun? Is anyone acting like it's a fake-ass gun? Is the defendant acting like it's a fake-ass gun? Of course not, because it wasn't fake. And now let's look at Lou. Lou says, well, so here's what happened. Originally, we hear nothing about the circumstances of, I went over to the house and we were gonna go shooting. We don't hear any of that. All that he says, now he said, I might have told the defense, I might not have, I don't remember. I didn't get into particulars. Are you kidding me? It's the entire case. But all of a sudden, he gets on the stand and he says, for the first time, well, here's what happened. I was gonna teach the defendant, we were gonna go shooting at a gun range. So I brought my Glock 380, which does not use 9mm ammunition, and I brought my Smith & Wesson 9mm, which cannot use a Glock 9mm, Glock 43 magazine. It won't fit. They don't even look anywhere the same, and that is from Luke. Look completely different. He says, he gets over to the house, and that's when he realizes for the first time, oh my God, I bought the wrong magazine for my Glock. Now, does it make sense that he felt a need to go out and buy a magazine for his gun, and then did not find out for some period of time, he wouldn't say where he bought it, when he bought it, and it was not for the right gun, but he made another mistake that he clearly wasn't aware of. I confronted him with the fact, he said, well, so I realized when I was over there, I tried to put the 9mm, or the 380 ammunition in, and it wouldn't fit. Okay. But why was it found loaded completely with 9mm ammunition? As soon as it didn't fit, he stopped. And that's just, well, I'm a fidgety dude. I'm a fidgety dude. So while I was drinking, I was fidgeting, just loading a gun, loading a magazine for a gun I don't have and the defendant doesn't have. They spent a lot of time telling you, wait a minute, that magazine is new, hasn't been used. I asked Lou, isn't it true, Lou, that when you buy a gun, a new gun, most of the time they come with two magazines? Well, I don't know, I usually only buy one. Well, it's interesting because he clearly went out and bought a second magazine for the 380, so not quite understanding what that means. But what is very clear, ladies and gentlemen, is here's what happened. Lou doesn't own a Glock 43. He's never had one registered, so he has no reason to have a magazine for a gun he doesn't own. The defendant doesn't have the Glock 43 magazine. He has no reason to have a Glock 43 magazine for a gun he doesn't own. However, there is evidence that suggests that the gun that was used in this crime was a Glock 43. It doesn't have to be, but it is consistent with the evidence. And what is clear is that the defendant got rid of the gun after the incident. Now, he says the gun he got rid of was a prop gun. That's not what the evidence shows. He got rid of that 9mm, the magazine that went with it. But he clearly forgot that in his closet was a second magazine for that gun. A magazine that clearly was not being used in that gun and very well might have been new because he was using the magazine that was in the gun when it was fired at Relli. So Lou's version is completely impeached, but it's even worse than that. So they apparently
Will he just be done? Kill us now.
have this information. 12E and Lou have information about this prop gun that will completely prove that the defendant did not commit this crime. And when does it get turned over to prosecutors and police for the first time? January 20th, the day before this trial started. Now they say, oh no, but actually, we told them about it in August 16th or 17th, 2024. That's still almost 3 years after the incident occurred. Remember, ASAP Lou is at the house when the search warrant is served. He didn't even have to go to the police. All he has to do is say, hey, you know what? That magazine, that 9mm magazine, that's mine. By the way, it was a prop gun that he had. Nothing. You know why he didn't say it? Because he hadn't made up the defense yet. That's why. Do you know why 12 didn't say anything? Because he hadn't made up the defense yet. That's what the evidence shows. And then what happened? Literally on February 9th, the morning that Lou was going to testify, we are given information. Oh, it turns out that Lou gave the gun to somebody in New York. And that's why they don't have a gun. Now remember, we're finding this out on what is basically the last day of the trial. We don't have the ability to get that person. But the defense, that's someone they've known about all along. Where is he to testify about this gun? They're saying we have to bring this person out here when there's no reason to believe that anything that person is going to say is true. But we're supposed to bring that person out here who we don't even know exists to prove that it's not a prop gun. That it's not a prop gun when that's their witness. Do you not think for a moment that if that witness could have withstood cross-examination, they would have brought him out here? Of course they would have. And how do you know that any of this is true? Because you're instructed on it. So the defense spent a long time attacking me, primarily me, attacking Relli. Where is the instruction about
Another time, it's not their burden. This is like 8 times burden shifting.
evidence that I ended up fabricating? It's as if the defendant tried to hide evidence or discourage someone from testifying against him. That conduct may show that he was aware of his guilt. What does that mean? That instruction is because the defendant, by his own, meaning the defense admission, through their witnesses, is that the defendant got rid of the prop gun, the piece of evidence that would demonstrate that he's innocent of these charges, that he got rid of that gun after the incident. The judge isn't going to give that instruction unless that instruction is something you can consider. Not going to do it. What does it say? If the defendant tried to hide evidence or discourage someone from testifying against him, that conduct may show that he was aware of his guilt. If you conclude that the defendant made such an attempt, it is up to you to decide its meaning and importance. However, evidence of such an attempt cannot prove guilt by itself. So in other words, just because the defendant got rid of the gun, that's not enough to prove to you by itself that the defendant is guilty of these crimes. But when you put it with everything else, it is a huge piece of evidence. If someone other than the defendant tried to create false evidence, provide false testimony, or conceal or destroy evidence, that conduct may show the defendant was aware of his guilt. But only if the defendant was present and knew about that conduct, or not present, authorized the other person's actions. Circumstantially, the evidence suggests that ASAP Lou and Twelvey and Wally are not doing this on their own. The evidence, the direct evidence from Wally is that he talked to the defendant immediately afterwards, their conversation. The idea that ASAP Lou and ASAP Twelvey were not having repeated conversations about this incident strains any even idea of reality. You all know that's not true. Of course they talked about it. Obviously, it's a huge incident that occurred. So that is an instruction you were given. It doesn't say anything about Relli. There's no instruction like that for Relli in this case. Flight. If the defendant fled immediately after the crime was committed, that conduct may show that he was aware of his guilt. What does that mean? After the incident, guys, the second incident, he takes off. If it is in fact, if it was simply a prop gun, why is he running? Why is Twelvey running? Why are they getting out of there? Why are they getting rid of the gun? I mean, I'm trying to argue, you guys, why is the sky blue? And I hope that when you're listening to it, I hope you're all understanding this is not a complicated, complex case. In the end, the evidence in this case, almost all of it, it's not circumstantial. So the video is direct evidence of what happened. The testimony of the witnesses is direct evidence. Relli's statement on the call is direct evidence. The testimony, as incredible and unreliable as it is, of Wally, of Twelvey, and of ASAP Lou is direct evidence. This is not a circumstantial evidence case. About the only circumstantial evidence in this case that you have that matters is circumstantially, we have to prove that the defendant pointed the gun at Relli in the first incident because we don't have it on video. But we've got his gun being pulled out, we have his gun in front of him, and we have Relli in that position. We have him fighting with Relli right before and fighting with him right after. So the only reasonable interpretation of that circumstantial evidence is what you're seeing. Defense failure to call logical witnesses. This is really important. I mentioned this before. Every argument that the defense made, the defense, and again, I'm not blaming Mr. Tacopina. The witnesses got up here and lied. Mr. Tacopina gets a statement from the witnesses. The witnesses say what they're going to say. He calls them. Mr. Tacopina does not vouch for his witnesses, meaning, just as we don't. We call witnesses, and those witnesses testify, you evaluate them. However, it is certainly legitimate that all these individuals that the defense is saying, why didn't the people call them? Those are witnesses that they are saying we have to introduce to disprove their fabricated defense, which we don't have the ability to do because they control that evidence and information. They've got the prop gun, we don't. They have these witnesses they don't tell us about, we don't. We have proven that this was not a prop gun in every way that we can. it defies common sense, it defies logic, and it defies all the other evidence. Now listen, I'm not blaming the defense for what they've come up with. When life gives you lemons, you make lemonade. Okay, that's what they tried to do. They have tried to take a case, and they got bad luck. Imagine, guys, for a second, if we didn't have those video cameras. Imagine what the defense would be. Well, you can't show anything happening. This is all made up. You got nothing. But we have the video. We have the gunshots. That's bad luck for the defendant. And again, that situation he made, that's his luck. Now, one of the things that's going to happen is you're going to go back there, and we talked a little bit about this before. Let's assume that somebody, when you go back there, starts saying, what if, isn't it possible that, could this have happened? You are not allowed to speculate outside the evidence. That also goes for things like, well, gosh, what if Rocky gets prison on this case? I don't want to go to prison. If any one of you feel that yourselves, you need to let the court know, I can't serve as a juror on this case. That's okay. Some of you during voir dire at points said, I don't know about certain things. And if you remember, the judge told different jurors, hey, listen, if at any point in time you cannot live up to your oath, let the judge know. If one of the rest of you decide, I'll give you an example. Let's say someone goes back there and they say, you know what, I really dislike DBA. I don't like him. I didn't like him when I saw him. He's obnoxious, etc. Whatever. If that is what you are basing your verdict on, it's improper. It's misconduct. If someone says, I'm never going to convict on a case, I don't like looking. If it's you and you can't get past it, you need to report yourself to the court. If it's someone else, they need to do it. We don't know if misconduct happens unless you let the court know about it. So if people, yourself, others are not living up to their responsibilities, you need to let everybody know. That goes the same for the celebrity issue, okay? The defendant should not be convicted because he's a celebrity. But he also should not be acquitted because he's a celebrity. He should not be acquitted because he's got a lovely family. He should not be acquitted because he's successful and wealthy. He should not be acquitted because he can go out there and entertain people and make millions of dollars. Those are factors I'm not just recommending, you're not allowed to consider those factors. All you're doing is you're going to weigh the evidence in this case, and you're going to come to your decision. Reasonable doubt in this case. So, proof beyond a reasonable doubt is proof that leaves you with a binding conviction that the charge is true. The evidence needs to eliminate all possible doubt, because everything in life is some possible or imaginary doubt. What does that mean? Well, it simply means that you're going back and you're going to look and you're going to say to yourselves, okay, here's the case that people presented. The people that presented evidence that the defendant used a real gun. Have we proven that it was a real gun? Not just from our case, but from the evidence that the defense put on as well. They've argued this is a prop gun. And when anybody goes back there and says, well, wait a minute, I don't like Relli, I don't find Relli credible. The problem is, what do you need to find Relli credible about? The evidence is they're admitting it's him. They're admitting it's a gun. They're admitting he fired it. They're admitting that's him at both locations. The only thing that they are really disputing is they're disputing that Rocky ever put the gun up to him in the first incident, which, by the way, once he pulls it out and he's pointing it and you can see it, he doesn't have to point it at it, but once that gun comes out in that situation, you can read the elements 245. They've got it. The second incident is easy. He actually fires the gun. So where exactly is Relli's credibility? Where is it material? It isn't. They have put Relli on trial in this case because in the end, he is a very convenient target. Legally, it doesn't work. Commonsensically, it doesn't work, but that's what they've argued. You can come and should come to the conclusion in this case, beyond a reasonable doubt, based on the video and based on the defense in this case. But if you need Relli's credibility, the best evidence you have comes from Wally, their witness, and that tape. That's the only thing you need to listen to. Any testimony in court, that's in court. Everyone knows why we're in court. That is the one piece of evidence coming from the defense where there's no argument that Relli knew he was being taped. There's no argument that he had any incentive to be untruthful. And you listen to him and you know what he's saying is true. He is shocked. He is basically telling Wally, dude, I tried to get money from him. You don't want to give me any money. Why'd you bring the boys in? He won't give me any money. He tried to kill me. He tried to shoot me. No question. By the way, Wally never mentions it's a prop gun. because the defense had not been thought of yet. We started off in this case very early on. We started off with a situation with Boomer. And Boomer is a very important illustration of the difference between what's reasonable and what's possible. And as you remember, we know what happened. We know that the evidence demonstrated that Boomer was the one that got into the trash. And the evidence has demonstrated in this case, beyond any reasonable doubt whatsoever, that the defendant, Rakim Mayers, that on November 6th, 2021, he committed these crimes. I'm going to end with this. We've done our job in this case. We have. We've put on more than enough evidence through our case, through the cross-examination of witnesses. We've done our job. I'm going to ask you all to do yours, whether you want to convict the defendant or not. Based on the evidence, that's what you're compelled to do. Because we can't have individuals, we can't have them deciding that because they're angry or they're upset or they've been disrespected, that they're going to be allowed to go out and shoot at people on the street on a busy Saturday night.
It sounds pretty
We cannot
basic.
have it. As you go back there, and I'm going to say this again, the first thing that I would ask you to do is to decide, was this a prop gun or not? And if you decide it is a prop gun, for those of you who do, you're going to have to get past all of the nonsensical evidence in this case. You need to ask yourselves, are you following the evidence? Are you following your head, or are you following your heart for whatever reason? Once you do that, the case is over, because that means the defense is fabricated. That means it was a real gun. That means you can't believe anything that was said by any of their witnesses. And that means that in the end, the defendant used a real firearm to commit these crimes. Again, as defense counsel stated, I want to thank you all for your time and for your attention. And I too want to thank Judge Arnold. It's not going to be the case. And I want to ask, to the best of your ability, when you go back there, you pretend that he's not APRocky. You pretend that he's just a guy named Rakim Mayers. And you treat him the way you would treat anybody else who was accused of these crimes with this evidence. And when you return a guilty verdict, that is not on you. That's on him, because that is what the evidence has demonstrated. Do not let anybody tell you that you own his conduct. He owns it. On November 6th, he made a very foolish decision, an illegal decision, a criminal decision, a decision that could have hurt individuals far worse than what happened. And it's your job and your responsibility to hold him accountable. Because if we're not going to hold privileged people accountable, who are we going to hold accountable? Again, thank you for your time and attention.
Oh my God. Oh. Yeah, he's got another 30 minutes to wrap up. I'm like, it's just like, kill me now. Oh. Let's see what's going to happen now. Jesus Christ. Uh-oh. Oh. Oh, my God. Takapina's got his laptop out. I'm sure that's not good. Let's see what the problem is. This jury, he literally pissed away the entire afternoon. This jury is going to hate his guts for that.
First remark relates to the jury instruction on circumstantial evidence. It's jury instruction number 224. Jury instruction number 224 tells you everything you need to know about circumstantial evidence. There's some question about whether it was shown in its entirety. The entire jury instruction is in 224. Another thing I want to mention to you is I think it is very obvious that everyone at that table left it all out of the field. Everybody put out 150%. I think that's very evident. All right. I want to hopefully focus your duties by kind of summarizing something that both sides have mentioned to you. All right. The people have the burden to prove beyond a reasonable doubt that the gun was real. If the people have not proven beyond a reasonable doubt that Mr. Mayers used a real 9mm, then the verdict is not guilty. If you do find that the evidence, excuse me, that the gun was real, then you look at the 5 elements that are listed for assault with a semi-automatic pistol. That's jury instruction 875. You have to decide whether those elements, all 5 elements, have been proven beyond a reasonable doubt. Then also you can consider the jury instructions on self-defense and the defense of others. You have that jury instruction as well. So I'm hoping that this assists you in kind of focusing how you deliberate. All right, I'm going to read the 2 final jury instructions. When I'm finished with this, I'm going to send you to where you're going to be deliberating. You won't be deliberating in the jury deliberation room here for this court. You'll be deliberating in the deliberation room that is for my court, which is Department 115 on the 11th floor. So when I release you, I'd like you to go to the 11th floor and go to Department 115. Department 115 is right there when you get off the elevators. And Alex will meet you up there. He'll escort you into the jury deliberation room. You can take all of your materials, you can set them down, and you can leave for the day. On Tuesday, you must be here by 9 a.m. Jury deliberations start at 9 a.m. And when you show up on Tuesday, you're to gather outside the courtroom doors of Department 115 on the 11th floor.
Yes.
Same thing?
There's not too much of a problem. Can we start at 9:30? If possible. If everyone's okay with that. Like,
Is that what you all want? All right, I'm seeing nods. Yeah, all right, 9:30. 9:30. All right, here are the final 2 jury instructions. When you go to the jury room, the first thing you should do is choose a foreperson. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is your duty to talk with one another and to deliberate in the jury room. You should try to agree on a verdict if you can. Each of you must decide the case for yourself, but only after you have discussed the evidence with the other jurors. Do not hesitate to change your mind if you become convinced that you are wrong, but do not change your mind just because other jurors disagree with you. Keep an open mind and openly exchange your thoughts and ideas about this case. Stating your opinions too strongly at the beginning or immediately announcing how you plan to vote may interfere with an open discussion. Please treat one another courteously. Your role is to be an impartial judge of the facts, not to act as an advocate for one side or the other. As I told you at the beginning of the trial, do not talk about the case or about any of the people or any subject involved in it with anyone, including but not limited to your spouse or other family or friends, spiritual leaders or advisors or therapists. You must discuss the case only in the jury room and only when all jurors are present. Do not discuss your deliberations with anyone. Do not communicate using social media during your deliberations. It is very important that you not use the internet in any way in connection with this case during your deliberations. During the trial, several items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room when you begin to deliberate. I made arrangements for a screen, a projection screen, to be brought into the jury deliberation. It's actually bigger than that. So if you want to review the videos, you'll be able to do that. We're going to need a clean computer, though, that they can use. You've got to connect the computer to the projector, which is connected to the screen. Mark, our audio visual guy, he can show you how to do that if necessary. If you need to communicate with me while you are deliberating, send a note through the bailiff signed by the foreperson or by one or more members of the jury. To have a complete record of this trial, it is important that you not communicate with me except by a written note. If you have questions, I will talk with the attorneys before I answer, so it may take some time. You should continue your deliberations while you wait for my answer. I will answer any questions in writing or orally here in open court. Do not reveal to me or anyone else how the vote stands on the question of guilt or issues in this case unless I ask you to do so. Your verdict on each count and the special finding of the firearm allegation must be unanimous. This means that to return a verdict, all of you must agree to it. Do not reach a decision by the flip of a coin or by any other similar act. It is not my role to tell you what your verdict should be. Do not take anything I said or did during the trial as an indication of what I think about the facts, the witnesses, or what your verdict should be. You must reach your verdict without any consideration of punishment. You'll be given verdict forms. As soon as all jurors have agreed on a verdict, the foreperson must date and sign the appropriate verdict forms and notify the bailiff. If you are able to reach a unanimous decision on only one of the charges, fill in that verdict form only and notify the bailiff. Return any unsigned verdict form. To the alternate jurors, the jury will soon be deliberating, but you are still alternate jurors, and you are bound by my earlier instructions about your conduct. Do not talk about the case or about any of the people or any subject involved in it with anyone, not even your family or friends, and not even with each other. Do not have any contact with the deliberating jurors. Do not decide how you would vote if you were deliberating. Do not form or express an opinion about the issues in this case unless you are substituted in for one of the deliberating jurors. Will the clerk please swear the bailiff?
Yes, Your Honor. Please raise your right hand. Thank you. You solemnly state that you take charge of the jury. Keep them together. You will not speak to them yourself, nor allow anyone else to speak to them on matters connected to this case, except by order of the court. When they have agreed on a verdict, you will return into court. Furthermore, they can take charge of the ultimate jurors, keep them apart from the jury, whether delivering on cause, until otherwise instructed by the court, so help you God.
All right, the case is now yours. Alex is going to meet you on the 11th floor in front of Department 115. He will escort the 12 of you into the jury deliberation room. You can put your materials down, and then you can leave for the day. Remember, 9 o'clock Tuesday, 9:30 Tuesday, please be outside the courtroom doors, not here, Department 115 on the 11th floor. The four alternates, I'd like you also to go up to the 11th floor now, and what I'm going to want you to do is to give Deputy Bennett your contact numbers. I assume you all have cell phones? All right, I'd like you to give Deputy Bennett your cell phone numbers so we can reach you in case we need you. And if we do call you, we're gonna need you quickly. So while the jury is deliberating, you can be in the hallway, you can be in the jury assembly room downstairs, you can walk around, you can be in the cafeteria, but you have to be ready, willing, and able to come to the courtroom if you're summoned. All right, you folks are going to be excused now. Take all of your materials. Council needs to remain. We have a couple of council people.
Your Honor, what should the alternates do with our materials?
Yeah. You can leave those. We have chairs upstairs in Department 115. You can just find a spot and you can leave them there. Everybody take all of your transcripts, notes.
Here we go, chat. Oh, that's it. We're at the end.
All right, again, to the jury. Join. Listen. All right, the next question is readback. If there is a readback, request for readback of testimony, what I want to know is whether both sides are willing to waive their presence and agree that the court reporter can go into the jury deliberation room and provide the readback of testimony. However, both sides will know what that readback is before it's ever provided.
I agree. We're on that also in agreement with what's going to be read.
Any communication from the jury, whether it's a request for readback or a question, will be given to both sides before any response is given to the jury. If there is a request for readback, all of you will know what the request is and will hammer out what readback will be provided.
With that, then there's no problem with the court will go back.
All right. Again, Mr. Mayers, you have a right to be present for the readback of testimony. What would happen is the readback of testimony would happen in open court. And you would be there, your lawyers would be there, the prosecutors would be there, and I would be there. In the alternative, you can waive your right to be present. So what would happen is if there is a request for readback of testimony, the testimony would be provided, but it would be the court reporter going into the jury deliberation room and providing the readback, the testimony that is requested. And you won't be in there, your attorney won't be in there, the prosecutors won't be there, and neither will I. Do you understand? You waive your right to be present? Join? Yes. All right, the last thing is I thought that 1 hour call would be appropriate, meaning that if the jury summons that they have reached a verdict, that the verdict would be read an hour after they have made that notice. Do you have any response? Do you think it needs to be more than that, less than that?
I mean, no, it should be fine. I mean, obviously, no, it should be fine.
Oh, that reminds me. Mr. Mayers, Well, under the circumstances, Mr. Mayers needs to be here within 1 hour.
Yeah.
People, do you think 1 hour is sufficient?
If- If we could, an hour and a half would be easier, but if the court wants an hour.
Well, I can make it,
90 minutes would help us. I'm guessing.
I'm fine with that, I don't care, that's fine, once 90 is fine.
all right, we'll do 90 minutes, and if everybody can gather before that, okay? But it'll be 90 minutes from the time that we're notified that there is a verdict. When I said to the jury that all of you left it all in the field, I mean that. You all put out 150%. So you did your clients proud. All right, anything else to take?
We do have one.
Just one thing. So during the PowerPoint presentation of people, they played the video from 1616 Priest Del Mar, and I can't be certain of this, but it appears to us that the sound of the first shot played earlier on the video they showed to the jury than the one that they presented in People's Exhibit 15. So just before we leave here today, if we can just look at the PowerPoint presentation and confirm that the video was the same video admitted as People's Exhibit 15 would be fine. If the shot was actually moved, that they modified that video in some way, we'll have to figure out some type of remedy, but I just wanted to clear that before we bring it today. That's okay.
Nothing was modified anywhere. We took the videos that were admitted and we used them in PowerPoint. I do not believe that I need to sit down with counsel and go through, the court is certainly in its authority in ruling that that is an insignificant issue. The court has seen the evidence that's been presented, so I'll leave it up to the court.
The jury has the exhibits, so I'm going to deny that request.
Your Honor, it was evidence on it's not an insignificant issue, it's whether or not the shot occurred before Relli went to Hills. It's a significant issue in this case. In fact, the people now aren't letting us look at it, particularly after they tried to present an exhibit of knuckles that weren't evidence. It's disconcerting. The court's not going to let us look at it. It is what it is.
I think that showing the exhibit of Relli's knuckles, I don't think that was intentional. It was an oversight. Mr. Lewin said it was an oversight. It's a mistake. We're all human beings. We make mistakes. The jury has the exhibits. The exhibits are what matters in this case, not the PowerPoint presentation.
There he is.
Oh, there you go.
Did you want to bring anything up?
No.
Mr. Logan, anything? Mr. Lewin?
No, just a reminder on the tax.
Yeah, we forgot to ask that. Thank you. All right, well, that's the record.
That's a wrap.
All right. All right, chat, that's it. The trial is over and the jury will start deliberating. Oh my God. I hope it's not guilty just to punish the prosecution. That was an awful trial. Oh. I mean, God almighty. J-Rock gifted 5 subs. J-Rock came in and found 5 greens, 5 grays. It was like, I'm going to put you out of your misery. And went and made him a green. And then they suffered even more because we're still all here. And Jonathan Thompson gifted $5. Thank you. Apparently left us speechless, folks. Maybe that's how awful the prosecution was. He was left speechless because I know I felt like I was at times. Like, oh, just kill us now. Kill us now, God. Oh. This was just awful. Oh, my God. Oh, my God. Oh. I mean, really, that was mind-numbingly. I don't understand how Tacopina. I understand little like, really either him or Lewin, how they could sit there and think, "Oh, I really did a good job today with all of that." It's just the whole thing. Pick a better trial. Well, I thought it was going to be a good trial. Here's the problem. Once you pick a trial, you're stuck because I don't like bailing because if you bail, that usually ends up meaning the trial gets good. So I don't bail on trials. Once we're there, we're there. Okay? So it's a suicide pact. It's a one-way ticket. Oh. I don't know. I still, at this point, I think it's a not guilty, or I think it's a hung jury. I think it's going to be a hung jury. I think the jury is basically tuned out and they don't care for any of this. And they're not going to convict them. So, yeah. Yeah. Yes, the stream of attrition has ended. So, oof. Yeah, this was just. Ugh. I hated every second, but I wouldn't have left for anything. Yeah. I thought there were a lot of parts of the trial actually. I do too. This closing was just atrocious. Closing arguments were atrocious. But overall in the trial, I think there were very interesting things that came up. I think that the cross-examination of Relli was absolutely hilarious. And the fact that he couldn't keep his cool. No, there was a lot of things there. And there's a lot of things that weren't brought up that I think both sides can use. And yes, at the end of the day, is Rocky's argument of like, well, it was a fake gun. That is strange credulity. But do I think a jury is going to, I think he's got probably at least one of the jurors in buying it. I think he's got at least one of the jurors buying it. Hellpike, good to see you, was saying, I think guilty. And here's the thing. If he gets convicted, I 100% can see that happening. I 100% can see that happening based on the case that's been presented. I could see all 12 jurors convicting him. I hope they don't, but it definitely could happen. It definitely could happen. Oh. Definitely could happen, chat. It definitely could. It definitely could. So, we shall see. We shall see. Let's see here. Working on the poll, chat. Hold on. It takes a second. Now, guys, remember there are no lesser included here, so that's the nice thing. Hold on here. Let's see here. What's the next one? There you go, chat. All right, the poll is up. Have fun. There's not lesser included, so we don't have to worry about them. But there's guilty, not guilty, and then everybody should go to prison. Everyone, Takapina, the judge, the court reporter, Lewin, they all go to prison. Monrez is saying both sides should lose. So ultimately, worst case scenario, he'd be looking at the 24 years. The prosecutors, remember at the beginning, were all butthurt about the reporting because they said, and I guess even with, given the fact he has no record and the facts of this, he'd be looking at most like 8 years in prison. But even then, he could receive probation for the offense. So that's the thing. They explained it won't be 24, but it could be like, anywhere from probation to 8 years is what a more likely outcome would be in the situation. 24 is like the worst. Like 24 is just the statute, like applied. So it's not like they can really be that bad. Like I said, it'll be like they said anywhere more likely from 8 years or less. So, I mean, when you look at the statute on its own, that's why people are getting 24 years. But it's likely going to be less. Oh. Bella's saying if you have to sell a conviction on, we don't have to give him that much time. Yeah, but that was this guy. Remember, Lewin cries about everything and complains about everything. It makes sense. He complained about what the press is reporting. So that's what he does. He whines and cries. J-Rock's been a member for 17 months. Thank you, J-Rock. It says Maddie B from CA wants a model stream. I understand, but it's midnight, so no. I'm going to go sleep. Let's see here. If Relli gets convicted, or yeah, if there's a conviction, the civil suit's a slam dunk. Yes. So, and that's it. If Rocky wins or gets a hung jury, Relli's screwed. So, and the thing is, Relli's going to be in a lot more trouble because discovery is going to be a lot more invasive. So, oh, this has been real romantic. Well, hey, it's spending Valentine's Day with you guys. 2.0 says hello. She wasn't feeling 100% tonight, so we didn't spend around. Maddie says, "Fuck you." I'll just stop. We'll do it tomorrow night, chat. We'll do it tomorrow night. Oh, I'm living in a fake time zone. April says, "How long do you feel they're going to deliberate?" Normally, I tell you like a 13-day trial, it'd be a while. But remember, every time we did a trial, or every time we did the case, 5 or 6 hours, and it was only 2.5 hours of footage, or 3 hours of footage of actual trial. So you could compress this down into like a 6-7 day trial, really. And remember, like, I just don't think they're going to be that long. I think maybe like 3 hours at the most, 2-3 hours. I could see that. I don't think they're going to go that long. Remember, there is not a lot. Like, guys, there's not a lot to this case. Was the gun like? Do they buy Rocky's story or not? And it's not going to be super in depth. I don't see it taking that long at all. I mean, maybe 3 hours, but I think it'll be less. I could see like an hour, like really like on the short end, an hour and a half, 2 hours. And basically, you know what? I'll just say it right now, hour and a half to 3 hours. That's my, that's the lock of the week, chat. Hour and a half to 3 hours. That's the pick of the week. Calling it now. Calling it now, chat. That's what we're doing. That's what we're doing. Yeah, there's not much to chew over, correct, Joe? It's good to see you. Hope you're doing well. You guys stayed up all night over there in Europe for this. There's not a whole lot to it. There is not a whole lot to this case. But we'll see. I mean, sometimes jurors focus on the dumbest things in the world. So, what do I think? I think it's going to be a hung jury. I don't think he gets convicted, but I also don't think he'll get acquitted. And I bet it's going to be like a really goofy hung jury. It'll probably be like 7-5, 8-4 to convict or something like that. That's probably what it'll be as well. Look forward to the hung jury pretrial stream. Do Cooking Taco Tuesday next week. Yeah. Maddie says, I didn't read my milestones. Okay, I don't know what the fuck you're talking about. What was the milestone stream? Your milestone post. I don't know what you're talking about, Maddie. So, I don't know. SB Seller saying a hung jury 90 minutes. Yeah. I think at the shortest amount of time it'll take him is 90 minutes. On the high end, it'll take him 3 hours. So, there you go. Jade says, can you explain a hung jury? What does that mean? A hung jury just means that there is no verdict. They couldn't agree on a verdict. It's not guilty or not guilty. They literally can't agree. And they deliberate, and they can't come to an agreement. People are steadfast in their positions and they refuse to change them. So they're just at an impasse. They're deadlocked. Some would be voting for guilty, some would be voting for not guilty. And it'll be a numbered combination that equals 12. So it could be like 11-1 guilty versus not guilty, or flipped around, not guilty versus guilty. 11-1, 10-2, 9-3, 8-4, 7-5, 6-6. All the way there. So Happy anything if it's a hung jury, it'll take a lot longer than 2 hours. Not necessarily. Not necessarily, depending on what happens. They could be there 3 hours and they could say we're deadlocked. And they might get they might get an Allen charge, and then we'll see what happens. Angela says Jay-Z's lawsuit got dismissed. Yes, and more importantly, it got dismissed. The lawsuit with the lady who made up all the bullshit about getting raped by Jay-Z and Diddy. That lawsuit got dismissed with prejudice. The attorney, the alleged victim, Jane Doe, dismissed with prejudice. And that's a very telltale sign. And even in the dismissal, they mentioned no settlement was made. They basically had to pack it up and go home because they realized she was a liar. So Jay-Z wins. Jay-Z wins. Jade is saying, is a hung jury a bad look for Rocky? No. I mean, a hung jury is good enough. They're not going to retry this, so that's a win for him. They could always retry him, but he's going to be fine. He'll win. Like, this is a good one for him. That gives him street cred, and, it looks good. So that'll work there. And then a hung jury, because there's no verdict, it does. If Relli tries to sue him, it doesn't hurt. It doesn't hurt him at all. So, so yeah, I don't think it won't. This will not hurt him, a hung jury. Goy says, should the rules on hung juries and retrials be changed? Yes. I think a hung jury double jeopardy should attach. There's guilty, we could reach a verdict of guilt, we couldn't reach a verdict of guilt, and then we couldn't reach a verdict at all. Guilty, not guilty, or we were not able to reach a verdict. I think that the inability to reach a verdict is a verdict. That he's not guilty or not guilty. We don't know. Now, do I think you could use that? Should you be allowed to use a hung jury verdict as evidence in a lawsuit? Sure, in a civil action or in other places. I could see it being used to detrimentally affect the party, but yes, I think a hung jury jeopardy should attach. The idea that it's a mistrial and you get to restart and people get retried multiple times is not what the framers intended. So let's see here. What do you? Oh yeah, well, we got back to 25K. Oh, nice. And I kept on checking chat, and like the numbers started backsliding, and I'm like, what the hell is going on? Does not work. Oh. So we shall see what we're doing. We shall see what we're doing there. Where is YouTube Studio? There we go. Where are we at right now? 25,004. Thank you, God. We're back to where we were. We're back to where we were. We're getting back there, Chad. I was getting worried for a while. So, Maddie's right. You skipped this post. Like, yeah, okay. I skipped the post. Oh, does Naked want a Jamaican hung party? No. 25,004? Yes, correct. Only 4, yes. Okay. So you guys are thinking about, well, no, every once in a while, Google's like, oh, these were fake or bots or something, or they remove them. Google does that entirely on its own, so, yeah. Oh, that's karma for not doing the 24-hour stream. Well, Safa. Tony says, why does the jury die from hanging, but the defendant doesn't? Yes, why is it? Why do they have to die? Oh. So, do they pay out some money to the families when the jury is hung? Well, guys, a jury can be hung. People are hanged. Because if you said when people are hung, when the jury's hung like that, if you're doing the double entendre of the jury has large penises, the term for being, you're hanged by the neck until dead. So putting a rope around your neck and lynching up a tree, you're being hanged. You're not being hung. Just like horses. Horses are not shoed. Horses are shod. So it's not the same. Can I be put on a jury to be called hung for once in my life? Yes. Yes, that'd be great. I want to be on a jury once. You go under for voir dire. Why are you you're here? Well, I got a subpoena and I wanted the chance to say a court declared me very well hung. That would be hilarious. Oh. Bella's saying, do it guilty, not proven. Well, I already did a poll. Hold on. We'll check this out. We'll do it. We'll do it. Do it. Do it now. Do it good. Let's see here. What was this one at? Come on, it's got to work. Tell me, how did this work out? Okay, so we have a poll right now. The first poll ended, and the winner is prison for everyone at 54%. Fair enough, chat. Fair enough. I agree here. So let's start a poll. All right. There, we'll try it that way. All right. Okay, there's your poll, chat. Guilty, not guilty, or they didn't prove it at all. And I mean, that's really not guilty at the end of the day. But I understand some people think you didn't prove it, but they think he did it. So, 24 hours Tuesday, Sean, that's the verdict. I quit. Do I have a Valentine? Yes, I do, Jade. Yes, I do. I have future Mrs. Martin 2.0. My fiance. She's my Valentine. And she's sleeping right now, I think. So, and Clyde is sleeping too. If you saw him earlier, the cute little doggo, he is sleeping probably along with her right now. Sellers is saying, how is not proven different to stay in the position is not guilty? It's not really different in this situation. Bella's asking for it, so I'm going to indulge it. I mean, I understand some people might say he did it, but they didn't prove it. So I don't know. However you wish to do it. Mother of Papillons is saying, listening to Laid Back News with Nate and Joe going at it. Did I ever speak? Yes. The problem was I got there like 12:30, guys. I came straight from I had a court hearing at 11. So I went to court, did my thing, and hustled back. And I kind of got there in the middle of it, and I tried listening on the way home, and I couldn't get signal. I couldn't get 5G. So I pull in, and I get to the house, and I come inside, and I'm like, I don't actually, I think I know what we're talking about. I just had to sit there for a while just to, catch up because I was, late. And I didn't know what was going on, so I waited. Jade says, who is Clyde? Oh, well, if you didn't see Clyde yet, hold on. Let me see if I can get him. Clyde. Clyde, buddy. I think he's going to come in here. Hold on. Come here, Bubba Bear. Hey. Hey, Clyde. Hey, come here. Look, Clyde. Clyde, come on. Come here, Clyde. Hold on, I gotta go grab him. He's sleeping still. Hold on. This is Clyde. He is a good boy. He's our dog. He's one of our dogs. He's the dog that's very sociable. The other one is probably would not let me pick her up. I'd be worried she'd panic and maybe even bite me. But this is Clyde. He is our He's a Shih Tzu and a bunch of other things. He's a rescue. We got him from the shelter. We got him from the animal APL. So he's a good boy. He is a good boy. He likes to talk about Building 7. He likes to talk about the USS Liberty. And he has various other conspiracy theories. When he's normally like awake, he will talk about other conspiracy theories. He's a little sleepy tonight, though. If you can't tell, he was snoozing, but he woke up and came out here. So this is Clyde. And also, Chad, if you become a member, you get access to all the sticker emojis that we have down there. And guys, if you could show them, whoever's a member right now, spam some emojis out there, you could see what we have access to. Stacy says, how about the USS Truman? Yeah, that one he's still investigating. He doesn't know the answers on that one yet. So, but yeah, there he is. He's still... Laney only hangs out with 2.0. Well, sometimes 2.0 will bring Laney in for me, but you don't get to see her. Yes, there you go. The Switchies, the Feds, the Killdozers, Vince, the Ryder Truck, the Doggos, the White Claw. Yes, everything. So how often does Clyde think about the USS Liberty or Building 7? Thinks about Building 7 a lot. Building 7 is kind of like his thing. That's his jam. Jade says, "Hey, Clyde Poo Poo." Clyde Poo. Yeah, Bubba Bear. He's a good boy. He's such a good boy. We're very lucky. He's so nice, and he's such a great doggo. Such a good dog. Is that good, buddy? Huh? 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 He's completely out of it, so. This is the dog that Lewin had in his PowerPoint. I mean, kind of. So. How much does Clyde weigh? He weighs 21 pounds. When we first got him, he was skin and bones. You could see his spine. He was in really rough shape. He had been dropped off at the APL. He had kennel cough really bad. Was very underweight. We thought he was anemic a little too. Like there was about a 2-week period where we weren't sure Clyde was going to make it. There was a time where I thought we thought he wasn't going to make it. It was very weird because when we first got Clyde and it was nice out, so we left the door open on the porch, like to our back, because we don't there's no trees around, so there's no bugs really where we're at. He would walk down and just go sit in the yard, and he would just sit there and kind of stare off into space, and we kind of thought he's just not going to make it. Like sometimes that happens. They're just really sick, and where they're at in life, they just don't make it. And we thought he was just kind of we were a stop. We were going to give him the best time we could give him. And very quickly, after, about a week at home, Clyde kind of deteriorated a little bit, but very quickly after that week, he bounced back. So, wait, is Clyde old? Clyde is 5. Well, we've had Clyde now almost 2 years. Coming in April, it'll be 2 years. Clyde was 5 years old when we got him. So no, Jade, we've had Clyde for a while now. Clyde is definitely happy and healthy. I was just saying when we first got him, he was he was in a really bad spot. Very quickly though, he's gained back. We've been able to put the weight on him and stuff. So yeah, he'll live a long time. God willing. He's 6 now. He'll be 7 coming up. So he's got at least another 10 years or so. Yeah, dogs that size can be 20. Yep, they can. Bella says he didn't want to get down. Yeah. Well, he was sleeping, and it's hard to run the computer with your hands full. So, and besides, he's gonna go back and go. He's gonna go find 2.0 and go sleep with her. So, and then I'll be joining him very quickly. But yeah, Clyde is doing really good. We found him at the APL. It was kind of, we were, if you guys go to locals, you'll see it because we've talked about him before. We have a new generation of doggos for the show. We had the original doggos for the show, Baxter and Molly, and they've passed away. And we have the new ones now. We're on the new generation of dogs. So you thought that was mindset the whole time? Oh, that's funny. That's funny. Tony says, I got my first rescue cockatiel when he was 15, and they're well over 30 now. Yeah, that's the thing. Birds can live for a long time. So, yes, dogs 2.0, the second generation of dogs, yes. You were wondering why that was an Andrew emoji? Oh, no, it's Clyde. It's Vince McMahon, the chairman. Vincent Kennedy McMahon. Yes. You're fired. It's worth it to be a mindset just to have the tag. Well, we don't have to worry about the we don't have to worry about a mindset emoji because we always got this.
Legal mindset. Legal mindset. Legal dick suckers, more like it.
Oh, do dogs get lazy eyes? I don't know. I don't know if they can. That would be interesting. I don't know if they can. But yeah, we found Clyde, and we were looking for another dog, and it just worked out very well. And we found him in the at the APL, and since he's a little guy, he was in like the little stacked up, kennels that are on top, and he was like flipped over on his back, just looking out, and he likes doing that. He's very kind of submissive like that. And that's how he likes to chill out. And when they brought him out to us, he kind of walked over and flopped over on my foot and was like, "What's up?" And we kind of realized that moment he was ours. So Tony says, "I want to get a larger bird, but I have to consider whether they'll outlive me." Yeah, that's true. Because then you have to make sure somebody can take care of it. That's why somebody can take care of it. That's the thing. That's the thing. Wow, outing Clyde is a beta. Well, yeah, he came out and he just walked over. They walked him over to us, and he flopped over on my foot and was like, "What's up?" And then we took him home 5 days later. He only spent 10 days in the shelter. So, yeah. Tim Beatty says you don't really have to worry about that. I think you do, though. If you are in a situation where you've got animals, I think it's never a bad idea to make sure people know what you can do for them, especially if you end up getting older. And let's say you're somebody in your 70s and you have animals that can live for another 25 years. You should make sure you have something lined up because, where are those birds going to go? If you have a dog, where's your dog going to go or your cat going to go if you have a younger cat or a younger dog? I think that's, just responsible pet ownership is having something lined up, How did we get Laney? We found Laney at the time. We had gotten Laney. Actually, hold on one second. So when we had our Papillon, Molly, she passed, she had a congestive heart failure, and it kind of snuck up on us, but she ended up being in distress, and 2.0 ran her to the emergency vet. And while they took her in the back and were working on her, she coded out and they couldn't resuscitate her. So Molly passed away, and that was 2.5 years ago now. So we only had our big dog Baxter, and he was doing his thing, and we wanted another dog, and we kind of liked it. I've only had bigger dogs, but I was having a little dog like Molly was, the Papillon was a little thing, so it worked out. So we ended up about 2 years ago now, in December, we found Lainey on a rescue group here in Ohio, and they because we were looking for dogs that don't shed because I'm allergic to dogs, and we found Lainey. She's a dog from a puppy mill. She's only 5 years old at the time as well. She was a pretty young dog, and she still is a young dog. And they bred her really bad, and she, like, the last litter she had, a lot of the puppies died. So they gave her up to a rescue group, and she still had a couple of her puppies. And by the time we found her, she only had one of her puppies left. The other ones had gone, and we ended up taking her, and she's it's been a work in progress. Where she was 2 years ago to today, I wouldn't have believed it. So yeah, Lainey's great, great. Stacy says, was she one of the tiny Papillons? Well, hold on, I'll grab a picture here. We'll get a picture because you'll see. Let me see here. They're on locals, but I'll go grab it. Let me see here. Where is? So here we go. This is Baxter and Molly, if you guys never saw them. These are the originals. So these are the originals. So that was Molly, and the big brown lump is Baxter. So, and those were actually dogs that 2.0 had. And when I met her, she had those dogs, and yeah. Are there bigger? Stacy, you're saying she's small. I'm like, are there bigger Papillons? I didn't think there were, but yeah, so we had those, and they're the original dogs, and that's where they're sitting right now, where they're laying down, is right where Trump was, or Trump is currently. So, like, literally right behind me. That's where they used to sit. This is not the original studio layout. The safe was never here. So the safe was never here. And then one of these bookcases was actually where the safe was. So that is there. As far as Lainey and Clyde, I will show you guys have never seen Lainey here. We'll grab her. Where's a good picture? Where is? Let me see here. Where is it? We have pictures up on Discord. I was trying to grab it. Hold on, chat. Here we go. Let me see. I'm trying to find in channel works. Hold on, here we go. Okay, actually, here's a good. Well, hold on. Do we got a good picture? Oh, actually, here is a picture of Clyde when we first got him. He was a little rough. I got that, and hold on here. Found some Lainey pictures too, but we'll show you guys Clyde and Lainey as they get a little older here. Okay, so here you go, guys. Here's Lainey and Clyde. Here's Lainey. So, Blade says, can't believe you're still at it. I mean, we've done like 9-10 hour shows before, so it's not bad. She is a 50-50 mix of Bichon Frise and Schnauzer. But there she is. So there's Lainey. And then what else do we have here? And this is Clyde when we first got him. This is a little bit afterwards because he's kind of put on a little bit of weight, but you can see Clyde was really, really rough shape when we first got him. They had trimmed him all the way down at the APL, and you could see his spine. So yeah, he was having a rough time of it at first. Tim is saying my avatar is a borbal, similar size to a Papillon. Oh, okay. Yes. Oh, yeah. What 2.0 had covering for Alec Baldwin, she had Lainey on. I know, but still, it's so. Yeah, she covered Alec Baldwin when I was in court. He's always been a beanbag dog. Well, yeah, he was very skinny though. He was super skinny when we got him. It was really sad. And that's actually better than he looked the day we got him. The day we took him home, oh God, he was rough. Like I said, we thought we were worried he wasn't going to make it. There was a thought he wasn't going to survive very long. But you know what? If I thought he was going to be fine, but if it turned out he wasn't, then at least he'd have fun where he was. But I figured he'd be able to hang in there. So and I'm glad he did. Guys. So had to go over this with trial to call everyone off the ledge. Yes. So, all right, chat. Well, I think we're going to wrap it up here. It's 1, 2, 3, 4 a.m. I always love it when you can see that on the clock. There's got to be some sort of autistic thing about that. But yes, 1, 2, 3, 4 a.m. I always feel like I can find it when I look at the clocks. So it's 12:34 chat. We are going to wrap this up. We're landing the plane. Let's see how it goes for Rocky. I'm not so sure how well it's going to go. Tomorrow night chat, we will do some model work. This has been clear coded, so we are going to try to work on the weathering. We're going to start working on that. So, we'll be working on that tomorrow. I think we'll probably do a serious thing as well. I'm just not sure yet. Oh, it's 130 pounds. Wow. Tony says, I always catch a clock too like that. Yes. I agree. I really like JD Vance at his speech in Germany. I didn't listen to it yet, but yeah, it sounds like it was pretty good from what I've heard. I did not hear it. Maybe we'll watch it tomorrow. I'm not sure. We'll take a look at it. But with that said, chat, yeah. The trial's over. The jury's got it. And like I said, I think 3 hours till we get a verdict at most. Even less, though, very likely. And we're not Haitian, I promise. And all the right people were mad at JD Vance, so that's good. So, all right, with that said, though, chat, I think ASAP Rocky's got a fair shot here. I think the closing, his attorney could have done a better job protecting him. But we'll see what happens. So good luck, Rocky. Hope you do it. And until next time, chat, just because you did it does not mean you're guilty. It doesn't. Doesn't mean you're guilty. Am I going to be around Tuesday for the verdict stream? Yes. And remember, chat, there is no court Monday. It is President's Day. So I know a lot of you are saying, wait, I have to go to work that day. Yes, but it's a federal holiday. It's a court holiday. So there is no court on Monday. That's a positive thing. It's President's Day, chat. So, the poll. Hold on about the poll. Did we meet the poll, chat? Did we meet the goal? Okay, let's see here. What is the poll? 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 Use a poll. All right. What do we got? We have 51% not proven, or just it's not like we're not really sure what occurred. 28% not guilty, 20% guilty. And like I said, chat, I could easily see guilty coming out of this. Tenoch says, what is President's Day? President's Day is, well, obviously it's not just for the presidents. But the meaning behind President's Day, it's all the presidents. It's meant everything there. But it's because it's kind of like you commemorate Abraham Lincoln's birthday. You know, it's always on the third Monday every year. Like Lincoln's birthday is what day? Hold on here. What day is? What's that? Yeah, Lincoln's birthday is February 12th. I forgot the top of my head. But you kind of commemorate, you know, all of our presidents. But it's, and yes, it's mainly for, as 2.0 is trying to yell, it's mainly for Washington and Lincoln. But yes, it's meant for all presidents, but it really honors those two and what they do. So, because Washington's birthday is February 22nd of 1732. What? Well, do you really know it, or are you looking at the phone? I don't think you do. Well, I'm not getting up and coming to look at your phone. Because they're... Okay, that's fair. That's fair then. Oh, okay. So let me see here. No, it was meant to be unmuted. Don't worry. It's not Valentine's Day anymore. It's over. All right. But yes, Tenoch, I hope that answers your question. Yes, we're celebrating our El Presidentes. We do that here. Yes, like I said, mainly Washington and Lincoln. Even though people like J-Rock may consider Lincoln a tyrant, he did what was necessary to bring the South to heel. And then Washington, obviously, he's part of the reason why, he was part of the divorce there that we had between you guys, so, and us. Okay. I bet you don't need lamps on the nightstands with that glowing in the bedroom. Oh, yes. Very true. Very, very, very true. So. All right, chat. We are all done. We are all done here. So you guys all have a great night. But yes, Tuesday, I think I'll be around. I won't, I'm not going to do a verdict watch, but like I should be around. Yeah, hold on here. I have to go somewhere. Okay, that's at 11 here. So that's like 11 o'clock is like 8 a.m. their time. So the jury's not going to be ready. So sometime around like, because they're coming in like, sounds like 9, 10 o'clock. So like 4 or 5 o'clock our time, we'll probably have a thing there. 4 or 5 o'clock our time, we'll probably have a verdict. So that's what I think. All right, chat. So that is it for us. And you guys all take care. And I will see you guys tomorrow. I'll try to give you a heads up on what we're going to look at. But we might listen to JD Vance and just see what he says. Just hear what he says and see what it's all about. Stacy's on a Saturday, verdict in 30 minutes. Well, all right. Well, anyways, chat, you guys all take care and have a very nice night. Enjoy your weekend.
blacksmithing and models of planes, esoteric works and even some trains. Much merriment had while drinking White Claws, tips on hunting and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy Rick hated you?